and I see everyone is ready to start. I'm pleased to open this hearing and welcome you all here. It's always a pleasure to open a hearing, but this one particularly, we have had no, at least for my part, no hearing with people in presence for a year and a half now, and so this is a great feeling. At the same time, we all know that we have to be careful, and you have received the PCA or the Peace Palace Protocol, a COVID protocol. Please comply with the rules. There's no mask obligation in the Peace Palace in the sense that each institution needs to be deciding what its practice will be. I would suggest that when you move around here, or whenever, even in a hearing, you're close to someone, close meaning closer than 1.5 meters, wear your masks. But for the rest of the time in the hearing, I think we can dispense with it. At least those who do not speak, and others must do it as they feel. I also greet those who are in the other room. The restrictions indeed had require us to split the participants, so I hope they get a good streaming and feel they're part of the hearing, even though they're in a different room. We have, in terms of participants, I'm saying this for the transcript. We have, of course, the tribunal who's here in presence with the secretary, and we have the assistant who's participating remotely. We also have the court reporter who participates remotely, but I see that the transcript running, and so this is working well. For the claimants, can I ask the Claimants Council to say who's here in this room and probably also in the other one on your list? Mr. Pekar?
Yeah. Good morning, Madam President. Good morning, members of the tribunal. Good morning also to our colleagues on the other side. Because of the distancing rules, we could not do the traditional handshake, so I hereby extend it virtually to everybody in the room. It's a great pleasure to have a real in-person hearing indeed, Madam President. Let me introduce the team on the claimant side today. My name is Rostislav Pekar. I'm partner with Squire Patton Boggs. To my left, we have Mr. Stephen Enway, also partner with Squire Patton Boggs. For the left, Mr. Luka Mišetić, also partner with our law firm. And then Mr. William Rand, one of the claimants in this arbitration. In the second row, we have Mr. Pustaj from the Prague office of our law firm. To his left, we have Mr. Igor Markicevic, who is director of SEMBI. To his left, Mr. Erin Broško, who represents Rand Investments. To his left, Mrs. Lee Jean Broško, who represents Mr. Rand's children. And then in the third row, we have Mrs. Sara Penjer from the law firm Stanković and Partners in Belgrade. To her left, Mr. David Seidel from Squire Patton Boggs. And to his left, Mr. Nenad Stanković from Stanković and Partners. In the remote hearing room, we have our Serbian law experts, Mr. Miloš Milošević, Mrs. Bojana Tomić-Brkušanin, and Mr. Uglješa Grušić.
Thank you very much. Can I ask the respondent to do the same exercise? Do I give the floor to you, Mr. Jeric is your name, and I hope I pronounced it right.
Yes, you did. Thank you, Madam President. I'm also glad that we are here back to at least a resemblance of a normal. I think that everyone is happy to be working not online but in person. And yeah, Let me introduce now our team. My name is Vladimir Đerić. To my right-hand side is Ms. Senka Mihej and Mr. Petar Đundić, or Professor Petar Đundić rather, who are the principal counsel. And then we have Ms. Milica Volarev at the end of the row. And then starting from this side of the row, Ms. Bojana Bilankov. To her right-hand side, Mr. Nemanja Galić. And then Mrs. Ivana Vukčević and Mrs. Lena Petrović, all attorneys. And then last, but certainly not the least, are representatives of the State Attorney's Office of the Republic of Serbia, starting from the left-hand side, with Ms. Olivera Stanimirović, who is the State Public Attorney, and then Mr. Marinko Čobanin, and finally Mrs. Ksenia Maksić. So this is the respondent team for today, and we don't have anyone in the back room at the moment. Thank you.
Thank you. Fine. So you know how we will proceed over these coming days. The rules for the proceedings are set out in procedural order number 5, in part also in procedural order number 1. Today we hear oral arguments, 3 hours each maximum. We have already received the claimant's PowerPoint presentation, at least a hard copy. We received demos also from both sides on Saturday. You also know the time allocation over the entire hearing, which is 19 hours each. The secretary will keep the time and send an email every night to say where we stand. Before we go over to the oral arguments, is there any question, comment that should be raised?
No questions, Madam President.
No questions on the claimant side. Anything on the respondent side, Mr. Đerić?
No questions at the moment. Thank you.
Thank you. Then I would like to give the floor to the claimants for their opening, please.
Thank you, Madam President, and distinguished members of the Tribunal. At the outset, we'd like to thank the Tribunal for the careful time and attention that you've paid to this important matter. Our presentation today will be divided into the following sections, which you see on slide 2. First, a brief introduction. Second, the factual background of the dispute. Third, the Tribunal has jurisdiction over the entirety of our claims. Fourth, the actions of the Privatization Agency are attributable to Serbia. Fifth, Serbia violated its obligations under the relevant treaties. And finally, the compensation to which claimants are entitled for their losses. And with that, I turn to the introduction. Members of the Tribunal, the basis of our claim is simple. And in particular, I'd like to focus at the outset on 2 undisputed facts, which cut through all of the parties' arguments and evidence. One relates to liability, the other to damages. First, liability. On the 21st of October 2015, the Serbian Privatization Agency took the entirety of BD Agro and paid nothing for it. Its basis for doing so was an alleged failure to remedy a purported breach that the buyer had supposedly committed 4 years earlier by the pledging of certain land as collateral for a loan. But critically important, and again, all of this is undisputed, the last installment of the purchase price for the BD Agro shares had already been paid to Serbia years earlier. And therefore, the restrictions on the pledges of land no longer had any economic significance to Serbia whatsoever. Now, members of the Tribunal, I will show you that the only reason there was any restriction on BD Agro pledging its assets was to ensure that Serbia would be fully paid the purchase price. And after full payment was made, the contract with the privatization agency was fully performed and completed. And these provisions that were allegedly breached no longer had any purpose or application. Precisely because the purchase price had already been paid to Serbia in full years earlier, Serbia did not suffer and has never alleged that it suffered any economic harm whatsoever from the pledge. And yet, despite no economic harm at all, Serbia took the most severe action it possibly could. It took the entirety of the company and paid nothing for it. These facts are undisputed. Now, we have shown that these acts by Serbia breached a number of different provisions under the relevant treaties, but I want to focus on just one at the outset, and that is the proportionality standard under public international law. Even if all of the respondents' liability allegations were assumed to be true, even if every single one of respondents' Serbian law arguments on liability were correct, the undisputed facts that I just described still could not possibly survive the proportionality test under public international law. And we respectfully submit that you can decide liability on that basis alone, on undisputed facts and proportionality. What about damages? Well, here too, there is an undisputed fact that is critically important. And that undisputed fact, which you see on slide 7, is the following. After taking over the company in 2015, the Serbian privatization agency put its own management in place at BD Agro. And that management, appointed by Serbia, commissioned, relied on, and disclosed to third parties a valuation of BD Agro's equity, assets minus liabilities. And Serbia's appointed management's commissioned valuation was that the investment was worth 56.3 million euro. That's their number. Now, I want to be very clear. This valuation was done after the breach. And we all know that under public international law, the valuation snapshot should be taken before, not after, the alleged breach. The latest pre-breach valuation implied an equity value of 71 million euro as of December 31st, 2014, which was 9 months before the termination. And our damages expert, Mr. Hearn, now assesses the equity value as high as 78.2 million euro. But this undisputed fact is still terribly important. Even if we took Serbia's own number, the investment was worth 56.3 million after the alleged breach. And we respectfully submit, members of the tribunal, that these two undisputed facts should drive the outcome of this arbitration. I turn now to the factual background. The story of this case begins with the privatization process in Serbia. In the early 2000s, now on slide 11, Serbia decided to transform its economy and created the Privatization Agency. Now, what was the Privatization Agency and what authority did it wield? As this slide depicts, now on slide 11, the Privatization Agency was subordinate to the Ministry of Economy. And in 2001, the Serbian parliament enacted two different laws relating to privatization. First, the 2001 privatization law, and second, the 2001 law on the Privatization Agency itself. and I'd like to walk you through some of the key provisions of those acts now. First, now on slide 12, Article 2.1 of the Privatization Law, now on your screen, provides that the privatization agency's objective was to create, through privatization, favorable conditions for Serbia's, quote, economic development and social stability, end quote. This meant that the privatization agency had a public purpose. Next, on slide 13, Article 18 of the law on the privatization agency stated that the Ministry of Economy was required to supervise the privatization agency, with the latter reporting to the former at least twice a year. Moreover, Articles 12 and 15 of the same law, now on slide 14, stated that the privatization agency's director and its managing board members were all appointed by, or dismissed as the case may be, by the government of Serbia. Indeed, Article 62 of the 2001 privatization law, now on slide 15, made clear again that the Ministry of Economy was in charge of supervising and implementing the privatization process. Indeed, Article 5 of the law on privatization agency stated that the initial funds for the establishment of the privatization agency were provided from the state budget. Claimant's own expert, Dr. Radovic, confirms that the privatization agency was required to transfer proceeds of sales back to the state. Now, the agency itself, in fact, was sued in an ICC arbitration, the award of which is depicted on slide 18. And in the ICC arbitration, where the privatization agency was a respondent, the privatization agency stated in a brief, and we know this because you can see in the very first line of this excerpt on the screen, it says, quote, the privatization agency remarks in their brief of 2 April 2007. So what follows is the agency's position, and I quote, during execution of control of compliance with investors' obligations, the privatization agency performs its lawful duty, not to act as a contract party, but the holder of public powers. That was the agency's own position. For its part, the Ministry of Economy has taken the same position. In connection with the privatization at issue in this arbitration, BD Agro, the ministry stated that the agency is, and I quote from slide 19, holders of public authorities while performing delegated state administrative tasks. What have the courts said about the authority of the agency? Well, let's look both to domestic courts and international courts. First, as to domestic courts. Now on slide 20. The Serbian courts have held that, and I quote, the act of notification that the agreement on the sale of capital is terminated is not an administrative act, but an act by which the privatization agency uses legal power, and here's the key language, obtained by the transfer of authority under the public law of the state. What about international courts? The European Court of Human Rights has analyzed the Serbian privatization agency specifically on 2 occasions. First, a decision from 2008, which you'll see on slide 21, where it held that the privatization agency in Serbia was, and I quote, a state body. Second, now on slide 22, a decision from 2013, same conclusion. The agency is a state body. And finally, to close the circle, Serbia law also provided that when the privatization agency was dissolved, the Ministry of Economy assumed its tasks and its obligations, the same entity that performed these tasks and assumed these obligations before the law on privatization. Now, members of the tribunal, why do I tell you all of this at the outset? I do so because I'm about to turn to the agency's acts as it relates to claimants and BD Agro. And as you now have seen, the Privatization Agency's acts, which we're about to review, are cloaked in the exercise of public authority. We turn now to the second section in the factual background. On 29 September 2005, Mr. Rand, through Mr. Obradovich, submits the winning bid for BD Agro. Now on slide 25. In 2005, Serbia decided to privatize BD Agro. BD Agro was Serbia's largest dairy farm. But during the 1990s, it had fallen into despair. By 2005, BD Agro was heavily underinvested, its equipment was outdated, and its buildings needed to be completely revamped. The farm's operating modes were outdated and ineffective, and BD Agro was in significant debt. And I'll come back later to that debt that I just referred to. But let me be even more direct. As Mr. Rand has explained, this operation was entirely dilapidated. 6 inches of water on the floor of the kitchen. No heat in the main office, despite extreme cold temperatures in the winter. The cattle kept in spaces so small they could not move their entire lives, and when let out could barely walk. Employees who had no decent clothes and who had not been paid literally for years. The farm needed an investor to interject funds and sound management into the project. Enter Mr. Rand, who is here with us today, a Canadian businessman who resides in Vancouver. Mr. Rand learned about the opportunity to invest into BD Agro from Mr. Obradovich. Mr. Obradovich is a dual Serbian-Canadian national who resides in Serbia. And you'll hear from him later this week. As Mr. Obradovich makes clear in his first witness statement, now on your screen is slide 26, in May 2015, Mr. Rand in fact flew to Belgrade to inspect BD Agro's premises, and he witnessed what I just described to you in terms of how dilapidated the operations were. Now, I'd like to pause here. One of the key themes of Serbia's defense is that they had no idea that Mr. Rand was behind this investment, that it was news to them when we filed this arbitration. Members of the tribunal, I'd like you to test that assertion against the mountain of evidence that I'm about to show you. First, the government, indeed the Ministry of Economy itself, directly wrote to Mr. Rand personally from the very beginning. And you can see that email on slide 27. On this slide, you'll see that the Ministry of Economy wrote directly to Mr. Rand, you see there in the 2-line, "Dear Bill," encouraging him to invest in the farm by touting the potential for permanently increasing value. You'll see in particular point 4, and the ministry appropriately and correctly focuses on the significant value increases that could be had in the land. And in fact, as shown on the next slide, Mr. Rand flew to Belgrade in May 2005. As Mr. Rand explains in his first witness statement, now on slide 28, he personally met with several high-ranking government officials, including Minister Bubalo. You'll see his name circled here. And I'd ask that you remember that name, Mr. Bubalo. We'll be seeing a lot more of him on the documents throughout the case. He's one of the highest-ranking members of the Serbian government at the time. He's the Minister of Economy, which I already told you is the body directly responsible for supervising the privatization agency. And Mr. Rand had dinner with Mr. Bubalo and his wife on this trip. In addition, Mr. Rand met with the Minister of Finance and the Minister of Agriculture, Forestry, and Water Management on this trip. Following the trip, Mr. Rand personally wrote to Minister Bubalo thanking him for meeting with him. And you see Mr. Rand's email now up on your screen. And with the government demonstrating its support Mr. Rand agreed to participate in the privatization. So you can see the discussions that took place before Mr. Rand decided to invest. They are directly between the Minister of Economy himself and Mr. Rand personally. Now, as Mr. Rand explains in his witness statement, now on slide 30, the plan was that Mr. Rand would become the beneficial owner, while Mr. Obradovich would acquire the shares only nominally. And the reason was simple. Given that Mr. Rand does not speak Serbian and would not be on the ground in Serbia on a day-to-day basis, it made sense to allow Mr. Obradovich to nominally own the shares, even though he did not have any beneficial rights to them. And this was hardly a secret. Quite the opposite. The beneficial ownership arrangement was openly discussed with Serbian government officials, and not only did they not object, they fully supported it. This is attested to by both Mr. Rand and Mr. Obradovich in their witness statements, excerpts of which are on slide 31. And you will note that Mr. Rand notes that this was discussed on multiple occasions with Mr. Bubalo, that same Minister of Economy. And as both witnesses explain, not only was Serbia aware of it, it fully supported the beneficial ownership arrangement. Now, given that Serbia's key defense appears to be that Serbia didn't approve this ownership structure and indeed didn't know about it, the tribunal may well ask, where is Mr. Bubalo to refute this evidence? Serbia has decided not to make him a witness, so neither we nor you members of the tribunal will be able to ask him any questions. And as you will soon see, members of the tribunal, this becomes a pattern with Serbia in this arbitration, where key witnesses on the Serbian side have not been made available as witnesses in this arbitration for us to question. The reality, and the contemporaneous documents will show you this, is that Serbia was well aware of this beneficial ownership arrangement from the outset, and indeed had been accustomed to it, had been accustomed to beneficial ownership structures, as you can see from slide 33. This is an invitation to participate in an auction for another company, and this was before the BD Agro privatization. And you can see that the privatization agency expressly contemplates beneficial ownership structures. In the same invitation, again for a different company before the BD Agro privatization, the agency expressly asked for the disclosure of beneficial ownership structures, and you can see that from slide 34. Nor was this an isolated case. On slide 35, you'll see a bid for yet another company in Serbia, this too before the BD Agro privatization, where the agency again requests disclosure of beneficial ownership structures. Well, what about the BD Agro privatization? For the BD Agro auction, in sharp contrast, the privatization agency did not ask for the disclosure of beneficial ownership. There simply was no requirement to disclose. That's reflected not only in the invitation documents themselves, but also in Mr. Obradovich's witness statement, which is before you on slide 36. But as I've described to you, and as you will soon see further, despite being under no obligation to do so, claimants repeatedly disclosed Mr. Rand's beneficial ownership anyway. On the 19th of September 2005, now on slide 37, to formalize his arrangement with Mr. Rand, Mr. Obradovich entered into the MDH agreement. MDH was a BVI company owned and controlled by Mr. Rand. Now, as shown on slide 38, if Mr. Rand was successful in the bid, the MDH agreement conferred upon MDH and thus Mr. Rand rights of a controlling shareholder, voting rights, a call option on the BD Agro shares at a nominal price, only €1,000. So what happens? Mr. Rand participates in the auction, and he's not the only bidder. 3 others attended, but Mr. Rand submits the highest price, approximately 5.5 million euro, to be paid in 6 installments over a 5-year period. He won on price. On the 29th of September 2005, the ministry writes a congratulatory email. To whom does he address his email? Bill Rand. And he says, as you can see from this slide, you all succeeded. And let's just take a step back. This is written by the Ministry of Economy, the same body that is charged with supervising the privatization agency, to the person that Serbia now says they had no idea was behind the investment. And he notes that the ministry says it will coordinate with George. That's Mr. Obradović. In other words, the ministry is congratulating the beneficial owner and says he'll work out the details with the nominal owner. That's exactly as you'd expect in a beneficial ownership structure. Mr. Robert Dean, our expert on British Columbia law, which is the law that governs the MDH agreement, has explained, as you see on slide 40, that through the MDH agreement, MDH and thus Mr. Rand acquired beneficial ownership of the BD Agro shares. And that, members of the tribunal, takes us to the next section. On the 4th of October 2005, the privatization and pledge agreements are signed. After winning the bid, 2 different contracts are signed with the privatization agency. The first, which is on the left side of your screen, is the privatization agreement. The second, on the right side of your screen, is the pledge agreement. And let's briefly review the key provisions of both in turn. First, the privatization agreement. Mr. Obradović, on behalf of Mr. Rand, was to pay a purchase price of approximately 5.5 million euro, payable in 6 installments over a 5-year period, and invest an additional 2 million euro into BD Agro. Now, under the pledge agreement, the other document, the one on the right side of the screen, the shares in BD Agro were pledged to the privatization agency until the full purchase price was paid. So if the full purchase price wasn't paid as agreed, then the agency could have foreclosed on the shares. But once the full purchase price is paid, then these agreements are fulfilled and completed. And now let's review the key provisions of each agreement. First, the privatization agreement, and there are 3 key provisions I'd like to review at the outset. The first is Article 533. Which states that the buyer will not alienate or dispose of a certain amount of fixed assets, and then it states, quote, until payment of the entire sale and purchase price. The second, now on slide 44, is Article 5.3.4, which says the buyer will not encumber with pledge the fixed assets except for the purpose of acquiring of the funds to be used by the subject. Now, as you'll soon see, it becomes a matter of common ground between the parties, at least before this arbitration, that once payment of the entire price is made, both of these restrictions cease to apply. That became a matter of common ground between the parties before this arbitration, and I'll show you the document where the agency took that position. After the full purchase price, restrictions on disposing or pledging assets is no longer a concern for the state. Under the privatization agreement, after full payment is made, this is a privately owned business that has been paid for fully, free and clear. Now, the third provision I wanted to review in the privatization agreement is Article 7. Article 7 sets forth the provisions whose breaches can justify termination of this contract. And it states that of the 2 provisions we just reviewed, 533, 534, only a violation of 533 could result in termination of the contract. Article 534 is not even mentioned. and this becomes critically important later. So I'd ask that you bear it in mind. That's the privatization agreement. What about the second contract that was signed, the pledge agreement? Under the pledge agreement, the BD Agro shares would be pledged to the privatization agency until the full purchase price was paid. And Article 2, which is now on slide 46, states this explicitly, that the pledge over the BD Agro shares is only valid, and I quote, until final payment of the sale and purchase price. And I would also note on slide 47 that Article 3.1.2 of the privatization agreement says the same thing. So it's with this contractual framework in place that we now turn to the next section in the factual background, which is that Mr. Rand immediately starts to manage BD Agro. After the privatization, Mr. Rand was appointed to the BD Agro board and immediately began to control operations. On this slide, I cite 22 different exhibits which show you just how intricately involved Mr. Rand was in the business. Constant contact with managers and employees, receiving financial reports and making decisions about the company's finances, regularly visiting BD Agro to personally control its operations, and routinely communicating with external consultants and business partners. Mr. Rand was also involved in directly financing the company's operations, together with the Lundin family, a family from Sweden, but which lived in Switzerland. And here is just one of the many documents where Mr. Rand was transferring money to the farm. Now, I've already showed you that the Serbian government was well aware of Mr. Rand's involvement since the very beginning. But to further underscore the point, company representatives continued to openly and transparently disclose Mr. Rand's ownership in the farm. For example, Mr. Jovanovic, who is the CEO of BD Agro and used to work for the government, stated to Serbian government officials, OECD officials, and other business persons that Mr. Rand's investment was, and I quote from slide 51, the biggest Canadian investment in Serbia so far. And Mr. Rand immediately met his investment obligations. Indeed, now on slide 52, on 10 October 2006, the privatization agency issued written confirmation that all the required additional investments in BD Agro had been made. And those investments, members of the tribunal, from Mr. Rand, quickly transformed BD Agro into a state-of-the-art farm. Here are pictures of Mr. Rand at the farm in the years after he started managing the operation. Suffice it to say, no one was hiding Mr. Rand's involvement in the project. Exactly the opposite. BD Agro's CDO, Mr. Jovanovic, continued to routinely disclose Mr. Rand's ownership to third parties. In this email from October 2007, now slide 54, Mr. Jovanovic openly describes Mr. Rand as, quote, our major shareholder in Canada. By this time, BD Agro's success story had caught the eye of the Serbian government officials, and they visited the farm in January 2007. As Mr. Obradovic explains, now on slide 55, on the 3rd of January 2007, the Prime Minister himself visits the farm. And he does so with that familiar name, Mr. Bubalo, the Minister of Economy, as well as the Minister of Capital Investments. And on the next slide, slide 56, you'll see a picture of that visit. And although the Prime Minister is not in the picture, Mr. Bubalo, the Minister of Economy, is. He is the individual immediately under the Canadian flag. The person with his back to the camera is Mr. Obradovic, and the person immediately to the right of Mr. Obradovic is the Minister of Capital Investments. You'll also notice the flags. From right to left, the Serbian flag, the Canadian flag representing Mr. Rand and his beneficial ownership, and then Sweden and Switzerland to represent the Lundin family. Let's fast forward a year. We're now in December 2007, and Mr. Jovanovic was continuing to routinely disclose Mr. Rand's ownership to third parties. Here again, you see him describing Mr. Rand as, quote, our major shareholder. And, as shown on slide 58, Mr. Rand continued to send money to the operation. And as a result, BD Agro became a model example of how privatization and foreign investment can significantly benefit a host state. In fact, Mr. Efforts earned the farm widespread praise. In one article that was published in 2010, now on slide 59, media reports were describing the farm as, quote, the most modern cow farm not only in Serbia, but all of Europe. And another report ranked it as one of the most important suppliers of raw milk, not only in Serbia, but in the entire Balkan region. Now, if we just pause here, members of the tribunal, contrast these contemporaneous reports with the utterly dilapidated condition in which Mr. Rand found the farm when he first visited it before the auction. This transformation didn't happen by accident. It happened because of Mr. Rand's investment. And that takes us to Section 5. In February 2008, Mr. Rand restructures his ownership through SEMBI. Now on slide 62. By the end of 2007, the Lundin family decided to exit the project and requested repayment of loan funds. Mr. Rand agreed to replace the Lundin's funds with his own, and he subsequently used this opportunity to change the holding structure of BD Agro's shares to include his three children, Kathleen Rand, Allison Rand, and Robert Rand. And he achieved this by purchasing a Cyprus company called ICSID Investments Ltd. To serve as the holding company for his beneficial ownership in BD Agro. And so on the 22nd of February 2008, SEMBI and Mr. Obradovic concluded an agreement transferring the beneficial ownership to SEMBI, which you can see on your screen. In effect, the SEMBI agreement replaced the MDH agreement. Now, our Cyprus law expert explains, as you can see from slide 64, that SEMBI, through this agreement, acquired all the equitable rights in the privatization agreement and the BD Agro shares. In addition, as shown on slide 65, SEMBI assumed all obligations against the privatization agency and the Lundins. And from that moment on, whatever Mr. Rand did, SEMBI did. And so when you hear us describe Mr. Rand and his actions going forward, it's effectively synonymous with SEMBI. SEMBI immediately recorded its beneficial ownership in its financial statements. This is an important fact, and it's found on slide 66. If we can go back to it for a moment. You see that SEMBI immediately recorded its beneficial ownership in its financial statements. And now moving to slide 67, SEMBI also became actively involved in BD Agro's management. There was a board of directors at SEMBI, and you can see from this slide minutes from meetings of that board of directors where the directors were immediately involved in BD Agro's management. Moreover, Mr. Rand was one of the SEMBI board of directors, which you can see from slide 68. And lest there be any doubt, Mr. Rand remained in full control at all times. Here you can see witness statements from Mr. Markicevic, general manager of BD Agro, board member of BD Agro, and director of SEMBI, and Mr. Obradovic. And in that regard, Mr. Rand himself wrote letters to business partners of SEMBI stating that all instructions regarding the company should only be accepted if given by him. Further, as this slide shows, Mr. Rand continued to be personally involved in all of BD Agro's affairs, just as he was before. On this slide, I cite 30 exhibits demonstrating his continued involvement in all aspects of the operation. If that were not enough, Mr. Rand and Mr. Jovanovic continued to routinely disclose Mr. Rand's ownership and control to BD Agro's business partners. You can see that in 3 emails on this slide alone, the 2 on the left and 1 in the upper right, which are authored by Mr. Rand, and in which he says, effectively, I own the farm. And in the 4th email in the bottom right, where the CEO of the company, Mr. Jovanovic, describes Mr. Rand as our owner. Mr. Markicevic also disclosed Mr. Rand's ownership to BD Agro's creditors, and some of those creditors were Serbian government agencies. And you can see that from slide 73. And as this contemporaneous document shows on slide 74, Mr. Markicevic described Mr. Rand externally as, quote, our owner from Canada. In fact, Mr. Rand's involvement was so well known that the Canadian embassy in Serbia began to communicate him with regard to the farm. This is an email from the Canadian ambassador to Serbia, John Morrison. And Ambassador Morrison writes to Mr. Rand, quote, Dear Bill, you obviously have a winning team. Things like this heighten enormously the respect that Serbians have for Canadian investments generally. And as I've already showed you, now on slide 76, Serbian and Canadian politicians and government officials were well aware as well. On this slide, you'll see an email on the left from Mr. Rand to Serbian government officials describing the business as, quote, our dairy operations. You'll also see an article on the top right reporting that the Speaker of the House of Commons in Canada visited the farm with a parliamentary delegation, referring to it as, quote, Europe's biggest dairy farm. And note the bottom right email where Ambassador Morrison states that he enjoyed meeting, quote, Bill's son, because Mr. Rand could not attend that particular meeting and his son went in his stead. And lest there be any doubt, the Privatization Agency was aware as well, as this slide shows. Members of the tribunal, I'll even show you an email later sent directly to the Minister of Economy himself that described Mr. Rand as the majority owner. But let's take things chronologically. Here we are in 2010. Because of Mr. Rand's investment, the farm has now achieved accolades, not only in Serbia, but in Europe generally. It has garnered the attention and indeed visits from the Serbian Prime Minister himself, the Minister of Economy, the Canadian Ambassador to Serbia, the Speaker of the House of Commons, and numerous other government officials. To say that Mr. Rand's ownership was a secret is, in a word, absurd. BD Agro, with Mr. Rand controlling the company, had become a success story as we sit here at the beginning of 2011. But then everything changes. For reasons we may never know, everything changes in February 2011. In February 2011, the Privatization Agency decided to allege non-existent breaches of the Privatization Agreement. And in particular, now on slide 79, on the 25th of February 2011, the agency alleged that BD Agro violated Articles 533 and 534 of the Privatization Agreement. And let's take each allegation in turn. First, 533. You'll recall, now on slide 80, that 533 prohibited BD Agro from alienating fixed assets worth more than 30% of the total value of BD Agro's fixed assets shown on its final pre-privatization balance sheet. So how did BD Agro supposedly violate this provision? Well, as you can see on slide 81, the Ministry of Agriculture ordered BD Agro to slaughter the portion of the herd that had been infected with a particular disease. Incidentally, the cattle had that disease when Mr. Rand purchased the farm. BD Agro followed this order. What happened when BD Agro followed the order of the ministry? The privatization agency turned around and alleged a violation of 533, saying that BD Agro had now alienated more than 30% of its fixed assets by doing so. Now, to state the obvious, following a government order and then being told you are in violation of the privatization agreement is remarkable. Such a government-ordered slaughter obviously constitutes, if anything, under the privatization agreement, an event of force majeure. And in fact, the privatization agency later admitted that it was a force majeure. And you'll hear that throughout this hearing. Further, the slaughtered herd was fully replaced by a superior breed that Mr. Rand directly flew from Canada at his own personal cost of €2 million to replace the cattle that had to be slaughtered in accordance with the ministry's order. And I would additionally note that the amount that Mr. Rand paid, the $2 million out of his personal funds, was in addition to the amount of approximately $2 million as well from the Export Development Canada, and BD Agro itself had to pay more than $3 million to replace this herd. Perhaps most striking, however, is that even in February 2011, the exact same month when this allegation was made, the privatization agency admitted in a document I'm about to show you that it knew if you accounted for the slaughtered herd, BD Agro was below the 30% threshold and therefore not in violation of 533. Let me repeat that. The privatization agency admitted the same month that it made this allegation that it knew if you accounted for the slaughtered herd, which BD Agro was ordered to do by the ministry, it would not have caused a violation of 533. And let me show you that document now. This is on slide 83, where you can see that the privatization agency confirms in its final report on control that if the culling of the cows is not counted, 533 was not breached. They knew this the minute they made the allegation. Mira Kostic signed the report together with 3 other representatives from the privatization agency. And despite Ms. Kostic's intimate involvement in the facts of this case, you'll hear and see her name all over the record, she too, curiously, has not been made a witness in this arbitration. So again, neither we nor you members of the tribunal will have the opportunity to ask her any questions. Yet despite admitting that if the slaughter of the cattle was accounted for, Article 533 was not breached, and knowing that in February 2011, the privatization agency continued to allege a breach of 533 for the next 4 years. And they continued to demand that BD Agro provide an explanation showing there was no violation. But they weren't asking for legal arguments. They were asking for facts, for auditor reports, showing that 533 wasn't violated. As I've just showed you, they had all the facts. And they knew that if the slaughtered cattle were accounted for, there was no violation. They continued to make these demands knowing full well that BD Agro couldn't possibly comply with them. Indeed, it was not until 4 years later, and this is critically important, 4 years later, in the termination notice itself, that Serbia dropped the 533 allegation. And I have on slide 87 an excerpt from Serbia's brief in this case, where it confirms, and I quote, only the breach of 534 was the reason for termination. In other words, not 533. The first time they dropped this allegation of 533 was in the termination notice itself in 2015. Now, why is it so important that Serbia dropped the 533 allegation, albeit only in the termination notice itself? Why is that so important? Because remember what I told you at the beginning regarding Article 7 of the Termination Agreement, which stated that of these two provisions, only a violation of 533, not 534, could result in termination. And the importance of this point cannot be overstated. It is undisputed that on the terms of Article 7, the termination provision of the Privatization Agreement, the only provision that Serbia now says was breached is not a basis for termination. What about the Article 534 violation? Well, Serbia alleged wrongly that BD Agro had pledged certain plots of land to secure a loan in 2010 worth about 2.2 million euro, and that violated Article 534. Well, this allegation was equally baseless. Even if one accepts that 534 had applied to the actions of BD Agro as opposed to the buyer, that's the word that's used in the agreement, that's Mr. Obradovic, even if one overlooks that issue, Article 534 only precluded BD Agro from pledging its assets as a security for loans taken by third parties. Indeed, that provision clearly states that BD Agro can pledge its assets, quote, for the purpose of acquiring of the funds to be used by BD Agro. It's undisputed that the funds acquired under this 2010 loan agreement were used by BD Agro. BD Agro used the majority of these funds, the majority, 1.23 million approximately, for its primary business activities. BD Agro used a minority of these funds, roughly 670,000 euro, to repay the debt that it had assumed from a company called Cirkveni Signal, a company for which Mr. Rand was also the beneficial owner, which was BD Agro's debt at that time. And BD Agro used the remaining of amount of the funds, approximately 300,000 euro, to provide a loan to Inex, another company beneficially owned by Mr. Rand. And consequently, it is clear that BD Agro used the majority of that money for its own primary farm business. Again, that's not in dispute. And so to that extent, the pledge corresponding to the loan was perfectly valid under 534. And it's also undisputed that the 2010 loan was repaid in 2012. And that the lender, Agrobanka, a bank that was controlled by Serbia at the time, was required to delete the corresponding pledge when the 2010 loan had been paid off. Agrobanka, however, then in control of the Serbian government, arbitrarily refused to release the pledge. So even if Mr. Rand had just decided to repay BD Agro's receivables from Cirkveni Signal and Inex, there would have been no effect on Agrobanka's refusal to release the pledge that allegedly violated 534. And members of the tribunal, let me also say that making loans, even for companies that are not financial institutions, is common business practice. Take, for example, law firms, the entities at least with which I'm most familiar. Large law firms often have related entities. In my firm, we have different LLPs that are connected by a Swiss Verein. That's how many large law firms are organized. US LLPs, UK LLPs, AU LLPs, related entities. And large law firms frequently give loans between their affiliated LLPs. They also sometimes give loans to employees or partners, depending on their own specific personal economic circumstances. And they do this despite the fact that their primary business isn't lending money, it's the practice of law. There's absolutely nothing improper with it and nothing in Serbian law that prohibited it. In short, the loan to NX and the paying off the debt of Crkveni Signal was not unusual, it was entirely valid. And moreover, I would note that the BD Agro relationship with NX and Crkveni Signal had been extremely beneficial, not detrimental, to BD Agro. Why? Because before Mr. Rand took over BD Agro, NX had purchased the debt of BD Agro from BD Agro's creditors. Remember, I told you I'd come back to the point about debt at the very beginning of my presentation today, and this is that point. NX had purchased the debt from the creditors of BD Agro, and after Mr. Rand took over BD Agro, he caused NX to forgive the interest on that debt worth 1.7 million euro. In other words, the NX relationship with BD Agro saved BD Agro 1.7 million euro. To put it simply, these companies, their relationships between NX, Crkveni Signal, and BD Agro did not hurt the farm, it significantly helped it. What about Crkveni Signal? Crkveni Signal, although it's received little attention in this case, under the very same loan, the very same 2.2 million euro loan, put up its own buildings as partial collateral. And you can see that on the next slide. This is a document. This is on slide 92. And this is the report of the Privatization Agency itself, where it acknowledges that as part of this very same loan, not only did BD Agro put up the pledge on land that they say violated 3534, but Crkveni Signal had put up its own collateral. But in any event, these issues should be moot because the loan for which this pledge was made was later paid off in 2012, as Mr. Obradovic explains here on slide 93. And therefore, the bank never moved against the pledged land. There never was any harm. And note that a new loan was taken in 2012 to pay off the 2010 loan. It's effectively refinancing. Who was the entity that guaranteed the 2002 loan? Crkveni Signal. Showing again, this caused no harm to BD Agro. And indeed, the value of BD Agro is the same regardless of whether the loans are secured by a pledge or not. In short, this pledge not only was in compliance with the privatization agreement, it was entirely irrelevant to Serbia. And members of the tribunal, let me emphasize this, that's even before the purchase price was fully paid. But it's to that topic that we now turn. To put the matter to rest once and for all, on the 8th of April 2011, Mr. Rand pays the final installment of the purchase price. And under the privatization agreement and the pledge agreement, that should have ended everything. Now, before I start this section, members of the tribunal, I would ask that you flag slide 96. It's incredibly important. On the 25th of February 2011, I'm sorry, let's see, it's at 96. On the 25th of February 2011, the Privatization Agency expressly confirmed that obligations under Article 533 and 534 were in effect only until payment of the full purchase price. This is a document where the Privatization Agency is telling BD Agro how it understands these agreements and that these two provisions they say were violated cease to exist, cease to apply upon the payment of the final purchase price. An incredibly important admission. And I quote, "The above stated obligations," that is 533, 534, quote, are in effect during the term of the agreement, October 4, 2010. Now just pause there. That's when the final payment installment was due originally, but it was later extended by a few months, which is why you then see the language which has been extended. In other words, the effective 533 and 534 are in effect only during the term of the agreement, which is terminated when the final payment is made. So the question then arises, when was the final purchase price made? And the answer, members of the tribunal, is a month and a half later. A month and a half after the agency alleged a breach in February 2011. In particular, now from Mr. Rand's witness statement on slide 97, the full purchase price was paid, quote, on 8 April 2011. And members of the tribunal, this is undisputed. You can see the privatization agency's confirmation of this on slide 98, where it states that the last installment was made on, quote, 8 April 2011. Now, I've already showed you that the ministry itself has admitted that as of this final payment, 533 and 534 ceased to apply. And therefore, there couldn't possibly be a breach of them. But there's another important effect of paying this final installment. It means that upon full payment, the privatization agency was under a mandatory obligation to release the pledge that it had on the BD Agro shares. Remember, I showed you that Article 2 from the pledge agreement at the outset. Now, pause for a minute and consider what that means, because I think this helps explain Serbia's conduct later. If Serbia releases the pledge on these shares, it would lose the ability to seize the shares and expropriate them later. Let me repeat that. If Serbia complies with its obligation to release the pledge on the BD Agro shares in accordance with Article 2 of the pledge agreement, as it is required to do, then it would have impeded its ability to later expropriate the shares. And again, I think that is helpful to bear in mind as we look at Serbia's conduct for the next several years following this date. And Serbia, on this issue, the release of the pledge and their obligation to do so on the BD Agro shares, effectively admitted that as well in the same February 2011 report. And I direct your attention, members of the tribunal, to slide 99, where the privatization agency states, and I quote, "The contractual provision in the share pledge agreement stipulate a pledge in favor of the agency," and here's the key language, "until payment of the complete share purchase price." Again, another terribly important admission. Now, we know why the ministry took this position, because as you see on slide 100, and you've already seen this provision, Article 2 of the pledge agreement states this explicitly, that Serbia's pledge on the shares lasts only until, quote, final payment of sale and purchase price. And as I've already shown you, Article 3.1.2 of the privatization agreement says the same thing. Indeed, there are other legal norms that require the release of the pledge on shares. For example, the privatization agency had a rule book on procedure for control, which you see on slide 102. And it states, now up on your screen, when, quote, the purchase price for the entity being privatized has been paid in full, end quote, the center, quote, shall draft a decision removing the pledge from the shares/shareholding. Couldn't be clearer. In addition, precisely because these conditions no longer applied, 533, 534, the agreement cannot be terminated. Our Serbian law expert, Mr. Milosevic, confirms that, stating that upon the payment of the purchase price, the privatization agreement could no longer be terminated for breach of Article 534, and with equal force, the Serbian courts have held that under these circumstances, the privatization agreement could no longer be terminated. And to read that slide, now on slide 105, with the expiration of controlled deadline for the performance of privatization agreement, there is no room for termination of performed agreement. In short, upon the full payment, the privatization agreement and the pledge agreement were concluded, and they could not be terminated again thereafter. Upon full payment, there is absolutely no reason whatsoever for Serbia not to release the pledge of shares. And upon full payment, there is absolutely no harm whatsoever to Serbia. Incredibly, however, the privatization agency refused to remove the pledge on the shares and blocked any disposition of the shares, later enabling it to expropriate them. Now, to understand the mechanics of this, the Central Securities Depository and the clearinghouse would deregister the pledge on shares only upon written confirmation issued by the privatization agency. And the claimants repeatedly sought the pledge's release from the agency, but the agency simply refused to do so. And to make matters even more untenable for Serbia's position, as I already noted, in June 2012, BD Agro repaid the 2010 loan. So not only had they fully paid the purchase price under the privatization agreement, they also fully paid off the loan that was secured by the pledge that allegedly violated Article 534. So it was assured that no one would move against the pledged land that allegedly violated 534. It was assured that Serbia, BD Agro, none of them would suffer any harm as a result of this. Now, with the tribunal's indulgence, I also think it's important, even though we're currently talking about the facts, to pause here and note an important legal principle under Serbian law, and that is, even without Article 7, which, as we already saw, says that the agreement cannot be terminated for a violation of Article 534, even without Article 7, under Serbian law, an agreement can be terminated only for a violation of an essential obligation, and only if such violation is not minor. Two different requirements there. It has to be an essential obligation and non-minor. And this rule is laid down in Article 131 of the 1978 Serbian Law on Obligations. What does it mean to be a non-essential violation? As this slide shows, now slide 109, it is a violation that, quote, does not endanger the achievement of the main goal, the main purpose of the contract. Members of the tribunal, that is exactly the situation we have here, even if you assumed a violation of which there was none. Not even Serbia has ever contended that the secured loan with a pledge on land endangered the achievement of the privatization agreement. Indeed, I'll repeat, the purchase price was fully paid, and the loan that the pledge secured paid off. Now, as applied to this case, claimant Serbian law expert confirms that Article 534 is not an essential obligation. And on the next slide, he explains that in any case, even if it was an essential obligation, and it wasn't, the alleged breach was only minor. So as we wrap up this section, you will have noted that there are a number of independent alternative reasons why Serbia's arguments fail under 534. And I only focus more on 534 than 533 because that's the only alleged breach Serbia maintains. And so on this slide, slide 12, I enumerate them all. 5 independent alternative reasons why their arguments fails. And while I rarely read text slides, I think it's important to do so here. Number 1, there was no breach of Article 534 at all, because the entirety of the 2.2 million euro loan was used by BD Agro. Number 2, even if that were wrong, and it's not, Article 534 was only in effect until full payment of the purchase price. And full payment of the purchase price was made 4 months after this pledge was made. At that point, any alleged breach ceased to exist. But let's assume both of those arguments are wrong, 1 and 2. Number 3, Article 7 explicitly enumerates the provisions whose violation can be a basis for termination, and as you've seen, Article 534 is not even mentioned. Let's assume that's wrong too. Now we're 4 levels deep. Even if all 3 of the first arguments are incorrect, the alleged breach was minor under Serbian law and non-essential in terms of the obligation, and therefore cannot be a basis for termination of a contract under Serbian law. But let's assume that too is wrong. Now we're 5 levels deep. And I come back to that undisputed point I made at the very beginning of my presentation today. Even if everything else I told you was wrong, Serbia's conduct violates the proportionality test and other standards under public international law because Serbia suffered absolutely no harm from the pledge and yet took the most severe action it possibly could have. It took the company and paid nothing for it. If any one of these arguments are correct, and I would respectfully submit they all are, but if even one is, then Serbia's argument fails. That takes us to the next section. The Ministry of Economy confirms there is no justification for terminating the privatization agreement. We're now on slide 114. And this is one of the more important facts of the case, members of the tribunal. On 10 May 2012, the Privatization Agency requested instructions from the Ministry of Economy on how to resolve the matter. Now, the claimants, Mr. Obradovich, BD Agro, were totally unaware of this at the time. In response, look what the Ministry of Economy, the body that supervises the Privatization Agency, says. It says that there is, quote, no economic justification to terminate the agreement. And you can see the actual words from the actual document on slide 115. In this letter, the Ministry of Economy confirmed that there was no economic justification to terminate the agreement. And if you look to the reasoning for this conclusion, it is exactly our position in this arbitration. Number 1, the buyer paid the entire amount of the sale and purchase price. Number 2, the buyer, quote, used the funds received from disposal of the property to comply with the obligations of the subject of privatization. Number 3, the stated disposal of the property did not threaten the continuity of the business activities of the company. And we've also underlined a 4th point, which I think is important to stress. Look what the Ministry of Economy says. The buyer of capital achieved the highest possible level of organization. This is the Ministry of Economy saying this. And yet, in the face of that letter from the Ministry of Economy, which it sends to the Privatization Agency, in the face of its superior body concluding otherwise, the Privatization Agency would not give up on termination. And the agency sends a notice to BD Agro on the 31st of July 2012 saying that evidence is needed to be provided that there was no violation of the agreement within a certain period of time. We'll start seeing some of these notices coming in now. You'll see 60 days is mentioned here. On the 8th of November 2000, well, let me back up. You may ask yourself at this stage, even though Mr. Rand knew the allegations were baseless, why didn't he simply remedy them rather than risking losing the full investment? Well, recall that at this time, and indeed until the termination notice in 2005, there were 2 alleged violations given equal weight by the Privatization Agency. They were pressing both, 533, 534. Again, it was only years later, the exact moment of the termination, when they removed the 533 allegation. So put yourself in Mr. Rand's position. The 533 allegation couldn't be cured. The agency knew all the facts, the slaughter of the herd. There were no new facts to learn. These requests for audits were a ruse. To put it bluntly, one cannot raise cows from the dead. This was not curable. Nor was the 534 allegation curable by a simple payment. BD Agro paid off the 2010 loan. And the financial institution that held the pledge, remember Agrobanka, then controlled by Serbia, still wouldn't release the pledge on land, despite the fact that the loan had been paid off in 2012. Even though the loan had been paid off in 2012, Agrobanka, now controlled by Serbia, would not release the pledge on the land. So one hand from the government wouldn't release the pledge, even though required to do so, while the other hand from the government is demanding that BD Agro get it released. In short, the government of Serbia had put Mr. Rand in an impossible position. On 8 November 2012, the Privatization Agency sent another notice to Mr. Obradović, this time giving him another 30 days. But again, the agency knew the claimants couldn't provide the requested information. All the facts were known. Again, one can't raise cows from the dead. Again, it was a ruse. But if that were not enough, what happened next was truly extraordinary. Unbeknownst to the claimants, the privatization agency approached its legal advisor, its outside law firm, Radović and Raković, an external law firm that the privatization agency had used regularly in the past. And they asked for their independent external lawyer's opinion about their positions on Article 533 and 534. And that law firm issued an opinion, and its conclusions were striking. And we're going to go through those findings in detail in the next section. On the 11th of June 2013, the privatization agency's law firm issued its legal opinion, and it confirmed there was no legal justification for terminating. Now, you'll recall, members of the tribunal, the Ministry of Economy had already concluded there was no economic justification for terminating. Now you have a law firm saying there's no legal justification for terminating. In the legal opinion, the privatization agency reached the following conclusions. And I would ask the tribunal to contrast these findings with Serbia's position that you're going to hear later today. First, the privatization agreement was, and I quote, performed and fulfilled on 8 April 2011, and that, quote, all contractual and legal control authorities of the privatization agency ended. Second, quote, there is no legal possibility for extensive interpretation of the reasons for the termination of the agreement. And you can also see at the end in the law firm's own emphasis, that's their underlining, the following statement. According to the agreement itself, the agency does not have the right to terminate the agreement due to violation of obligation referred to in Article 534 because this is not stipulated as a reason for termination. Third, the privatization agency's legal advisor also confirmed that any actions taken after 8 April 2011, i.e. the final payment, were irrelevant. And fourth, the agency could not, quote, keep in force the agreement after all obligations had been fulfilled. Members of the tribunal, this evidence is damning. It matches precisely the reasoning of the Ministry of Economy, and it matches precisely our position in this arbitration. But it runs squarely counter to and directly undermines the position taken by Serbia in this arbitration. You may ask, what did the agency do with this opinion when it received it? Well, we know the answer to that question. As you can see from the next slide, they were told to, quote, put it in a drawer and forget the opinion ever existed. That's the testimony of Mr. Markicevic, which you see on this slide. And he identifies the particular individual who told him that. Now, I want to be clear, he had not seen the opinion, Mr. Markicevic, at the time. He had been told that such an opinion had been produced, but did not know the contents of it. It was only much, much later that the claimants actually saw the contents of this legal opinion. In sum, we have the Ministry of Economy, which supervises the privatization agency, concluding that there was no, and I quote, economic justification to terminate the agreement. We have the privatization agency's own law firm issuing a legal opinion stating that there was no legal justification for termination, but the privatization agency decided to hide these conclusions before the claimants and proceeded to terminate anyway. Matters were becoming dire, and it was now clear that the privatization agency, having been told both by the Ministry of Economy and its own independent law firm that its actions were illegal, had its own agenda. And BD Agro couldn't know what was incentivizing them to act this way. Now, around this time, Mr. Rand sought to have Mr. Obradović concentrate more on Mr. Rand's other Serbian businesses and sought to bring in a new nominal owner. Although we don't have a slide on this point to save time, the result was that the agency said that such an assignment was possible, but then refused to ever grant it. And there's evidence in the record to that effect. Now, I told you earlier that I would show you a document sent to the Minister of Economy himself, where Mr. Rand was described as the majority owner, and I'm going to do that now. In December 2013, Mr. Rand, given the dire situation, sought help from the Ministry of Economy through Milan Kostic, a member of the Serbian Progressive Party. You see the letter on your screen, and you see there that it's disclosed openly he is the majority owner of BD Agro. On the next slide, I'm going to show you the email chain that sent that letter. So you see Mr. Kostic sends the email to the minister's office, which you can see on the far right side of the screen, and you can see the email address that it's sent to uses the word cabinet in the address. That email address is for the office of the Minister of Economy. Then you can see, if you go to the bottom middle part of the screen, the office of the minister sends it to the minister's personal email address. That's the middle excerpt on the screen. The minister then sends it to Vladimir Milenković, who was director at the Serbia Investment and Export Promotion Agency, and Mr. Milenković then sends it to Goran Jofic, who was his deputy, and requests in all caps, urgent meeting needed. Urgent meeting. And that urgent meeting took place the next day. But before we talk about that meeting, let me just remind you again then, this isn't a letter that openly was discussing Mr. Rand being the majority owner of BD Agro that was sent to the minister himself. At this urgent meeting the next day, on the 19th of December 2013, BD Agro's representatives Aaron Broshko, Managing Director of Rand Investments, and Igor Markicevic, General Manager of BD Agro, Director of BD Agro, Director of SEMB, meet with SIEPA. And Mr. Broshko and Markicevic explained BD Agro's story, again that Mr. Rand was the beneficial owner, expressed concerns about these baseless allegations of violations that had been going on now for years, and noted the request for the assignment from Mr. Obradović, which had not been approved. And they were told that SIEPA would get back to them to address their concerns. Unfortunately, however, no one from the Serbian government ever followed up with Mr. Broshko or Markicevic. On the 23rd of December 2013, the Minister of Economy initiated a, quote, procedure for supervision of the work of the Privatization Agency. And I'll come back to the significance of that in a moment. Members of the tribunal, I have one further section to address before I'll ask your leave, Madam President, to turn the floor over to Mr. Misicic.
This may then also be a good time for a break because I see you're close to half of your presentation.
Absolutely. So we'll take the break then when I conclude and hand it over to Mr. Misicic.
That's what I meant, yes.
Okay, thank you. My final topic is that on the 7th of April 2015, the Ministry of Economy reverses course. Now, you'll recall that on the 30th of May 2012, so now almost 3 years ago, the Ministry of Economy confirmed that there was no economic justification for terminating the privatization agreement. Now, here we are 3 years later, and all of a sudden, out of the blue, the ministry changes its position. We can only speculate why. But one thing is for sure, there is a new Minister of Economy in office. Indeed, during the 10 years that Mr. Rand held this investment, before it was taken from him, the Ministry of Economy's office was a revolving door, with the minister himself changing 6 times in 10 years. So what happens with this newest minister? Well, I had just showed you that the Ministry of Economy had opened a supervision procedure to monitor what the agency was doing vis-a-vis BD Agro. And the new minister publishes its report on that procedure on the 7th of April 2015. And in that report, the Ministry of Economy states that it completed its supervision procedure and reverses course, suddenly instructing the privatization agency to require compliance, even though it had previously concluded that BD Agro was already in full compliance. And you see that on slide 132. Now, members of the tribunal, those conclude my remarks for today before I hand it over to Mr. Misicic to complete our section on the factual background. But I would leave you with the following. Given the facts that I've just described to you, what is Serbia's case? It is the following. We're stripping you of your investment in its entirety, which we ourselves valued after we took it from you at 56 million euro, based on a legal technicality. Even though the Ministry of Economy, the body that supervises us, said there's no economic justification for it, and even though your own external law firm told you there's no legal justification for it. If there were clearer facts of a breach of the proportionality principle under public international law, it is difficult to imagine what they could be. Thank you, Madam President.
Should we take a 15-minute break now and then resume for the second part of the presentation? Good?
Thank you.
And remember the mask. you ready to resume? Mr. Misetic, you
Yes.
have the floor.
Thank you, Madam President. Members of the Tribunal, it is an honor and pleasure to appear before you today on behalf of the claimants in this case. The first topic that I will address in my presentation concerns 2 meetings of the Commission for Control, which is the body that eventually rendered the decision to terminate the privatization agreement. The Commission for Control was comprised of 5 members, 3 of whom were appointed by the Ministry of Economy and 2 by the Privatization Agency. The meetings of the Commission for Control that I am now going to discuss took place on the 23rd of April 2015 and the 19th of June 2015. The discussions that took place during these 2 meetings were recorded in audio files produced by Serbia during the document production phase in this arbitration. As you will see and hear in a moment, these recordings prove, beyond any doubt, that the Privatization Agency was intentionally violating the law and treating the claimants in bad faith. On slide 134, you will see the audio recordings confirm that the Privatization Agency was fully aware that the pledge on the beneficially owned shares should have been released by the Privatization Agency upon the payment of the purchase price by the claimants. The pledge agreement was crystal clear. The Privatization Agency was required to lift the pledge on shares when Mr. Obradović paid the purchase price in full, which occurred on 8 April 2011. This is a crucial point because, as the Privatization Agency itself recognized on these audio tapes, had the pledge been released, the buyer would have been able to transfer the beneficially owned shares, after which the Privatization Agency would no longer have been able to expropriate the shares. We will now play for you some relevant sections of the recordings that address this point. The recordings are in Serbian, but we have added English subtitles to them so that you are able to follow the discussion. As you will now hear, the members of the Privatization Agency were aware that the buyer had a right to transfer his nominally owned shares in BD Agro as of 8 April 2011, but the Privatization Agency nevertheless preferred to breach its obligations, to breach the pledge agreement, so that they could expropriate his shares. The first voice you will hear on the audio is that of Julijana Vučković, a witness in this arbitration, from whom you will hear later this week. I think we have trouble with the audio.
Druga tačka je zahtjev kupca za tačka je zahtev kupca za ustupanje ugovora. Druga tačka je zahtev kupca za ustupanje ugovora. On je znači 17.4.2015. dostavio agenciji zahtev za izdavanje rešenja o brisanju zaloge na akcijama ustanovljene u korist agencije. Taj zahtev je dostavio u toku trajanja ugovora, a posle isplate kupoprodajne cene, pozivajući se na ugovornu odredbu koja kaže da kupac i agencija zaključuju ugovor o zalozi akcija, na osnovu koga kupac predaje agenciji potvrdu o akcijama koju agencija čuva do otplate kupoprodajne cene. Taj zahtev je postavio 2012. Mi nismo postupili po tom zahtevu, nismo odgovorili na taj zahtev. Iz istih razloga koje i sada navodimo u našem, da tako kažemo, obraćanju komisiji, gde kažemo ukoliko bi komisija izdala rešenje o brisanju zaloge na akcijama, ukoliko bi agencija, izdala to rešenje o brisanju zaloge na akcijama, kupcu upisanim u njegovu korist, on bi bio slobodan da raspolaže istima, što je izvesno imajući u vidu zahtev kupca za ustupanje ugovora. Ako se dozvoli to raspolaganje akcijama, na što on, ponavljam, opet ima pravo na osnovu ugovora, generalno agencija ne bi više bila u ugovornom odnosu sa nekim i ne biste mogli da preduzmete mere u odnosu na ugovornu stranu kad vam je pravni osnov generalno sa time otpoji da kupac može da raspolaže sa svojim akcijama. Takođe imamo nalog od ministarstva da se ostavi naknadni rok i saglasno tome mi smo i predložili isti rok, zapravo prepisali ono što stoji u izveštaju i pitanje šta da radimo sa zahtevom za brisanje zaloge. Prosto smo to pitanje postavili pred vas, imajući da već 2012. on postavio taj zahtev i da mi nismo izdali tu potvrdu. Mislim, svesni negde da on ima pravo po ugovoru, a svesni toga da ako mu se to dozvoli da on može dalje da otuđe te akcije.
Mislim, u kontekstu će on imati problema, objektivnih problema, da izvrši ove naše naloge. To je jedno. I drugo, sad odnos ugovora i predloga odluke oko ovih zaloge na akcijama, zato što prema ugovoru praktično zaloga treba da se briše kada isplati cenu koju je on isplatio. A s druge strane, onda imamo jednu nesigurnost šta će da uradi sa kompletnom imovinom kada onda može slobodno da raspolaže svojim akcijama. Onda nema potrebe ni da mu se daje ovaj rok ni ništa, onda će on da radi kako hoće. Sad samo to znači, da li on može da izvrše ove ugovore ukoliko ima mogućnosti da izvrše ove ugovore, kaže ove obaveze u odnosu na tu zabranu, tome samo.
A zaloga se nije vezala za izvršenje ugovornih obaveza, nego se vezala samo za kupoprodajnu cenu, što je očigledno nesmotreno napravljeno u ugovoru. A je sad zakon novi to ispravlja na neki način i kaže potvrda se izdaje i o brisanju zaloge i o ispunjenju ugovornih obaveza kad izvrši sve obaveze, a ne samo kupoprodajnu cenu. Eto, to je to i sad sam ni na nebu ni na zemlji. S jedne strane imate obavezu po ugovoru, a s druge strane vam je jasna posledica toga.
A on je isplatio kupoprodajnu cenu koje? 2000...
Aprila. Ne, 6. ratu je aprila 2012. 11.
Dobro, onda se nije ništa preduzimao u tom pogledu. Ne znam kako bi mogli, ne bi nikako mogli da formulišemo da pokrijemo i jedno i drugo. Kako svesni sad da mu to damo i da Nego nas posle Boga.
Pa dobro, idemo na to da mu ne damo, a on da ga teramo da nas tuži. To je, pa sud ne presuje.
Members of the tribunal, what you just heard and read proves that the privatization agency knew it was contractually obligated to release the pledge, but decided not to do so, just so that the buyer would not be able to transfer the beneficially owned shares, which he was fully entitled to do. The privatization agency also recognized that the claimants submitted an auditor report which proved that there was no breach of Article 5.3.3. And you see that quote on your screen. The buyer, and I quote, "The buyer then submitted certain proofs wherein the auditor confirmed that it fulfilled, that is, acted in accordance with the item 533. You have already heard about Article 533 from Mr. Anway, but I mention it again because, as I will show you in a moment, even though the privatization agency expressly recognized that it was in possession of proof that this provision had not been breached, and you have that excerpt on your screen where this admission is made, the privatization agency nevertheless continued to request from the claimants additional evidence of compliance with Article 533. We turn to slide 136. The participants at this April 23, 2015 meeting also acknowledged their awareness that they were placing burdens on the buyer which they knew the buyer could not meet. Yet they decided to participate in the charade of giving him an extension of time to comply with their requirements, while simultaneously acknowledging privately that he could not meet them, and while violating his rights to transfer the shares before the agency could expropriate them. And you see that quote on your screen, quote, "Since Juliana already said that there is no chance they will fulfill all of these contractual obligations." Slide 137. The privatization agency also admitted that it intentionally violated the law by not releasing the pledge. It admitted that it committed this willful violation of law in order to be able to seize BD Agro shares from the buyer before the buyer could obtain legal protection from courts. Again, we will now play a recording reflecting the privatization agency's discussion on this point.
O kupovini kapitala je rečeno da može da raspolaže sa akcijama, jel?
Da može kada isplati prodajnu cenu. To je on i učinio. Ali ako bi mi sad doneli tako, bar po mom mišljenju, ja ne bi bila sklona, mada imam problem sada sa ugovornom obavezom koja je tako kakva. Ako bi ministar skinuli tu zalogu, on bi mogo slobodno da raspolaže akcijama i da to proda. Tako da bi se ja sve založila za to da mi odložimo to brisanje zaloge do izvršenja, odnosno do isteka ovog roka dok on ne izvrši ove obaveze ugovorne koje smo mu naložili da uradi, odnosno ne mi to. A mi ćemo ih potvrditi kroz našu odluku. Sad jedino ne znam, oni mogu okrenu u neki spor i mi kršimo ugovor.
Kako se spor dobiti?
90 dana će proletati za tren, a spor neće se ni zakazati za 90 dana, tako da ćemo to rešiti pre, mislim...
Da, možda ćemo...
Džajlibu.
Imamo 90 dana. Kako ćemo vidjeti, to se šta ćemo?
Što 90 dana?
Što je sad? Nešto se tiče ovog roka od 90 dana i predloga ovih mera, tu nemamo šta mnogo da to nam je po nadzoru naloženo, tu nikad ne možemo nešto da...
The audio recordings literally speak for themselves. They reflect an utter disregard for the claimant's rights. the participants in this meeting are recorded acknowledging their decision to breach their obligations to lift the pledge on shares, acknowledging their plan to delay their final decision on the lifting of the pledge on shares until after they can terminate the agreement, and acknowledging that their actions will likely lead to a cause of action filed by the buyer against the agency. But the members of the agency simply do not care because, they say, they will be able to terminate the privatization agreement and expropriate the claimant's shares before the claimants would have enough time to get any court or tribunal to act. Slide 138. The privatization agency also expressly admitted at the same meeting that took place on the 23rd of April 2015 that the privatization agency was subject to outside pressure, including pressure from employees and trade unions. And you see the quote on your screen. We have mentioned daily communications we are receiving from the employees and trade unions. Slide 139. And from this slide, you can see how the outside pressure affected the decision-making of the agency. The discussion on the screen occurred after the participants acknowledged the buyer's right to have the share pledge lifted and right to transfer the shares to one of Mr. Rand's other companies. And it is because of that outside pressure from the unions and employees that one of the participants says, quote, "If we consciously give it to him now," meaning if we allow him his right to transfer the shares, "not even God could cleanse us." And so Sasha Novakovic of the privatization agency says, "All right then, we can decide not to give it to the buyer, and then we are forcing him into suing us. This is, may the court rule." In other words, we know we are breaching his rights, and we know he will sue us, but let a court or tribunal give it to him. And if the court or tribunal rules against the agency, that would be preferable to the agency itself complying with its obligations because, quote, "Not even God could cleanse us if we comply with our contractual relations and other obligations to release the pledge and are exposed to the wrath of outside pressure groups." On slide 140, as you can see on this slide, in the middle of the discussion of how much time they would give to the buyer to comply with the agency's requirements, the participants turned off the audio in violation of Serbian law. Given all of the admissions made on the audio, the claimants are only left to wonder what was discussed after the privatization agency turned off the recording device in violation of applicable law. Slide 141. One final point with respect to the April 23rd, 2015 meeting. As you can see on this slide, the privatization agency confirmed that it considered instructions from the Ministry of Economy received in April 2015 to be, quote, orders. So you see on your screen, underlined in red, we have an order from the ministry, as we were ordered to do in the supervision. That's ordered to us. The order of the ministry should be implemented as given. The minister ordered it. This is yet more evidence of the fact that the privatization agency was clearly exercising public authority when dealing with the privatization agreement, but you will hear more on this point from Mr. Pekash later today. Slide 142. I'm now moving to the second audio recorded meeting of the Commission, which took place on the 19th of June, 2015. As you can see on the screen, the privatization agency again expressly recognized during this meeting that there was no breach of Article 533 because the culling of cows, which was the main reason of the alleged breach, represented force majeure. And so you see a quote underlined on your screen. It really is not logical to me for us to impose obligations on anyone or terminate the agreement for disposing of assets in excess. In reality, it was force majeure. Slide 143. Despite the fact that the privatization agency recognized that there was no breach of Article 533 and that the claimants had already submitted an auditor report proving force majeure, just 4 days after this audio recorded meeting, the privatization agency on the 23rd of June 2015 requested from the buyer a new auditor report proving the buyer's compliance with Article 533. This request was completely unnecessary and indeed amounted to harassment, because the privatization agency itself was already in possession of all the evidence it needed to conclude that there was no breach of Article 533, as is evident from the 2 audio-taped meetings of the agency. This is therefore yet more evidence of Serbia's bad faith. Where is Sasha Novakovic? Sasha Novakovic is the Ombudsman, whom you read about in our pleadings. If we can turn to slide 145. Sasha Jovankovic, the Ombudsman, illegally intervened in the privatization process. Slide 146. On the 23rd of June 2015, the same day on which the privatization agency requested that the buyer submit a new auditor report, Mr. Jankovic published a recommendation that the privatization agreement should be terminated. Slide 147. The online statement published by the Ombudsman expressly confirmed that, in his investigation, Mr. Jankovic was not focused on the rights of employees that he purported to protect, but rather was focused on whether the buyer had fulfilled the terms of the privatization agreement. Slide 148. To be clear, the Ombudsman had no jurisdiction whatsoever to investigate fulfillment of the privatization agreement, as the Ombudsman is only entitled to investigate potential breaches of human rights. But Mr. Jankovic was not deterred by the legal limits to his jurisdiction. Instead, he commenced an investigation into the privatization agreement itself, based on a complaint by a small number of BD Agro's employees who were calling for the termination of the privatization agreement. I would like to pause here because it is important to put this complaint into a proper context. Complaints like this were very common in all post-communist countries. The reason for this fact is very simple. In the vast majority of cases, the management of companies before and after privatization was very different. State and socially owned companies were often managed in a very inefficient manner, with very low labor productivity and overemployment. After privatization, new owners often implemented measures aimed at increasing the efficiency of companies and their employees. Even more importantly, and this was also the case with BD Agro, new owners often put a stop to various types of inappropriate behavior that was typical in state and socially owned companies, such as misappropriation of assets. Moreover, new owners promoted employees based on merit rather than on seniority, as was the practice in state and socially owned enterprises. Obviously, not all employees liked these types of changes, and they took steps to achieve reversal of the privatization process. To sum up, the Ombudsman's intervention was unlawful. The Ombudsman clearly expresses public authority, but did not have jurisdiction to investigate the privatization agreement itself. He clearly did not have authority to opine on interpretation of the agreement to determine whether any breaches had occurred, let alone whether such breaches justified termination of the privatization agreement. And the Ombudsman made his recommendations without hearing the affected parties. Indeed, the Ombudsman recommended termination without having even contacted the owners of BD Agro to hear their views. The Ombudsman, Mr. Jankovic, had political ambitions, which is in the record, and 2 years later finished second in the race for president of Serbia, which may explain some of his unusual actions in the present case. But Mr. Jankovic is not a witness in this arbitration. We would have liked to have asked him some questions on these topics, but are unable to do so. Slide 151. And what was the outcome of the Ombudsman's unlawful intervention? As I will show you in the next section, it resulted in the termination of the privatization agreement and expropriation of the claimant's investment. Slide 152. Before the termination, Mr. Rand had one more meeting with Serbian officials. Specifically, Mr. Rand met with Mr. Ivica Kojic, the then Chief of Staff of the Prime Minister of Serbia. As you can see on this slide, Mr. Rand testifies that Mr. Kojic apologized for the conduct of the privatization agency and the Ministry of Economy and promised that the claimant's problems would be resolved shortly. But Mr. Kojic also is not here to answer questions because Serbia has not offered him as a witness. Slide 154. The situation, however, was indeed resolved, but not in a way that the claimants expected or were entitled. On the 18th of September 2015, the Ombudsman wrote again to the Privatization Agency and the Ministry of Economy to stress that the privatization agreement should be terminated. Just 10 days later, the Privatization Agency followed the Ombudsman's recommendation and terminated the privatization agreement based on an alleged violation of Article 534 alone. Members of the Tribunal, as you have seen on some of our previous slides, up to this moment, the Privatization Agency repeatedly requested evidence of compliance with a number of other provisions of the privatization agreement, most importantly, Article 533. As I have already explained, the Privatization Agency did so even though it was well aware that these provisions were fulfilled. But when it decided to terminate the privatization agreement, the Privatization Agency dropped all references to alleged violations of Article 533 and other provisions, and instead focused only on an alleged breach of Article 534. As I will explain in a moment, this is a crucial point because even if there were a breach of Article 534, and there was none, a breach of Article 534 in 2010 did not and could not, under Article 7 of the Purchase Agreement, represent a legitimate ground for termination of the privatization agreement in 2015. Slide 156. As you can see on this next slide, after the Privatization Agency rendered the decision to terminate the privatization agreement, it sent a notice of termination to BD Agro. The agency waited until this notice of termination of the agreement to advise the buyer that it no longer alleged a violation of Article 533 or any other provisions of the agreement except Article 534. Importantly, the notice of termination expressly stated that the Privatization Agency terminated the privatization agreement in line with the report of the Ministry of Economy. This is yet more confirmation of the fact that the Privatization Agency was clearly acting based on instructions of the Ministry. Slide 157. As I noted a moment ago, the Privatization Agency terminated the privatization agreement based solely on an alleged violation of Article 534, which did not represent a ground for termination under the privatization agreement. Slide 158. What is Serbia's answer to the fact that the privatization agreement did not allow for termination based on a breach of Article 534? It argues that you should simply disregard the agreement and instead look to the general provision on the law on privatization regulating termination of the privatization agreement. This approach, however, fails for three different independent reasons. Slide 159. First, the Privatization Agency could not rely on Article 41A13 of the privatization law because this provision only refers back to the privatization agreement, which does not state that a violation of Article 534 is a basis for termination. Slide 160. In other words, Article 41A of the law on privatization is only a general provision that must be read in conjunction with the privatization agreement. Not only did the privatization agreement not provide for termination based on a breach of Article 534, but Article 534 on its own terms applied only until payment of the purchase price, which took place in April 2011, 4 years before the termination of the privatization agreement. Slide 161. Second, even if you were to look at Article 41A in isolation, there was no violation of this provision. This is because even if there were a technical violation of Article 534, it was a violation for only 4 months and was cured when the buyer made the final payment in April 2011. As you can see on this slide, Article 41A states that a privatization agreement can only be terminated if a breach identified by the Privatization Agency is not remedied within the additional period given to the buyer by the privatization agency. In other words, if the privatization agency identified a breach of the privatization agreement, it was first supposed to give the buyer an additional time period to remedy the breach. Once that period expired, the privatization agency was supposed to check whether the breach still existed as of the end of the additional period. In case the alleged breach was remedied, or the obligation under the privatization agreement ceased to exist before the end of the additional period, a privatization agreement could no longer be terminated. Members of the tribunal, this is exactly what happened in the present case. All obligations under Article 534 ceased to exist in April 2011, when the purchase price was paid in full. Thus, when the last additional period given to Mr. Obradović expired in 2015, Article 534 no longer applied. This in turn means that there could not have been any breach of this provision, and there was no basis for termination of the privatization agreement. Slide 162. Finally, even if Article 41A could be applied in isolation, and even if there could have been a breach of Article 534 in 2015, and as I just explained, this is not the case, a potential breach of Article 534 still would not represent a valid reason for termination of the privatization agreement. This is because Article 534 did not represent an essential term of the privatization agreement. On the contrary, because Article 534 would only have been a minor breach of the privatization agreement. As Mr. Anway explained earlier today, under Serbian law, Article 534 is not an essential term of the privatization agreement. And in any event, the alleged breach was minor. An agreement can be terminated under Serbian law only for a violation of an essential obligation. And you can see confirmation of this from the claimant's Serbian law expert, Mr. Milošević, in front of you on the screen. He says, quote, "In my opinion, the obligation under Article 534 is not an essential obligation under the privatization agreement." Slide 163. To conclude, the privatization agency could not rely on Article 41A13 of the privatization law because this law only refers back to the privatization agreement, which does not state that a violation of Article 534 is a basis for termination. Second, even if Article 41A was to be applied in isolation, there was no violation of this provision because there could not have been a breach of Article 534 in 2015 when the last additional period granted by the privatization agency had already expired. And finally, even if Article 41A13 could be applied in isolation, and even if there could have been a breach of Article 534 in 2015, a potential breach of Article 534 would still not represent a valid reason for termination of the privatization agreement because it was only a minor breach. Slide 164. Given all of the above, it is absolutely clear that the privatization agency's requests for remedies were unjustified, arbitrary, and nonsensical, and the termination of the privatization agreement was completely disproportionate and done in bad faith. Slide 166, please. On the 21st of October 2015, the privatization agency rendered a decision on the transfer of beneficially owned shares to the privatization agency, thus expropriating the beneficially owned shares. Needless to say, this conduct would not have been possible in any commercial relationship. It was only possible because the privatization agency exercised public authority. Slide 167. This conclusion is further confirmed by the fact that, as explained by expert witness Milošević, the Central Securities Depository was obliged to transfer the beneficially owned shares to the privatization agency upon its receipt of the decision on transfer. Once again, this power does not arise merely from a commercial relationship. Slide 169. And what was the outcome of all of this for Serbia? It acquired a company which, based on the valuation commissioned after Serbia took control of BD Agro, had an equity value of 56.3 million euros. And Serbia acquired it without paying any compensation to the claimants whatsoever. BD Agro's employees all lost their jobs, and the assets of the company were sold under suspicious circumstances, which we have outlined in our correspondence to the tribunal. Slide 170. We would very much like to discuss these facts with the Serbian officials responsible for this outcome. However, as you can see on this slide, while there are several names that you have heard repeatedly today, you will not have an opportunity to speak to any of these people. For example, you cannot ask Mr. Jankovic, the Ombudsman, why he felt authorized to recommend termination of the privatization agreement. You also cannot question Mr. Kojic, the former Chief of Staff of the Prime Minister and the current Chief of Staff of the President of Serbia, who promised Mr. Rand that all problems would be resolved to his satisfaction. You will not be able to ask Mr. Kojic what changed between his promise and the termination of the privatization agreement that occurred only 2 weeks later. You also cannot speak to Mr. Novakovic, a member of the commission that decided on the termination of the privatization agreement, and who you could hear on the audio recording we played earlier today saying was better for the agency to breach its obligations and lose in court or in arbitration than to comply with the agency's obligations under the pledge agreement. And finally, we do not have Mr. Bubalo, the Minister of Economy at the time of the privatization, who could testify about his knowledge of Mr. Rand's beneficial ownership. We will leave it to the tribunal to make its own conclusions about why these people are not participating in this arbitration. Madam President, members of the tribunal, that concludes our presentation of the facts of the dispute. With your leave, Madam President, I would invite Mr. Pekash to address the tribunal on jurisdiction, merits, and quantum.
Madam President, it is my honor to address you today and all members of the tribunal on behalf of the claimants. My presentation, as foreshadowed by Mr. Mišetić, will focus on the remaining 4 areas of our claim. First, I will discuss jurisdiction, then attribution to Serbia, then violation of Serbia's obligations under the treaties, and finally, quantum. Tellingly, Serbia raised a number of objections to jurisdiction over the present dispute. In total, we counted 7 of them. Some of them actually include several grounds. I will not be addressing all of them today. They were extensively addressed in our rejoinder on jurisdiction, which is the latest party submission on that issue. And I would kindly refer the tribunal to the details of our arguments, which are laid out in that submission. The one objection I do wish to address in greater detail at this hearing is the objection jurisdiction ratione materia under the 2 BITs, because that objection relates to the question whether the 2 BITs protect claimants' beneficial ownership over what we call the beneficially owned shares. This is a 75 and something % shareholding in BD Agro, which was nominally owned by Mr. Đura Obradović. The beginning of our analysis is 19 September 2005, when Mr. Obradović and MDH, a BVA company owned by Mr. Rand, enter into an agreement, which we call the MDH agreement. And under that agreement, MDH, and therefore its owner, Mr. Rand, acquired beneficial ownership over the beneficially owned shares pro futuro in the event that Mr. Obradović is successful in the auction for privatization of BD Agro, in which he was to participate as a nominal bidder for the benefit of MDH and Mr. Rand. Mr. Enway explained already to you that there is ample evidence on the record that this structure was known to the Serbian Ministry of Economy, and the Serbian Ministry of Economy, which supervises the privatization process, expressed strictly no reservations with respect to this structure. The MDH agreement does several things. It grants a call option on the shares for the benefit of MDH. The call option can be exercised for a nominal amount of 1,000 euros. It obligates MDH to secure financing for the investment in BD Agro shares and the subsequent investment in the operations of BD Agro if the shares are acquired. And then, very importantly, Articles 4 and 5, independently of the call option, create rights which constitute the basis for MDH and Mr. Rand's beneficial ownership of the shares. So in Article 4, we can read that the shares in BD Agro shall be and remain at the risk of the purchaser. And then in Article 5 of that agreement, we can read that MDH, and therefore Mr. Rand, will have ample rights to direct Mr. Obradovich's exercise of his shareholder rights in BD Agro, which include matters such as the nomination of directors, for example, at the shareholders' meetings of BD Agro. The agreement does not have a governing law clause, but the parties intended it to be governed by the laws of British Columbia, which is evident from the person of the drafter of the agreement. This is Mr. Rand, who used to practice law in British Columbia for, I believe, over 25 years, and who resides in Vancouver. And even MDH, which is a BVI company, has a place of business in Vancouver. Most importantly, the parties, or rather the representatives of the parties to the MDH agreement, that is Mr. Rand for MDH and Mr. Obradovich for himself, agree even today that the laws of British Columbia are the laws which they had in mind at the time, and they are, to the extent that this actually is possible, willing to make that choice of law even retrospectively today. And I will pause when addressing this point a little bit, because it is a recurrent feature of Serbia's arguments in this arbitration that Serbia looks either at the MDH agreement or the SEMBI agreement, which we will see in a while, reads that agreement as if the agreement is the beginning and end of the world, to determine then what the rights and obligations of the respective parties of that agreement were. Here, I believe we must understand that these agreements are important in this arbitration, but they are not contested. These agreements merely document a long-term cooperation, long-term relationship between the parties, which are represented by Mr. Rand and Mr. Obradovich here. And while various corporate entities were used for the documentation of that cooperation at its different stages, one thing is important. Mr. Rand and Mr. Obradovich always acted in perfect agreement. Obviously, there were some difficult moments in that cooperation. One of such difficult moments came in 2013 when Mr. Rand decided to replace Mr. Obradovich as a manager of BD Agro. But as we know from the testimonies of both these gentlemen, even that difficult decision did not change the fact that they were and still are acting in agreement, and they were acting in agreement even in the years 2013 to 15, let's say, when Mr. Obradovich was still the nominal owner of BD Agro, but no longer a manager or director of that company. And therefore, if we hear arguments such as that Article 2 of the MDH agreement provides for a method of transfer of the shares in BD Agro which just cannot be effectuated, and as a result, we, I now speak for Serbia, believe that the agreement is invalid because the parties did not agree on any alternative method of transfer, etc., these arguments simply are not valid. There is no indication on the record that there was any disagreement as between Mr. Rand and Mr. Obradovic. They were always acting in agreement, and it was clear that if there is a difficulty of a technical character like this one, this will be simply resolved by agreement on a different method of transfer. And this different method actually, and now I return to my slide 175, we have on the record the expert report prepared by the claimant's expert on British Columbian law, Mr. Dean, who confirms that MDH became the beneficial owner of the beneficially owned shares as soon as Mr. Obradovic acquired them, and independently of the exercise of the call option. And that entails also the fact that under British Columbia law, MDH had the right to insist on the transfer of nominal ownership at the time of MDH's choice, and Mr. Obradovic had an obligation to comply. And the parties then would have simply sat down and found a way how the transfer can be accomplished in accordance with Serbian law and any other applicable requirements. The fact that that method of transfer was not spelled out in the MDH agreement has strictly no bearing on the validity of the MDH agreement, and more broadly on the fact that Mr. Obradovic and Mr. Rand cooperated, and that Mr. Obradovic at all times recognized that he is merely a nominal owner of the assets, such as the beneficially owned shares in BT Agro. I already foreshadowed the second document, which is important to document the existence of beneficial ownership, is the SEMBI agreement concluded on 22nd February 2008, which superseded the MDH agreement and which brought into the picture one of the claimants in this arbitration, the Cyprus company SEMBI. The SEMBI agreement has a governing law clause which provides expressly for Cyprus law. We asked our Cyprus law expert, Mr. Georgiades, to review the agreement, and he concludes that the SEMBI agreement is perfectly valid and enforceable under Cyprus law. Mr. Georgiades also confirms that the SEMBI agreement granted the claimants beneficial ownership over the beneficially owned shares. What the SEMBI agreement did actually is that it applied to three categories of assets. And the assets and the transfers with respect to these assets depended on whether some further, as it is put in the agreement, the need to sign additional documents was there or was not. So the first category of assets covered by that agreement were the shares in BD Agro. Their transfer of nominal ownership required additional paperwork. The parties did not intend, obviously, for the SEMBI agreement to transfer nominal ownership. They knew that this was not sufficient to have such an agreement, and therefore this was left for the future and for execution of further documents. The SEMBI agreement, however, the effect of the SEMBI agreement was that beneficial ownership in these shares did transfer to SEMBI. Only beneficial, not nominal. With respect to the privatization agreement, there was again a requirement for the consent of the privatization agency for the assignment of that agreement. That again is something which required further paperwork. The parties did not obviously intend that the SEMBI agreement alone would effectuate such assignment. They simply agreed to do the paperwork if and when necessary. However, under Cyprus law, this was sufficient to transfer the equitable interest in the privatization agreement to SEMBI. And then the third category of assets were the receivables that Mr. Obradovic held against BD Agro on the basis of shareholder loans that he had provided to the company in prior years. There, for the assignment of such receivables, no further paperwork was needed, and therefore SAMBI became the owner of these receivables as of the moment of signing the SAMBI agreement. The SAMBI agreement, Serbia now says, violated Article 41J of the law on privatization because Serbia says that article makes assignment of privatization agreement conditional upon consent of the privatization agency. Here we must look at how assignment is defined under Serbian law. The definition of assignment under Serbian law is different from the definition of assignment under Cyprus law. And obviously what Article 1J of the law on privatization has in mind is the Serbian law definition of assignment, because that's a piece of Serbian legislation. And under Serbian law, an assignment occurs only at the moment when one contracting party is replaced by a third party which becomes bound by the agreement. This is not what the SAMBI agreement in itself sought to achieve, and as a result, Mr. Miloš Milošević, our Serbian law expert and former Serbian judge, concludes that the SAMBI agreement did not violate Article 41J. The SAMBI agreement also did not violate Article 295 of the 2004 law on companies, which restricts the ability of directors to direct the shareholders in the companies where they are directors to vote their shares in a certain fashion, because this provision of Serbian law does not apply to agreements between nominal owners and companies owned by the beneficial owners. So this is what I would call the substantive perspective of that provision. And then from a purely formalistic perspective, which however is probably what informed Serbia's objection in the first place, Mr. Rand is not a party to that agreement. The agreement is between SAMBI and Mr. Obradović, and not directly between Mr. Rand and Mr. Obradović. We believe that the more important argument actually is the substantive one. The purpose of Article 295 is to avoid managers who are not owners from maintaining their position indefinitely by controlling the shareholders. Here we have actually the opposite situation. We have Mr. Rand as the beneficial owner, who because of his beneficial ownership later also became director of BD Agro and remained a director of BD Agro until 2012. The SAMBI agreement also did not violate Article 52 of the 2006 securities law, because the transfer of nominal ownership of the beneficially owned shares could have been effectuated in a number of methods which were in full compliance with Serbian law. This is the conclusion of our Serbian securities law expert, Mrs. Tomić Brkušanin, who will be cross-examined later this week, and who is very knowledgeable about these matters because she's a former official of the Serbian Securities Commission. So this is about the facts and the two agreements which are the most important for the assessment of beneficial ownership. Now let me speak briefly about the law. The protection of beneficial ownership is a general principle of international law, we submit. And we cite here on this slide to a scholarly article which was published quite some time ago in 1989, and which based that statement mainly on the jurisprudence developed by the US and United States Claims Tribunal, which did recognize claims by beneficial owners. We obviously also have much more recent legal authorities for the same proposition. Here on this slide you can see 3 investment arbitration awards which speak about beneficial ownership. I believe the most important one is the one at the left, This is the Oxy versus Ecuador 2 case, the annulment, where the annulment committee clearly stated that neither the international principles nor the committee's decision imply that investors holding beneficial ownership are left unprotected from interferences by host states. Such investors will enjoy the protection granted under the treaties which benefit their nationality. And this is exactly what Sambi and the Canadian claimants are doing today. Serbia tries to avoid that general principle of protection of beneficial ownership under public international law by arguing that beneficial ownership is not protected under Serbian law. However, that argument fails because the protection of beneficial ownership under international law does not depend on the enforceability of protections granted to beneficial owners against third parties under the domestic law of the host state. This is the Iron United States Tribunal decision to which I referred a second ago. Serbia also argues that under Serbian law, the claimant's beneficial ownership would be labeled as a right in personam rather than a right in rem, and somehow tries to deduce from that therefore it is not protected under the two BITs. While we will look at the BITs in a moment, let me state that the labeling of the claimant's rights under Serbian law does not matter for the purposes of public international law analysis, but even if it did matter, then it is quite clear that public international law protects both rights in rem and rights in personam. And here we are quoting for that proposition the decision in Magyar Farming Company versus Hungary, which we do not need to introduce further to this tribunal. So the conclusion is clear. Public international law in general protects beneficial ownership. And while Serbian law may not protect it in the same fashion, Serbian law certainly does not prohibit beneficial ownership. And in any event, the approach to beneficial ownership under Serbian law simply does not matter because Serbia's obligations under public international law, and specifically under the two BITs, prevail over Serbian law. So now let's take a brief look at the bilateral investment treaty. So first we have the Canada-Serbia BIT, which has an incredibly broad definition of covered investment in Article 1. It states that a covered investment is an investment owned or controlled directly or indirectly by an investor. This is one of the broadest definitions, if not the broadest definition, of an investment under any bilateral investment treaty. On the following slide, we added a few additional reasons as if the broad scope of Article 1 was not enough. Obviously, it is not a surprise that a Canadian BIT would be focusing on beneficial ownership because Canada is a common law jurisdiction which routinely protects beneficial ownership. Then the second bullet point addresses the very formalistic argument which was raised against us and which is based on the fact that in some continental law jurisdiction one cannot be an owner of an in-person right, one can be a holder of that right. There is this semantic dichotomy which luckily has no place under public international law, but lest there be any doubt, we looked at the French version of the Canada-Serbia BIT, which employs the term détenu instead of owned. Therefore, this should be clear that this dichotomy has no place under the Canada-Serbia BIT, and that beneficially owned shares constitute a covered investment under the Canada-Serbia BIT. And the beneficially owned shares are a covered investment also because of another completely independent reason, and that is that they are, and well, they were before they were expropriated, always controlled by Mr. Rand, a Canadian national. And actually, for the purposes of this jurisdictional argument, it does not matter whether that control was de facto or legal control, because there is ample investment arbitration jurisprudence which confirms that both legal and de facto control satisfy requirements such as those in Article 1 of the Canada-Serbia BIT. And then, even though the definition of control under domestic law is irrelevant, Mrs. Tomic Barkushanin confirms that Mr. Rand controlled BD Agro also within the meaning of Serbian law. And last but not least, what constitutes the beneficial ownership obviously can be labeled beneficial ownership, and we prefer that analytically it is preferable to label it in this manner. But the beneficial ownership stems from the rights granted to SEMBI under the SEMBI agreement. And if we took a slightly different perspective, we would see that the Canadian claimants also, are indirect beneficiaries of the rights granted to SEMBI under the SEMBI agreement. These rights then create what would be called, using the language of the Canada-Serbia BIT, an interest in an enterprise, the enterprise being BD Agro, which entitled the owner to share in income or profits of the enterprise. This is a type of covered of investment expressly provided for in Article 1F of the BIT. And obviously, for an interest in an enterprise to exist, it is irrelevant that SEMBI never acquired nominal ownership of the shares. The protection of an interest in an enterprise is not contingent on the acquisition of any ownership of shares, be it nominal or beneficial. Even though we could say that then the interest overlaps with what we label as beneficial ownership. So this is a bit of semantics only. And then there is another type of interest which is also protected under the Canadian-Serbian BIT, and this is an interest arising from the commitment of capital or other resources in the territory of a party to economic activity in that category, and that would be satisfied as well. Now, instead of doing the same rather long exercise under the Cyprus BIT treaty, let me just conclude that obviously all of the arguments about public international law and the irrelevance of labeling under Serbian law also apply for the Cyprus-Serbia BIT, and the text of that BIT, even though it is definitely shorter than the Canada-Serbia BIT, provides for, we submit, an equally broad definition of investment, which are defined as any kind of assets, in particular, though not exclusively. Therefore, this is the typical open list of investments which we see in, I would say, older BITs. And the assets which are mentioned there are shares, claims to money or to any performance under contract having economic value. However, because the list is not closed, if the tribunal believes that the best approach to, the analytical approach to the rights that SEMBI had is the interest in an enterprise, which is used in the Canadian BIT, nothing in the Cyprus BIT prevents the tribunal from taking the same analytical approach, because it states any kind of asset, in particular, though not exclusively. Serbia argues that the Cyprus-Serbia BIT, because it uses the words invested, requires an active commitment of capital. So first of all, we believe that the argument is moot on the facts, because SEMBI paid 5.6 million euros for the beneficially owned shares, and this is well documented in this case. But we believe that Serbia actually is wrong also on the law, because as the tribunals in Saluka versus the Czech Republic and Mytilineos versus Serbia both explained, the term invested actually is a simple link which does not require any additional actions on the part of the investor. And then we also believe that the cases Standard Chartered Bank versus Venezuela and Alapli versus Turkey, and I would say generally Professor Park's interpretation of are not applicable in this case, simply because the Cyprus-Serbia BIT does not have the off language. Then Serbia also argues that the investment does not meet the definition ratione materia under the ICSID Convention. Here I will be extremely brief. Obviously, even if the Salini test were to apply, it is satisfied. And then the second argument seems somehow to suggest that the ICSID Convention does not allow claims by indirect shareholders or claimants. That also obviously has been disproved many, many years ago. That leads us to claimant's objection against jurisdiction ratione voluntatis, and this is the most important part of it, is the one where it is stated in rather strong terms that the investment violated Serbian law. We grouped the arguments raised by Serbia into 4 categories. The first category are objections raised on the alleged violation of a duty to disclose the beneficial ownership, presumably during the participation in the auction for BD Agro's shares. The second category is the money siphoning objection. The third category is what we call land machination objection. And the fourth category is something I have touched to some extent already, and that's the argument that the MDH agreement and the SAMBI agreement somehow conflict with Serbian legislation on trading with securities. One very important thing I would like to mention at the outset is that the first 3 categories of objections were raised only in the rejoinder and not in the counter memorial, and as a result they are inadmissible. The ICSID Convention and the ICSID arbitration rules are absolutely clear. Objections to jurisdiction must be raised within the time limit set for the filing of the counter memorial, and that time limit was not observed here. There's no excuse for Serbia having missed that time limit, because if we look at the points in time when the alleged fact became known to Serbia, we see that it is very, very long before the date of the counter memorial, and of both the counter memorial and then the rejoinder when they were finally raised. Therefore, no excuse for the belated raising of these objections. Another important rule is that illegality may only affect jurisdiction if it occurred when the investment was made and not then later on during the lifetime of the investment. And here the siphoning and land machination objections, so that would be objections 2 and 3 from my list, do not relate to the making of the investment. They relate to something which happened thereafter. And in fact, they strongly, obviously, misinterpret what happened thereafter, to put it very mildly. Another important rule is that only fundamental violations of law necessary to the making of an illegal investment will deprive a tribunal of its jurisdiction. And this is through these lenses also that we must look at the securities law objections. So as I already said, the objection based on Article 52 on the law on securities is just baseless, because there were legal methods how to transfer the shares from Mr. Obradovic to SAMBI or MDH. There was also no violation of Article 531 of the Privatization Agreement through the conclusion of the MDH agreement, because what Article 531 of the Privatization Agreement prohibited was change in legal title, change in nominal ownership, and that did not happen. And therefore there was no alienation as it is defined under Serbian law. And as I already said, I believe the SAMBI agreement did not violate Article 41J, because it did not seek to immediately assign the Privatization Agreement to SAMBI as assignment is defined under Serbian law. The SAMBI agreement also did not trigger a takeover bid obligation, because it did not involve change of control. Mr. Rand had controlled the beneficially owned shares even before the SAMBI agreement, and he continued to control them after the SAMBI agreement. And finally, the MDH agreement and the SEMBI agreement did not violate this prohibition of agreements between directors and shareholders in a company for the reasons I have already explained. And therefore, what we call the securities law objection is completely baseless. The siphoning objection, which got very significant traction in the rejoinder, is untimely, but in any event, it was done without any real deep analysis of all of the accounts, without any real deep analysis of all of the transfers. We had Mr. Hearn then run his own analysis, and his conclusion is quite clear. Serbia failed to demonstrate any impropriety with respect to the money transfers between BD Agro on the one hand and Mr. Obradovic and or other Serbian companies beneficially owned by Mr. Rand on the other hand. With respect to the land machination objection, all of the transactions with BD Agro's land were legitimate, and the land swap was declared invalid due to the failure of the Ministry of Agriculture to obtain internal approvals. It is quite unbelievable, actually, that Mr. Obradovic had to spend some time in detention in connection with the criminal investigation of a transaction whose criminal character is in the fact that the Ministry of Agriculture did not obtain internal approvals. And then that leaves only the non-disclosure objection, and that was actually addressed by Mr. Anway, who was explaining the requirements with respect to the participation in the auction and the fact that Serbia did not ask about beneficial ownership in the papers that needed to be filled in for the participation in the auction, unlike in some other previous privatizations where they were interested in that information and presumably got it from the people participating. So if we just have this summary slide, it shows that Serbia's illegality objections fail because none of them fulfills all three hurdles. The only which was raised timely is the securities objection. The securities objection is also one which admittedly refers to the making of the investment, but there is simply no violation of Serbian law there, let alone a fundamental one. I will just briefly address the argument that somehow Mr. Rand's claims with respect to the indirect shareholding, the small shareholding that he has, even nominally indirectly through the Serbian company MDH Serbia, are inadmissible because MDH Serbia failed to file a timely waiver. I will just simply point out to the fact that Serbia has MDH Serbia has substantially complied with that obligation by filing that waiver at a later stage, and and the waiver actually was not required in the first place because Mr. Rand is raising a typically indirect claim. Then we have objections ratione temporis. I will just skip through them. The fact that the Canadian-Serbian BIT entered into force on 27 April 2015 changes nothing because the important facts, the termination of the contract and the expropriation of the shares happened in September and October 2015. The release of the failure to release the shares is a pre-existing breach of contract, which however continued even after the entry into force of the BIT, and thus it is a typical example of a continuing breach which falls within the tribunal's jurisdiction ratione temporis following the entry into force of the treaty as here. There was also an objection to jurisdiction based on the fact that somehow the claimants did not observe the 3-year time limit under Article 22 of the Canada-Serbia BIT. That is incorrect because that 3-year time limit requires not only knowledge of a breach, but also knowledge of loss that the investor has incurred. Obviously here the losses have been incurred or were incurred actually only at the moment when the shares were expropriated. And that is within the 3-year time period. Equally briefly, there is an objection to jurisdiction under the Cyprus BIT, which is based on a distinction between seat, which is the language used in the Cyprus BIT, and registered office, We now have the Mira decision and also Professor Park's dissent in CEAC versus Montenegro, which confirm both that seat under the Cyprus-Serbia BIT means registered office. Some other tribunals interpreted the same words differently, but that was in different, under different treaties, most often which provided for tests like effective management, real economic activities, or real seat. Nothing of that applies here. And the majority in CEAC Montenegro actually, with all due respect, got it wrong with respect to the Cyprus-Serbia BIT, but it is important to understand that they were doing so in very extreme circumstances where there was simply no signs of presence of the CEAC claimant at the place of its registered office in Cyprus, and the CEAC claimant never offered any evidence that the address was ever used for any business purposes. That does not apply to Serbia, and it's not even alleged that it should. And then there also is the test for holding companies developed by the Tenaris Tribunal, and we satisfied that test as well. Serbia is a holding company which has limited but still some activity in Cyprus, as demonstrated also by the minutes of the meetings of directors. In any event, Mr. Georgiades confirms that under Cyprus law, seat is registered office. Obviously, the analysis should be done primarily under the BIT and not Cyprus law, but it's helpful to know that there is no discrepancy. And finally, there was no abuse of process with respect to the claims because the beneficial ownership of the shares was recorded by SEMBI in 2008. Therefore, filing an arbitration claim, what was it, 10 years later, obviously cannot be an abuse of process, something made up just for the arbitration. That concludes my submissions on jurisdiction, and I will just go really quickly through attribution because that hard work was already done by Mr. Anway. First of all, Mr. Anway mentioned two decisions by the European Court of Human Rights, which found that the privatization agency is a state entity that fits squarely into attribution under Article 4 of the ILC articles. If that was not enough, we also know that the privatization agency is empowered by Serbian law to exercise elements of governmental authority, and as a result, the conduct of the privatization agency is attributable to Serbia also under Article 5 of the ILC articles. And again, even if that was not enough, then we also have Article 8 of the ILC articles, which covers conduct specifically directed by the state. And you have seen that the conduct of the privatization agency was specifically directed by the Ministry of Economy. In the interest of time, I will skip the section regarding the merits of our claims. We have a very distinguished tribunal which does know public international law, therefore we have no doubt that the tribunal will be able to review and assess the arguments we have made. I would just go directly to slide 240, which deals with the distinction between commercial and sovereign acts. The privatization process in Serbia was a governmental process pursuing a sovereign goal of economic development and social stability. And the non-commercial goals of privatization were also reflected in certain provisions of the privatization agreement. And we have investment arbitration decisions such as Audi versus Romania, which clearly state that privatization agreements and their performance involve the exercise of sovereign powers by the state party precisely because of the broader goals of privatization agreements, which are also present in the privatization agreement in question. And Bosca versus Lithuania confirms that acts adopted in privatization agreements are governmental in nature. And in any event, as Mr. Anway already said, the privatization agency itself explained in an ICC arbitration that it exercises sovereign powers in performing privatization agreements. Then there should be, just a reminder, there should be no doubt that the acts of the Ombudsman were clearly sovereign and not commercial act. The authority for it is, for example, Vivendi versus Argentina, another case we do not need to explain. And then what is interesting is the holding of the tribunal in Karatube versus Kazakhstan, which confirms that a contract termination which was ignited, and here I would say not only ignited but also fueled to some extent, by recommendations issued by a state body with no authority to do so, is a sovereign measure. This is exactly what happened here. The Ombudsman was not the only voice calling for the termination of the agreement, but he certainly was very vehement in pursuing that goal. And that leads me to the last part of my submissions, which is quantum. The claimants are entitled to compensation for their losses. So let me first review the applicable legal standard. Obviously, the principle that expropriation or other treaty breaches must be compensated is not disputed by Serbia. I believe that we should also have agreement on the fact that in the standard for expropriation, compensation for expropriation is a full reparation requiring payment of fair market value. And in cases of other breaches, if there is some residual value of the investment, that needs to be deducted from the value of the investment prior to the breach. Here, there actually will be some residual value. We were very recently informed that the bankruptcy trustee of BD Agro is willing to pay 89,000 euros approximately on the 2.5 million loans that Mr. Rand had provided to BD Agro, and we will be formally amending our claims to reflect that, obviously assuming that the amounts will be paid as promised. From the perspective of valuation in this case, it is important to note that the fair market value is the price a willing buyer would agree with a willing seller, and here comes the important part, unaffected by any compulsions and restrictions. Please remember that when we discuss in a while the various discounts that Serbia proposes be applied to the value of BD Agro's assets for alleged problems with bankruptcy. Now, second part of my submissions on quantum look at the valuations presented by claimants in this case. So Dr. Hearn, in his two reports, estimated BD Agro's equity value between 53.3 million and 81 million euros. This slide shows how he got to these numbers. As you can see, the main value driver is the value of the construction land that BD Agro owned in zones A, B, and C. Some small part also elsewhere. And then the second most important item is the residual discounted cash flow value of the farm business post-tax. That leads Dr. Hearn to a certain total asset value set out at the end of the first table. Then he subtracts total liabilities, 40 million, and that gives him the total equity value I just mentioned. These numbers, members of the tribunal, will be slightly adjusted in the presentation that Dr. Hearn will give on, I believe, Tuesday next week. As I will explain later, in an effort to bridge the gap between the parties, and having had the chance to review the latest submission on quantum, to which he did not have a chance to respond yet, he decided to slightly adjust the size of the construction land in zones A, B, and C, which results in a few million less of total equity value for the entire company. But both before and after that adjustment, claimant's valuation is in line with three contemporaneous valuations of BD Agro and its assets which were carried out between December 2014 and February 2016. According to these valuations, the equity value was between 56 and 71 million euros prior to the breach, and both, so prior to the breach, as of December 31st, that would be the 71 million euro implied value, because that valuation didn't go as far as to calculate the equity value, it just calculated the value of the land, and then 56 million after the breach. Two of these valuations, the lower ones, were expressly endorsed and relied upon by the privatization agency at that time. So the first valuation, the higher one, was prepared as of December 2013 by Mr. Mrgut. We have a real estate expert, Dr. Chris Grzesik, who actually confirms that Mr. Mrgut's valuation is correct, and Dr. Grzesik actually believes that the value would be even higher at 85 million euros. And you will hear from Mr. Grzesik and why he believes this is the right value, I believe, on Monday next week. Second, we have the two valuations which were endorsed by Serbia. They were both prepared by the company Confinex. The first one in November 2000, the first one was contracted in November 2015 by Mr. Markicevic, but it was, and Confinex concluded that BD Agro's equity value as of 31st December 2014 was 57.2 million. Serbia accepted the valuation and a pre-packed reorganization plan submitted by the new Serbia-appointed management of BD Agro in January 2016. And it was also approved by the General Assembly of BD Agro's shareholders, where Serbia was the dominant shareholder. And then we had the third report and second report by Confinex, which valued the equity value of BD Agro as of 31st December 2015. The value was 56.3 million, so that's immediately after the breach. That report was commissioned in January 2016 by the management of BD Agro, fully appointed by the privatization agency. Mr. Knežević, the representative of the privatization agency in BD Agro, accepted the updated valuation. And again, the shareholders of BD Agro, meaning the privatization agency, mainly submitted it to the commercial court in Belgrade as their official filing. The Confinex valuation was also used for revaluation of assets in BD Agro's financial statements, which were accepted by BD Agro's General Assembly, controlled by Serbia, and the bankruptcy trustee nominated by the Agency for Licensing of Bankruptcy Trustees. And obviously it would have had even criminal law implications for the managers of BD Agro to, let's say, not state the truth, or at least what they believed to be the truth in the financial statements of the company and in all these important documents that the company was filing to the Serbian courts in connection with the fact that at that time, after 10 years of disastrous management by the privatization agency, it was on the verge of bankruptcy. Now, why do we disagree with Serbia in this arbitration about the value of BD Agro? There are 6 main issues in dispute, we believe. The first one is the size of construction land. So Dr. Horn originally stated it's 290 hectares, to which Mrs. Ilic responded by conducting her own independent analysis and saying it's 279 hectares. In her second report, Mrs. Ilic was instructed by Serbia to decrease that number to 169 hectares. We believe that this instruction should be simply disregarded, and so does Mr. Hearn, who reviewed Mrs. Ilic's arguments and came to the conclusion that actually the 279 hectares, the value that she set out in her first report, should be used as the size of the construction land. So the first issue now does not exist as a contested issue, at least as between claimants and Mrs. Ilic's first report. We obviously still disagree with the 169 figure provided, or rather I would say instructed by Serbia. Another area of disagreement is the price per meter square of construction land, where we say, based on both Mr. Hearn and Mr. Hearn sets a value of between 22 and 30 euros per square meter. Mr. Grzesik definitely supports the higher bound. Conversely, Mrs. Ilic is as 21 euros per square meter. And then the other 4 items of difference all relate to discounts. And we say very arbitrary discounts which are taken by Serbia's experts. So first, Mrs. Ilic has a completely unexplained 30% discount for the size of the land. And we will obviously cross-examine her on that discount. That figure is then taken without any critical review by Mr. Cowan. And he adds further discounts. So we have a bankruptcy sale discount of 50% proposed by him, which we believe is entirely inappropriate because BD Agro was not in bankruptcy. And it is definitely contrary, actually, to the definition of fair market value, which this tribunal should use under public international law. Then he adds a further distress discount of 30%, which is unacceptable for the same reasons. And at the end, he adds costs of bankruptcy, which again completely ignores the fact that BD Agro was a going concern as of the expropriation date. But also it states that the bankruptcy cost would be 20% of the company value, while, as we have seen in recent correspondence, the actual bankruptcy cost incurred so far at a stage of bankruptcy where Mr. Rand is actually offered already some payment on his receivables are only 179,000 euros. So Mr. Cowan has that, what I believe, if I remember well, 1,400% off. So I already explained that there will be a slight adjustment of our claim due to the fact that claimants now accept the 279 hectares size of the construction land, so that we did the calculation here just for the tribunal to see that it does not have any dramatic impact on the numbers. Mr. Hearn will then provide a more detailed calculation when he is doing his opening presentation. So the lower bound of the BD Agro equity value is now 51.1 and the upper bound is 78.2. Because we did not have an opportunity to respond to Serbia's latest submissions on why the size of the construction land in BD Agro should be only 160-something hectares rather than 279, we have a few slides on this here. We do not believe it's particularly important, actually, because the reasons are clearly bogus. The reasons for the exclusion of the land have many things to do with the background of the bankruptcy and its sale and the bankruptcy sale in Serbia. We explained that already. Do not need to return to this. So this plan actually shows you the land which was excluded. This is the land in red. And the most prominent cause for this exclusion is the sham dispute with Budućnost Dobanovci, an entity that nobody has ever heard of, and which conveniently filed a claim only before the valuation for the purposes of the bankruptcy sale was to be done. It was then dismissed, but used as a pretext by the bankruptcy trustee for excluding the land. We believe that such sham claims have no place in an arbitration like this one. We also explained the issue with the land swap transaction. The land swap transaction is relatively unimportant because it only relates to agricultural land, which is not a value driver. And in any event, the land swap, even though it was invalidated, our position is that this will ultimately lead to compensation for the land to be paid by Serbia. Therefore, there's no need to deduct anything on that account. And on the following slides, we also explain a few other claims, third-party claims to the land, which are relatively minor. And we would ask the tribunal to review these slides simply to satisfy itself that our and Mrs. Ilic's actually original 279 hectare size of the construction land is entirely appropriate. Then when it comes to the price per meter square. I already explained that Mr. Grzesik, our real estate expert, fully supports the upper bound of Mr. Hearn's valuation at 30 euros per meter square, and he will explain why when he is cross-examined. He also confirms that Dr. Hearn's valuation follows a universally recognized valuation approach and relies on extensive research. Why does Mrs. Illich have a completely different number? Well, we say this is mainly because she very conveniently disregards two comparable transactions with construction land in Dobanoci. Dobanoci is the small village at the suburbs of Belgrade where the farm is located. And these two transactions have a median price of 31 euros per square meter. So this is even above the figure provided by Dr. Hearn. This is because these transactions, he believes that some adjustment should be made to these transactions, but that is clear market evidence, and we haven't seen any compelling reason why this should be disregarded as Mrs. Illich does. I already stated that the discounts that Mrs. Illich and Mr. Cowan then propose are completely unjustified. So the discount for size of land, there's really no justification for it. Similarly, there is no justification for a bankruptcy sale discount and distress discount, simply because if we look at BD Agro as of October 2015, BD Agro was not in bankruptcy. It was discussing about a reorganization plan, but it was still a going concern at the time of expropriation. It was declared bankrupt only 10 months thereafter, after, as I said, a disastrous management by the privatization agency. And one of the disasters was that the management appointed by Serbia completely ignored the reorganization plan, which had already been approved by BD Agro's creditors shortly before expropriation. And finally, the bankruptcy costs, I already explained that it is actually rather absurd for Mr. Cowan to count bankruptcy costs in millions, knowing that the actual bankruptcy costs of a bankruptcy which is at the stage of distribution already were only 179,000. So in conclusion, on quantum, this is the comparison of what we have on table. So first of all, we have claimants slightly adjusted BD Agro equity value, that's 100% equity value, between 51.1 and 78.2 million. We have Mr. Mergood's valuation, which implies an equity value of 71 million as of 31st of December 2014, so 9 months before the expropriation. We then have the first Confinex valuation, which is as of the same date, and which states an equity value of 57.2 million. Then we have the second Confinex valuation, which is for 31st of December 2015, so right after the expropriation, which is for 56.3 million. That is in a, I would say, stark contrast with the number provided by Mr. Cowan, which is between 5.8 negative to 13.8 positive million euros. I believe, members of the tribunal, that there should be no doubt, absolutely no doubt, that BD Agro was a valuable business. The main value driver was the construction land, which explains the liquidity problems that BD Agro had at that time. But despite the liquidity problems, this was a very, very valuable company, and Serbia fully agreed with that assessment at that time. And members of the tribunal, that concludes our submissions on quantum and the opening statement in this presentation, in this arbitration.
I anticipated the last sentence. I should not have. But congratulations for achieving in exactly 3 hours, according to my count. do my co-arbitrators have questions for the claimants at this stage, or I suppose we would rather hear the respondents than see later today if we have questions, and probably I think we will be eager to hear the witnesses and experts, and at some later time have questions for counsel. But if you have a question now, you're of course free to go, free to ask it.
Madam President, I have two rather small questions, but I'm in your hands, if you prefer.
Well, if it helps you to have them clarified now, that there's no reason not to ask them. It's just, I'm used to just listening more and then also hearing the respondents and then get to questions. But you're obviously, if you need just clarifications, you're welcome to ask.
Yes, just two quick point of clarification. One concerns Article 131 of the 1978 Law of Obligations. Probably if it can be put on the screen, it would be helpful. It is with regard to the existence of an insignificant part of the obligation and determination, yeah? You mentioned, according to your position, that there was no, even if there were, assuming, there was no insignificant breach or obligation. Here we have the text: an agreement cannot be terminated due to the non-performance of an insignificant part of the obligation. Your argument was that there was no, even if there were, the breach would have not been essential. And my point is, so this distinction between what is an essential obligation and what is an insignificant or significant. Could it be that a breach of an obligation which is not essential is nevertheless significant, or vice versa? That's the question, the first question.
Thank you, Professor Cohen. I believe that this is a question that Dr. Miloš Milošević would be eager to answer. For our part, these are two different concepts. An obligation is essential or non-essential. It could also, I discussed that with Mr. Milošević recently, it can also be used as accessory instead of non-essential. That is one distinction. And our position is that only breaches of essential obligations may lead to termination. Breach of a non-essential obligation, even if it's breached completely, once the obligation is non-essential, it cannot lead to termination at all. And then in addition, there is Article 131, which distinguishes between insignificant parts and limits the ability of a party to terminate an agreement for breach of an essential. It's not stated here, but that would follow from our previous argument, if it is breached only insignificantly. And in this case, we submit both that Article 534 was not an essential obligation, therefore its violation did not give rise to the right to terminate, and that even if we accepted that this is not correct and the opposite is true, then given the size of BD Agro's land and the value of BD Agro's land, the fact that there was a pledge on a small part of it to secure a loan which was in its totality 2 million euros approximately, but it is, I believe, accepted by Serbia that more than 1 million was used, perfectly legitimately, so there's 1 million where there is a question mark. So even if Serbia was right that yes, 1 million was not used as it was supposed to be used, the pledge is so small compared to the entirety of the assets of BD Agro and the value of the assets of BD Agro, that it would be only an insignificant part of the obligation not to pledge assets that would be breached. And therefore, it would not be possible, or it was not possible to terminate the privatization agreement also for this reason.
Yeah, thank you for this answer. My second brief question concerned the release of the pledge. According to the agreement, it should be done after the payment of the last installment. But it was mentioned that according to a new law, this should be done after all obligations are fulfilled. My question is, could you tell us when this new law was enacted?
So I believe that you are referring to the audio recording which we had. That I do not know for sure, and again, Mr. Milosevic will be able to answer. There was a major change in the law in 2014. So I believe that this relates to 2014, but to be confirmed by Mr. Milosevic. One thing which is also important is that there was a principle of non-retroactivity in the new law. So basically the new legal provisions did not apply to previous privatization agreements.
Thank you very much. That's all my questions, Madam President.
Thank you. Do you have any questions? No. No. Neither do I have questions at this stage. We can now take the lunch break. We have provided that we would take an hour, so now it's 37. Let's resume at 1:40. Is that fine with everyone?
Yes, Madam Chairman.
Good. Have a good lunch, everyone.
They have to, a lot of forms.
Yeah.
Oh, but then it's really cool they got it, no?
I think I'm like the only one joining.
Oh, I see, I see, I see.
So I think it just worked out with the timing where someone who they were renting it to, it just
Leaving.
recently left.
Senka, me čuješ? Da li je ovo okej?
good. I hope everyone had a good lunch, and we're ready to continue, and we're ready to listen to the respondents' opening. To whom do I give the floor first?
To me, Madam President.
To you, Ms. Mihar, please.
Thank you, Madam President.
I'm sorry to interrupt. I have one housekeeping matter
Yes,
that I
sure.
would, apologies for that. So first I would like to rectify what I told you this morning with respect to the people who are in the remote room. I forgot about my colleague, Mrs. Bolinova, who will be there today and also all the other days. I apologize to her and to you for that. And there also, when we came down for lunch, we realized that even though he was not invited to do so, Mr. Obradovic was in the room for the second part of our presentation. We reminded him of the rule that obviously he is not able to assist, and we made sure that he is not there, and the lawyers who are there for our legal experts will make sure that he will not reappear in the room on his own. He understood the situation. There was a misunderstanding on his part. We apologize for that problem. I just want to be transparent about it. All he heard is the second part of our presentation that he had already known from our preparations in any event, and we made sure that he's not there for, obviously, Serbia's opening statement.
Yes, and until he's heard, because that's
yes.
the rule, right? He's sequestered. And I watched this morning that we had Mr. Markicevic here and Mr. Broshko and Mr. Rand, of course, but no one else. Yeah. But I'm not used either to having two rooms, and I have no screen where I can see who's there. And that also reminds me, we may have representatives of Canada who said they would attend. They will do so during business hours in Toronto, so maybe they have joined now or will soon join if they're there. Of course, we acknowledge their presence and greet them. You've heard this mishap of Mr. Obradovic being in the room during the second part of the claimant's opening, and you heard the apologies. Anything would you wish to comment in any way?
Well, I think that all I can say now is that apparently claimants cannot control Mr. Obradovic, so apologies accepted.
That was it. No further points, nothing on your side that you wish to raise?
Not at this moment, thank you.
Good. Then please, you have the floor.
Thank you, Madam President. Dear members of the Tribunal, the opening statement of the respondent will comprise of three parts. First, I will deal with some main factual issues. Then Professor Đundić will address the question of the lack of jurisdiction in this case. And lastly, Dr. Đerić will address a few questions concerning the alleged breaches of the applicable BITs, as well as the amount of damages requested. The three questions that I will address are: who was the owner of the shares in BD Agro, how Mr. Obradovic managed BD Agro, and what circumstances led to termination of the privatization agreement. So when it comes to the question who was the owner of the shares, we heard also today during claimant's opening statement that the investment in BD Agro was all about Mr. Rand, that Mr. Obradovic was only a vehicle whose purpose was to play the role of the nominal owner of BD Agro, while the Lundin family were nothing more than extremely generous billionaire friends of Mr. Rand. And that is the story that claimants and their witnesses are telling us. However, as will be demonstrated during the respondent's opening statement, this story simply does not fit in with the documents that we have in the files. And my intention is not to tell you what happened back then between Mr. Rand, Mr. Obradovic, and the Lundins, because I simply don't know. just like the tribunal does not. But what I think any reasonable person can conclude from the documents that are presented, in this case is that claimant's narrative, as well as the narrative of their witnesses, is not truthful. There are too many gaps between their allegations and documentary evidence. So let us see what the written documents dating years before this arbitration tell us. So according to Privatization Agreement, the investment in BD Agro alone amounted to 7.5 million euros. That was the price and the investment according to Privatization Agreement. So in addition to BD Agro, Mr. Obradović also privatized 6 other companies in Serbia. According to claimants, all of these companies were beneficially owned by Mr. Rand, while Mr. Obradović was only a nominal owner. Yet, although we are talking about an investment worth millions of euros, there is no single paper in the files concerning the said arrangement between Mr. Rand and Mr. Obradović. So we should believe that Mr. Rand simply gave Mr. Obradović millions of euros and made him the owner of the shares of 7 Serbian companies without any agreement or document showing Mr. Rand's beneficial ownership and control over these companies. What we do have in the file is the share purchase agreement from September 2008, referred as MDH agreement, that is CE15. So what was the purpose of the MDH agreement? Again, I cannot tell you, and simply we do not know. But I think that it is obvious from the provision of that agreement that it was not to confirm that MDH was the beneficial owner of BD Agro shares. So let's look at the provision of the MDH agreement. As you can see, MDH agreement states in 2 different provisions, in point C and then again in point 3 of it, that the sole and beneficial owner of BD Agro is or will become Mr. Obradović. And this agreement was concluded before privatization agreement. So I would say that this document defeats the basic pillar of claimants' claim that before the privatization, I quote, Mr. Rand and Mr. Obradović agreed that Mr. Obradović would submit the bid in the auction and if successful would nominally acquire the privatized shares while Mr. Rand would become the beneficial owner. That was stated in claimant's memorial in para 67. Let us turn back to the MDH agreement. There is also a call option in point 2 of that agreement. And the call option should have enabled MDH to, I quote, become the registered and beneficial owner of the shares. So apparently, without the call option, MDH could not claim that it is the beneficial owner of the shares. And of course, claimants admit that in their reply in para 67, that the said option was never exercised, which means that the ownership over the privatized shares remained in Mr. Obradović's hand. Let us now turn and see what the financial documentation that we have in the files reveals. So we have Mr. Obradović, to whom Mr. Lundin, Longdale Assets, Mr. Adolf Henrik Lundin, and some oil company paid 10.5 million euros. So according to documents in file, these payments were made for different purposes, including, I quote, real estate investment, and then purchasing real estate in Serbia, and even 3 payments to Mr. Obradović were referenced as dividend. Of course, no reference to payment for BD Agro was ever made. And then again, there is no single agreement on the record between Mr. Obradović and these financial donors, which would show the legal basis and the motive behind these 10.5 million euros payments. Or in other words, there is no evidence that these payments were made for investment in BD Agro. In fact, it is unlikely that, for example, the payments referred as purchasing real estate in Serbia or dividends had anything to do with investment in BD Agro. Or to put it differently, all these payments were equally likely to be made for BD Agro as for any of the other 6 privatized companies in Serbia or any other Mr. Obradović investments in Serbia or elsewhere. All these payments, as the documents reveals, were made between January 2006 and February 2008. And during that time, Mr. Obradović also made payments for investments and the purchase price, not only BD Agro, but also in other privatized companies. However, apparently the Lundins did not finance only Mr. Obradović, but they also financed MDH, to whom they borrowed 3.3 million euros for, I quote, purchase, firm and building, and market research purposes. And we simply do not know how and where MDH spent these 3.3 million euros. There is no trace of that, not a single document. So there is no document on the record showing that these millions were paid to Mr. Obradović or invested in BD Agro. As a matter of fact, there is no document that these 3.3 million euros were invested in Serbia at all. Of course, it is conceivable that this money found some informal way of reaching Mr. Obradović, but that would obviously breach a lot of financial and criminal regulations in a lot of different countries. So I suppose that this did not happen. Other than the MDH agreement, claimants submitted 2 agreements concluded in February 2008, and these are Exhibits C 28 and 29. And according to claimants, these agreements were used by Mr. Rand to restructure his beneficial ownership. The first 2008 agreement was concluded between Mr. Obradović, the Lundins family, Mr. Rand, and Sembi Investment. According to that agreement, which I will refer as Lundin Agreement, it was Mr. Obradović and not Mr. Rand who borrowed 9 million euros from the Lundin family. It is clearly stated in that agreement. Again, this agreement shows that it was not Mr. Rand, but Mr. Obradović who held the interest in the privatization agreement. On the other hand, Sembi, according to the Lundins agreement, only wished, I quote, to acquire all the interest in BD Agro from Mr. Obradović. So it is clear that Sembi could not wish to acquire the interest in BD Agro from Mr. Obradović if that interest, as claimant suggests, was already in the possession of Mr. Rand or its affiliates. But it was not. It was in the possession of Mr. Obradović, and that is why the Lundin family secured their claims on Mr. Obradović's interest in the privatization agreement. And finally, what is also very, very important is that Mr. Obradović remained fully liable for any payments to Lundin family under this agreement. So I have to say that it simply makes no sense that Mr. Obradović would accept to remain jointly and severally liable towards the Lundins for the 9 million euros claim related to the company in which he does not have any interest nor control. Let me now turn to the second 2008 agreement. That agreement was concluded between Mr. Obradović and Sembi, and I will refer it as Sembi agreement. What we see from Sembi agreement is that in addition to 9 million euros borrowed from the Lundins for the investment in BD Agro, Mr. Obradović also borrowed another 4.8 million euros from some unidentified institutions from Geneva. So according to claimant's story, this 4.8 million also came from the Lundins. However, the problem with this is that there is simply no document that will prove this. Not a single document. And in fact, when you read Sembi agreement, you will notice that in point C of preamble, when it mentions 9 million claim, it explicitly refers to Lundin family. On the other hand, in the next sentence, when it refers to 4.8 million claim, it says other institutions in Geneva. So why would it be drafted like that if both claims belong to Lundins? And another question, why this debt of 4.8 million would not be referred to in the Lundins agreement together with 9 million claims? When it comes to transfer of the interest in the privatization agreement from Mr. Obradović to Sembi, in point 4, Sembi agreement stated that it will be done in consideration for Sembi, assuming the obligations that are mentioned in points 1, 2, and 3 of that agreement. So the first obligation was for Sembi to assume all obligation of Mr. Obradović towards the Lundin family, amounting to 9 million euros as set out in the Lundins agreement. The second obligation was for Sembi to either pay to Mr. Obradović the amount of 4.8 million euros owed to some institutions in Geneva, or to assume full responsibility for the repayment of this debt. Finally, the third obligation was for Sembi to pay around 2 million euros due to privatization agency. And claimants contend that all of these obligations have been fulfilled. They say that out of 13.8 million allegedly owed to the Lundins, Sembi paid 5.6 million euros, and that the Lundins waived the remaining debt. That is stated in memorial in paras 89 to 94. They also claim that Sembi paid the remaining part of the purchase price to the agency, amounting to just over 2 million euros. And that is stated in Mr. Obradović's third witness statements in paras 74 to 80. However, and again, no documentary evidence in that regard. And my intention is not to derive any legal conclusions that arise out of lack of evidence that Sembi performed its contractual obligations from the Sembi agreement. My intentions is simply to present to you the state of the facts as it stands from the documentary evidence, which is that Mr. Obradović allegedly transferred his interest in BD Agro although remaining liable for multi-million euro claims. And let us now see the evidence concerning the payments according to Serbia agreement. So we have the Lundin's agreement that kept Mr. Obradović jointly and severally liable for the 9 million claim. Claimant says that 5.6 million was repaid to the Lundins. To prove this, they delivered the document that showed the following. First, they show two payments from 2008 amounting to 3.6 million. These payments were made by reference to the agreement from 22nd February 2008. One payment was made to Mr. Ian Lundin, while the second one was made to company named FBAT Advocates. Then we have the third payment that was made in 2010. It amounted to 2 million euros, and it was made to a company named Untitled Asset Corporation, and it was designated as payment of loan installment. No reference to Lundin agreement was made. And we also have no documents showing any connection between the said company and the Lundins. As for the 4.8 million euros allegedly also owed to the Lundins, let me remind you that under the Serbia agreement, Serbia agreed either to pay 4.8 million to Mr. Obradović or to assume this debt. And claimants want us to believe that this amount was assumed by Serbia towards the Lundins. However, as I already said, there is no documentary evidence that this was indeed the claim of the Lundins family. And even more importantly, there is no document that Serbia ever assumed this debt towards anyone, or that it paid a cent to Mr. Obradović. In other words, according to documentary evidence that we have in our files, some unidentified institutions in Geneva still hold 4.8 million claim against Mr. Obradović. Finally, 2 million euros owed to the Privatization Agency was paid by Mr. Obradović personally. And there is no documentary evidence that Mr. Obradović received that money from Serbia. What we have instead is explanation of Mr. Obradović in his third witness statement in paragraphs 74 to 80 of what allegedly happened with these payments to the Privatization Agency. In simple terms, Mr. Obradović allegedly paid a shareholder loan to BD Agro, then BD Agro returned that loan to him, and then Mr. Obradović used this money to pay the 2 million debt towards the Privatization Agency. And that is how allegedly Serbia settled this debt to the agency. Again, we have no document concerning this agreement between Mr. Obradović and Serbia. No agreement concerning the payment of 2 million euros to Privatization Agency. To cut a long story short, out of 15.8 million euros in total that Mr. Obradović should have been released from by Serbia agreement, we have documents showing that only 5.6 million euros were paid to some Lundin and two other companies. According to documentary evidence, Mr. Obradović is thus still liable to Lundins for 3 6.4 million euros under the Lundin Agreement and 4.8 million euros to some institutions in Geneva. So I have a question. Is it really likely that Mr. Obradović would transfer all his interest in BD Agro and still remain liable for these millions allegedly spent for the privatization of that company? And I would say that the answer is self-evident. And that is in fact precisely why claimants had to resort to patching holes in their story by claiming that for the remaining debt, and that is in total 8.2 million euros, the Lundins, I quote, agreed to waive the outstanding balance of the debt as a token of appreciation of their long-standing successful business relationship and friendship with Mr. Rand. That is stated in claimant's reply in para 108. I have to say that I simply cannot buy that in 21st century, two experienced businessmen, Mr. Rand and Mr. Lundin, agreed about the waiver of 8.2 million euro debt without exchanging a single paper. I think that that would be not only illogical, but that would be in contradiction to both SEMBI and Lundin agreements. As you will see, both of them explicitly stipulate, I quote, neither this agreement nor any term hereof may be amended, waived, discharged, or terminated, except by written instrument signed by the parties hereto. In other words, without a written instrument signed, a waiver simply could not and did not happen, which means the Lundins, as well as some institutions in Geneva, I would say, still hold their claims against Mr. Obradović, who was that naive to nevertheless transfer his interest in BD Agro to SEMBI. So after we have seen all these documents, I think that it is safe to say that we have an elephant in the room this whole time. The Lundins, they are everywhere in the papers, but they are nowhere to be seen in these proceedings. They did not even appear to confirm that they waived more than 8 million euros. And when it comes to the roles that Mr. Obradović, Mr. Rand, and the Lundins had in relation to BD Agro, as you can see on the slide, Mr. Obradović evidently held all crucial elements of an actual owner. He concluded the privatization agreement, he paid the price for the shares, he made non-refundable investments under the agreement, and he was registered as the owner. On the other hand, Mr. Rand, as well as Lundins, had some connection with BD Agro. So, Mr. Lukas Lundin and Mr. Rand were both members of the management board of BD Agro. Mr. Ian Lundin received financial reports of BD Agro, while all of them discussed the operations of BD Agro. And claimants put a lot of emphasis on the Canadian flag that was placed in front of BD Agro. They also mentioned that today. So let's remind you that, for example, Mr. Obradović was both Serbian but also Canadian national. But claimants, however, remain silent on the reasons why would Swedish and Swiss flags, which represents Lundin's nationalities, be also there if that represents a proof of someone's beneficial ownership over BD Agro. Or perhaps all these flags were just a marketing. Let us now see what Mr. Rand and Mr. Obradović communicated to the relevant authorities even after Serbia agreement was concluded up until the termination of the privatization agreement concerning the question of ownership. So from 2013, Mr. Rand wanted to transfer the privatization agreement from Mr. Obradović to Koropi. In 2013, Mr. Rand's attorney presented Mr. Rand to the agency as the potential investor. I quote, interest to take over the privatization agreement of that company from the current majority shareholder. In one of the letters to the ministry from September 2014, for example, Mr. Rand himself explicitly said that he made a request to the privatization agency, I quote, to allow the transfer to him or a company owned by him of Mr. Obradović's ownership in BD Agro. And these letters sent to the agency and the ministry were therefore clear about who was the owner of the shares, Mr. Obradović. And this is probably why Mr. Rand wrote to the ministry that he is, I quote, reluctant to invest further time and money if there is doubt about whether ownership can be transferred. And first of all, if there was indeed a difference between nominal and beneficial owners of the shares, why Mr. Rand was not specific and referred to transfer of nominal ownership of the shares? And second, had Mr. Rand really exercised full ownership and full control over BD Agro shares, then why suddenly, from 2013, registration of his nominal ownership became that important to him that it even prevented Mr. Rand from investing in his own company? The fact of the matter is that whenever Mr. Rand, Mr. Boško, or even BD Agro's manager, Mr. Markicević, sent a letter concerning the transfer of the privatization agreement to Koropi, they never, and I repeat, never mentioned that Mr. Rand actually already considered himself as the beneficial owner. And you have plenty of their letters. They are designated as 37, C 37, 38, 113, 319, 325, 328, 329, 334, 707. So please read all these letters. Not a word about Mr. Rand's beneficial ownership. And another question. If Sembi was already the beneficial owner of shares, why wouldn't they mention that in 9 letters they have sent? And yet another question. Why would not Sembi, alleged beneficial owner of the shares at that time, be the company interest in the transfer of nominal ownership instead of Koropi? In the period 2014 to 2015, Mr. Rand as well as Mr. Markicević wrote to the agency and the Ministry of Economy only that since the summer of 2013, Mr. Rand supported BD Agro financially in the amount of about €500,000. We also have in the files a letter that was sent in 2015 by Mr. Rand and to Mr. Markicevic, who was the CEO of BD Agro. And this is what Mr. Rand wrote to Mr. Markicevic. He said, I quote, "In any case, any chosen model of cooperation will have to provide us with adequate security for our investment while enabling BD Agro to duly settle its financial obligations towards creditors under the adopted pre-packed plan of reorganization." This quotation, as well as this letter in general, simply does not sound like the letter that the owner would send to its company. Why would someone who is already a beneficial owner, allegedly covered by the Serbia agreement, talk about possible model of cooperation? And why would it require adequate security for the investment in his own company? That simply makes no sense. Finally, and I would say most importantly, the man who concluded the privatization agreement and was registered as the owner of the shares never, and I repeat, never stated that he was not the actual owner. Not a single document in the case file. The first time Mr. Obradović said that was in this arbitration when he appeared as the witness on claimant's side. What Mr. Obradović claimed, even in September 2015, just before the termination of the privatization agreement, is that he personally is a foreign investor, Canadian citizen, whose investment is protected by the Canadian-Serbian BIT. And although mentioned in this letter, you will see that Mr. Rand was not designated as the owner of the shares, but rather as a potential investor who expressed his willingness and interest in providing the necessary financial support for the recovery of BD Agro. Let me now say something about control of BD Agro. So claimants put a lot of effort in showing how Mr. Rand was the one who managed BD Agro and made all relevant decisions. And they have submitted plenty of emails exchanged between Mr. Rand and the employees of BD Agro discussing certain matters regarding the business and finance of BD Agro. However, I do not see any weight in these mails. As you can see from CE 72 and CE 255, Mr. Rand was a member of the board of directors, and he was also indirect minority shareholder of BD Agro. And this explains his involvement in BD Agro's affairs. Moreover, the details of the business and financial affairs of BD Agro were also shared and discussed with the Lundins as well. And you can see that from CE 584, 585, and 586. However, what is crucial when it comes to management and control of BD Agro is the fact that you will not find a single paper showing that Mr. Rand ever instructed Mr. Rand when it comes to management of BD Agro. Mr. Obradović, I'm sorry. So we do not have any document showing that Mr. Rand ever issued any orders or instructions to Mr. Obradović. To the man whom he allegedly controlled. On the other hand, even when accused of various criminal acts connected with his involvement and control of BD Agro, Mr. Obradović never mentioned that any of his actions were the consequences of the instructions of Mr. Rand, who was alleged owner, according to claimants. And you can see on the slides quotations from documents originating from the criminal proceedings. And in addition to Mr. Obradović's silence on Mr. Rand's alleged involvement, it is also worth noting that during a whole decade of criminal investigations regarding the management of BD Agro, which were conducted by many different public prosecutors and police authorities, there was still no trace of any link between Mr. Rand and decisions that influenced BD Agro's management in multi-million euros matters. Even the person who allegedly knew all about Mr. Rand's beneficial ownership, and that is Mr. Ljubiša Jovanović, the CEO of BD Agro between 2005 and 2013, was very explicit in his testimony before the prosecutor about who was the owner and had the full control over BD Agro. So Mr. Jovanović said, I quote, "Đuro Obradović was an initiator. He was the owner who was permanent and who dealt with key issues, some other acquisitions and relationships with banks, all that should be done by a majority owner." And let us now see how deeply claimant's story is undermined by lack of documentary evidence. As you will see from the files, there is no contract for the initial payment of 10.5 million from the Lundins and other companies to Mr. Obradović. There is no contract nor any other documents concerning payment of 4.8 million euros to Mr. Obradović by some institutions in Geneva. There is no contract for the payment of 3.3 million euros from the Lundins to MDH. There is no contract for the payment of 3.6 million euros that Mr. Rand paid to Sembi, nor a contract for the payment of 2 million euros from Mr. Rand's company Indonesian Developments to Sembi. There is no contract proving that Sembi assumed 4.8 million euros from institutions in Geneva. And there is no contract for waiving 8.2 million euros by Lundins. So in total, as you can see, there are 12 companies and individuals from several different countries that exchange millions of euros without a written contract. And what was the role of each of these men and companies? Who was the investor? Who was the beneficial owner? Who owed money to whom? Remains unclear. And why it remains unclear? Well, simply because claimants are hiding the documents that most certainly exist between these gentlemen and their companies. And I think that the consequences of this lack of documents is tribunal's inability to determine what was the actual arrangement between Mr. Rand, Mr. Obradović, and the Lundins. And before I finish this part of my presentation, let me say something that concerns payments made to Mr. Obradovic in 2006 and 2007 that I did not mention earlier. In para 14 of Mr. Azrak's witness statement, you will see that Mr. Adolf Lundin passed away in September 2006. And this is not mistake, it can be easily checked on Wikipedia. And you will also see from Exhibit C 405 and CE 406 that Mr. Adolf Lundin has made total of €1 million payments to Mr. Obradovic in December 2006 and April 2007, months after his death. So beside the fact that we have €1 million worth payments involving at least 12 different companies and individuals, unsupported with any underlying documentation, besides payments of dividends represented as investments in BD Agro, and payments made to MDH treated as payments to BD Agro with no supporting documents. And in addition to that, we have multi-million debts forgiven without any written trace, it appears that we also have payments ordered by a dead person. So if that does not ring the bell, then I really don't know what does. What I'm going to briefly reflect upon now is how Mr. Obradovic managed, or better to say, mismanaged BD Agro. So Mr. Obradovic was heading BD Agro for approximately 10 years, and in those 10 years, a number of suspicious activities occurred in BD Agro, and as explained in respondents' rejoinder, various criminal complaints have been submitted and many criminal proceedings have been initiated. A lot of money went in and out of BD Agro as well, but to be specific, a lot more money went out of BD Agro than it went in. To start with, Mr. Obradovic gave a significant amount of shareholder loans to BD Agro. And this in turn enabled him to make a significant amount of payments from BD Agro's accounts to himself. And he abused this relationship substantially and repeatedly. And that is explained in respondent's rejoinder in section 1F, 2, and 4. So what Mr. Obradovic wants the tribunal to believe now is that he had no record of payments and repayments of the multi-million shareholder loans. He was also allegedly unable to obtain his own bank accounts statements to prove these payments. We, of course, saw no contract for these multi-million shareholder loans. And Mr. Rand, who apparently provided all the money paid by Mr. Obradovic as shareholder loans, also submitted no record in that regard. And this in itself says a lot, and I would say that it's sufficient to raise serious suspicions of Mr. Obradovic and claimant's unlawful behavior. Having that in mind, the only thing that respondent could have examined are the bank accounts statements of BD Agro. These bank accounts indisputably prove that the groundless outflow of the funds from BD Agro to Mr. Obradovic was at least €500,000. And that much is confirmed by claimant's financial expert, Dr. Hearn, in his third report in para 127. And I say at least $500,000, since Dr. Hearn's results have been substantially manipulated and reduced by claimant's instructions. Specifically, claimants provided detailed instructions to their experts on how to analyze the transactions, telling him what he should consider as loans and what he should not consider as loans, what keywords she should use, what accounts should he look at, how should he interpret transaction codes, and so on. You can see that from Dr. Kern's third report in paras 123 to 126. But the story does not end there. The actual amount of the extracted money from BD Agro was even higher when one includes loan activities not conducted through bank accounts. Specifically, there is one known shareholder loan repayment that was made in form of assignment of land instead of a bank account repayment. And this occurred in the period 2006-2007. What happened is that Mr. Obradović thought that instead of BD Agro repaying him some 400,000 euros, it can assign to him the land which Mr. Obradović resold just 4 months after for over 1.4 million euros. And then again, it only took 3 additional months for the new buyer to resell the same land for 3.3 million euros. And you can see that from RE 145, 426, and 488. And what claimants do, they ask the tribunal to believe that Mr. Obradović had no clue that the land in question was much more valuable than the nominal set price, although he managed to resell it for 3 times more money in the matter of months. Faced with an obvious case of asset extraction, claimants had to come up with some way to magically turn a minus into a plus. So they said, let's look a broader picture. Let's include things that have nothing to do with the shareholder loans. Let's look at BD Agro's transactions with the associated companies of Mr. Obradović. And of course, let's look at Mr. Rand's receivables against BD Agro. This is, of course, completely misplaced approach because the question was whether BD Agro returned to Mr. Obradović more shareholder loans than it received from him. And even Dr. Hensbeck transaction analysis shows that it did. And what happened between BD Agro and associated companies of Mr. Obradović and Mr. Rand simply cannot repair that result. These companies could not give shareholder loans to BD Agro nor collect their repayment instead of Mr. Obradović. In any event, even if these transactions are taken into account, they will not help claimants to prove that Mr. Obradović did not mismanage BD Agro. So, as you can see, even from Dr. Herr's calculation, associated companies to Mr. Obradović owe to BD Agro 5 million dinars. This analysis is, however, incomplete, as Dr. Herr was instructed to consider only some selected transactions between these companies and BD Agro. In any event, the analysis of Dr. Herr is also redundant. Why? Because we have undisputed analytic cards of BD Agro in the files that show that associated companies still owe to BD Agro almost 800,000 euros plus interest. So INEX did not save BD Agro as claimants say. INEX owes money to BD Agro, among other companies of Mr. Obradović. To cut the long story short, these are the numbers that cannot be disputed. First, Dr. Hearn had confirmed that the bank accounts of BD Agro show that it repaid 88 million dinars of shareholder loans more than it received. And although the exchange rate substantially changed over the years, I think that it safely can be said that this amounts to close to 1 million euros. Second, the land that was assigned to Mr. Obradović in order to set his 400,000 euro claim was resold by Mr. Obradović within 4 months for 1,400,000 euros, and then again resold for 3.3 million euros. And third, the associated companies of Mr. Obradović still remain indebted towards BD Agro for around 800,000 euros plus interest. And let me just say that this debt will never be collected, as all of these companies have been financially destroyed by Mr. Obradović. So BD Agro would never collect that debt. Therefore, even with all of their instructions and stories, claimants were obviously unable to fill out the gap created by Mr. Obradović's mismanagement. They are unable to prove that the money was not siphoned from the BD Agro, and that is obvious as it can be. And claimants' alleged investment is thus entirely tainted by fraud and conduct, and as such does not deserve any protection under the treaty. I will now turn to the question of the termination of the privatization agreement. On the files, we have plenty of documents concerning this topic dating from before the initiation of this arbitration, and I would like to ask you that we focus on them instead on subsequent witness statements, expert reports, and legal interpretations provided by the parties in this arbitration. And before I go into details, let me just briefly remind you about the essential facts behind the termination of the privatization agreement. What happened in December 2010 is that BD Agro indebted itself with Agrobanka loan of 221 million dinars, and at the same time pledged its real estate as security for this debt. And very important, in the files, we have evidence that this pledge was still in place as of 13 March 2019. At the same time, the large part of that money was used for the benefit of other two companies, and that are Inex and Crveni Signal, which are, according to claimants, also owned by Mr. Rand. As exhibits RE1 and RE190 show, they never repaid these loans to BD Agro. And the third very important fact, already at the beginning of 2011, the agency determined that this represented a breach of the privatization agreement. And then the agency sent a notice to Mr. Obradović and requested the pledges to be deleted, or Inex and Crveni Signal to return the money to BD Agro. Or the agency said it will terminate the privatization agreement. And the agency kept saying the same in the next 4 years. Agency always communicated the same to Mr. Obradović. So what should have been done in order to avoid termination? If we adopt claimant's narrative of beneficial ownership, Mr. Rand's companies should have simply returned the money to his allegedly owned third company, BD Agro. In other words, Mr. Rand took some money from BD Agro and gave that money to his other companies. And the agency requested that he returns this money. So Mr. Rand did not need to give that money out to the privatization agency, but just to move this money from his right hand to his left hand. But he refused to do so, and that is why the termination happened. I will now deal in more detail with the questions of, first, whether the parties consider the above explained situation to be a breach of Article 534 of the Privatization Agreement that could lead to termination of the Privatization Agreement, and second, whether Mr. Obradović had any reason to believe that termination will not happen even if he does not remedy the breach. In the case files, we have different opinions of legal experts concerning the question whether breach occurred or not, and whether the agency had the right to terminate the agreement or not. But what I think is very important is how the parties to the privatization agreement understood Article 534 at the time before termination. So let us start with the agency. I think that the most useful document, and I think that my colleagues agree, is transcript from the meeting of the Commission of the Center of Control of the Privatization Agency held on 23rd April 2015. That is CE 768. In that document, you can find what was agency's legal point of view and what was its motivation. And this document reveals that members of the Commission discussed various issues concerning termination of the privatization agreement. And claimants argue, and they did it even today, that this discussion benefits their case. And I respectively disagree. I would rather say that the lack of discussion could be considered as bad faith when deciding of such important issues as termination of multi-million privatization agreement. Had there been any bad faith, as claimants contend, the Commission would have nothing to discuss. It would not take into account different opinions and options. It would not take into account different interpretation of statutory and contractual provisions. However, the Commission did just the opposite and had a detailed discussion of various factual and legal issues relevant in this regard. In any event, whether the legal opinion and point of view of the agency and its commission in particular was correct or not, could have, and I would say should have been addressed before the Serbian courts. In this proceeding, however, I would say that it is crucial to determine whether such understanding of Article 534 and the consequences of its breach were arbitrary and whether they were invented in the case of BD Agro or not. And the answer is more than evident from the case files. Absolutely not. In the files, we have a number of exhibits showing that the agency acted exactly the same in other cases. It has either requested the breach of Article 534 to be remedied under the threat of termination, or it indeed terminated other privatization agreements when this breach was not remedied. And you will find this evidence under the exhibits number RE 97, 363, 364, 369, 5, 4. And in fact, which is also important, some of these examples of agency's practice concern previous breaches of that same provision in the case of BD Agro. While there are also examples of other privatizations where Mr. Obradović participated as the buyer. In all of the cases, Mr. Obradović acted as requested by the agency and remedied the breach of Article 534. And this, of course, confirms that when it comes to the breach of Article 534, Mr. Obradović had the same understanding as the agency. He very well knew what he had to do, and he did it, although after some delay. Not so, however, in our case. In our case, there are also letters of Mr. Obradović and BD Agro that confirmed understanding that giving out the loans to Inex and Crveni Signal from 221 million loan constituted a breach of the privatization agreement. And during the whole period from 2011 to 2015, Mr. Obradović communicated to the agency about financial conditions of Inex and Crveni Signal. And Mr. Obradović even requested additional periods during which the breach could be remedied. Mr. Obradović did not refuse to comply with the agency's request when it comes to the breach of Article 534, as he did with respect to, for example, the breach of Article 533. And in one of those letters sent by Mr. Obradović in July 2015, just before termination occurred, Mr. Obradović explicitly noted that the auditors determined that, I quote, the buyer fulfilled all contractual obligation except in relation to lending to third parties, Inex and Crveni Signal. And that was stated in July 2015. What is also important is that all these letters, Mr. Obradović, came after the purchase price was already paid, meaning that Mr. Obradović knew that the full payment of the price did not release him from the obligation to remedy the breach of the privatization agreement that had occurred before the price was paid. That is very important. And this, of course, again, was in line with the practice of the agency in other privatizations. So what the agency did, it just kept with its practice. As you will also notice from Mr. Obradović and BD Agro's letters exchanged with the agency, they never questioned whether the breach of Article 534 represented a ground for termination of the agreement, although this particular breach was not explicitly listed in the agreement as a reason for termination. It was undisputed that the reason for termination was in Article 41 of the law on privatization, which applied regardless of and together with the reasons listed in the agreement. And of course, this stance cannot be even questioned, because both the Supreme Court as well as the Constitutional Court of Serbia confirmed that it is indeed the correct stance. Needless to say, the agency again followed this practice in many other privatizations. And when it comes to the question of whether Mr. Obradović had any reason to believe that termination would not happen if he did not remedy the breach, The answer is clear. Not. As you can see from the 7 letters of the agency that was sent during the 4-year period, the agency always communicated the same to Mr. Obradović, that the agreement will be terminated under the Article 41A of the law on privatization if the buyer fails to remedy the breach of Article 534. And this was repeated in 7 letters of the agency. And it is interesting how claimants now insist that the breach of Article 534 was minor and non-essential. Claimants try to downplay the breach by taking the amount for which the pledge was established over BD Agro's land and comparing it to the inflated value of BD Agro's assets. However, such comparison is completely inopposite. The money that Inex and Crveni Signal took from BD Agro first amounted to around 100 million dinars, which was almost 1 million euros at the time. The debt was later slightly reduced and remains today at 70 million dinars. So therefore, the debt is worth more than 1 installment of the purchase price for BD Agro. And claimants do not dispute the fact that the privatization agency could have terminated privatization agreement due to not payment of only 1 installment, which was less than this debt of Inex and Crveni Signal. Therefore, it is contradictory to say that the breach of Article 534 was insignificant. So the main question here is why Mr. Obradović did not remedy the breach. Why Mr. Rand, who claims to be the owner of BD Agro, Inex, and Crveni Signal, did not return to BD Agro what he previously borrowed to his other companies and kept the privatization agreement in place. Instead of remedying the breach, claimants and Mr. Obradović repeatedly mislead both the agency but this tribunal as well that the loan was repaid to Agrobanka and that the pledge was deleted. As you can see from documentary evidence, as opposed to claimant's story, neither was the loan repaid, nor was the pledge deleted, nor did Inex and Crveni Signal repaid the money they borrowed to BD Agro. And this all was in detail explained in our rejoinder in paras 126 to 132. I will conclude this part of the opening statement by repeating the obvious. First, Mr. Obradović knew that spending the part of 221 million loan for benefit of his other companies represented the breach of the privatization agreement. He corrected the same breach in the past, in BD Agro privatization, but also in other privatizations. Second, Mr. Obradović knew that the privatization agreement will be terminated if he did not remedy that breach. The agency always, and I repeat, always communicated that to Mr. Obradović. Remedy the breach or the privatization agreement will be terminated. But Mr. Obradović did not remedy the breach. Over 4 years, the agency gave him 4 years to remedy the breach. And still, he did not. So I would say that only possible, but also expected outcome was termination of the privatization agreement. It seems that I'm out of time, so I will only say a few words about deletion of pledge and assignment of the privatization agreement to Coropi, and my colleagues will later also address these issues. So first, I would like to remind the tribunal that retaining the pledge on the shares after the full payment of the purchase price was as well fully in line with agency's practice in other privatization. So agency again followed its practice. Second, when it comes to the request for assignment to Coropi that was made on 1st August 2013, it should be recalled that up until the termination of the privatization agreement, this request was never complete. And we explained that in our rejoinder in section 1E5, that agency simply never received all the required documentation, meaning that this request could not have been even approved at any point. And with this, I conclude my part of the respondent's opening presentation, and Professor Đundić will take over, but maybe it is the right time for the break.
Yes, are we about in the middle of your presentation in terms of time? Not completely.
Well, not in the middle, but...
So maybe we carry on a little bit, because it's better to have a shorter second part than a shorter first
Okay.
part.
Okay.
No problem.
Fine.
Members of the tribunal, Madam President, my esteemed colleagues opposite, just one issue, which is housekeeping issue, or rather time.
Excuse me, can we just move the screen
Yes.
there, because I don't see you, and I like seeing people who speak to me.
As I was saying, an issue which is rather a timekeeping issue. I was wondering if I could know how much time exactly do we have left?
Yeah, the
for
secretary
responding.
can tell you that.
Yes, you have 1 hour and 46 minutes left.
Thank you. Thank you. I apologize. As Mrs. Mihaj already said, my name is Petar Đundić, and I will give an opening statement on behalf of respondent on certain issues of jurisdiction. The facts presented here by Mrs. Mihaj prompted many questions of jurisdictional character, and I would say unsurprisingly. There is, of course, no need to take the tribunal through every aspect of jurisdictional objections submitted by respondent, and certainly not enough time to do so. Instead, today I will focus on issues of jurisdiction ratione materiae, ratione personae, ratione voluntatis, and ratione temporis under the treaties. I will conclude my presentation, if the time allows me, by briefly explaining why the claims represent an abuse of the ICSID mechanism. Starting with the jurisdiction ratione materiae. Now, the main issue and the most important question here is, what does it mean to own a share, stock, or other form of equity participation in an enterprise under the Canada-Serbia BIT, or shares, bonds, and other form of securities under the Cyprus-Serbia BIT. So who was the owner of stock in BD Agro at the time of the alleged breach? Claimants obviously believe that this question should be answered with reference to international law. Respondent disagrees. We believe that it is Serbian law that must answer the question of who acquired ownership in shares in a Serbian joint stock company. Now, our written submission contained detailed explanation on why the share purchase agreement, or MDH agreement as claimants call it, and the SAMBI agreement could not result in ownership of Mr. Obradovic shares being transferred to any of the claimants. In sum, the ownership of shares in a joint stock company was and still is acquired through the registration in the Central Securities Registry. I think it is important to note that the registration has never been only a way to obtain publicity, but a mode of acquisition of shares as well. Now, the law on companies relevant at the time gave a list of rights belonging to shareholders, and it also specified that it was prohibited, save from certain exceptions, to transfer those rights by way of concluding contracts. In turn, the 2002 and 2006 securities law envisaged that the right that belonged to shareholders are transferred by registration of a new owner in the Central Security Registry. There were also several restrictions, some made or some contained in the Privatization Agreement and some of statutory character, that prevented claimants from concluding contracts such as the MDH and the SAMBI agreement. Now, claimants' response to this has remained the same throughout the whole arbitration, and it is that Serbian law bears no relevance. Since their right is protected and stems from international law, the right of beneficial ownership, and forms the notion of beneficial ownership, no restriction of Serbian law applies to them. Now, members of the tribunal, this is the way in which claimants created a perfect land for themselves. A land where anything goes, as long as they invoke beneficial ownership in shares and opt for the application of British Columbia or Cyprus law for their contracts with Mr. Obradovic. No rule of Serbian law can touch them. From that point on, it is indeed a smooth sailing for claimants. But the fact is that no such land exists. For example, claimants, they assert that Serbian law allows for the beneficial ownership of shares in joint stock companies, but at the same time leave the matter of its acquisition and transfer entirely unregulated. This is, of course, impossible. No national legal system could exist in such a way. Claimants, to put it simply, offer the tribunal an interpretation of treaties by which any regulation and restriction imposed by a contracting party when it comes to the acquisition of equity in companies are effectively irrelevant. This is plainly wrong. Article 1 of the Cyprus-Serbia BIT speaks about assets invested in the territory of a contracting party in accordance with its rules and regulations. Article 18, paragraph 2.a of the Canada-Serbia BIT, for example, declares that the BIT does not prevent parties from adopting or maintaining prudential measures for protection of financial market participants. Now, those provisions would be meaningless if any restriction or prohibition could be somehow circumvented by invocation of beneficial ownership in securities. That is the first problem with the claimant's case and jurisdiction. The other major problem relates to the fact that respective contracts were actually unable to create beneficial ownership of claimants in Mr. Obradovic shares. This applies to the MDH agreement, which was long gone at the time that could be relevant for the jurisdictional inquiry, but far more importantly to the Serbia agreement. The most significant problem with the Serbia agreement is the fact that it is in clear contradiction with the imperative rule of Serbian law on privatization. And this is, as you know, Article 41Ž, contained in Claimant's Exhibit 220. Under the relevant provision, the assignment of the privatization agreement or agreement on sale of the capital was possible only with prior authorization of the agency. There is no dispute that no such authorization was ever issued or even requested when it comes to the SEMBI agreement in February 2008. Claimants, of course, once again argue that this prohibition affects only the transfer of nominal title in the agreement and not the beneficial ownership in BD Agro's shares. This was done in reply in paragraph 118. Claimants also asked the tribunal to simply disregard the prohibition from Article 41J. Claimants entirely ignore the purpose of the provision and the fact that such interpretation would leave it without any effect whatsoever. Article 41J does not allow for partial assignment. It does not allow for beneficial assignment. It prohibits all unauthorized assignments of privatization agreements, period. Now, the claimant's silver bullet for all of their problems is, of course, Article 9 of the SEMBI agreement, and that is designation of the law of Cyprus as applicable. But the fact that Mr. Obradovic and SEMBI agreed on application of the Cyprus law to their contract does not change anything. Otherwise, two private parties, and I emphasize this, two private individuals, or a company and private individual, could always find a way around any prohibition in the host state law by simply agreeing to the application of whichever law suits them the best. As we have heard many times during this arbitration, during these proceedings, the Cypriot law allows for the assignment in equity even when the original contract prohibits assignment. Now, this could be relevant only and only if the law of Cyprus would be applicable to the issue of assignability. The problem again is that even under the Cypriot choice of law rules, the law applicable to the assignability of the agreement is Serbian law. What is more, the rule about possible equitable assignment under Cyprus law comes with an important exception. This is that no assignment under equity is possible if the identity of the assigner was or is of importance to the creditor. We believe that it is undisputed, to the debtor. We believe that it is undisputed that the debtor from the privatization agreement, that is the agency, could have concluded the agreement only with the winner of the public auction back in 2005. This, coupled with the fact that unauthorized assignment was explicitly prohibited by the law on privatization, surely demonstrates that the identity of the other contracting party was of crucial importance to the agency. Even if we would disregard completely the mandatory rule of Serbian law, and even if we would accept that the transfer of beneficial ownership in BD Agro was possible separately from the nominal position of a contracting party, there is one issue that still remains. The wording of the SEMBI agreement does not support the claimant's interpretation. You have now Article 4 of SEMBI agreement on the slide. According to claimants, this tiny article, this short article, Article 4 of the SEMBI agreement, essentially contains at least two agreements. One by which Mr. Obradovic agrees to transfer his beneficial ownership in BD Agro to SEMBI immediately after the conclusion of the contract, and the other that merely contemplates a future possible assignment, and that would be the second sentence of Article 4. The problem is that the Serbia agreement does not say one word about separate transfer of beneficial ownership in BD Agro. There is no designation of Mr. Obradović as a trustee. There is no his obligation to follow SEMBI instruction in operating BD Agro's business or to continue holding shares in SEMBI's interest. Members of the tribunal, there is one more issue that warrants the tribunal's attention. The agency was completely unaware of the SEMBI agreement. There are tens of thousands of pages of documents created during the relationship between the agency and Mr. Obradović concerning BD Agro. But not one mention of the SEMBI agreement. So, the agency concludes a contract, Serbian Privatization Agency, concludes a contract with a Serbian citizen. It communicates with him for 10 years. It warns him to live up to his contractual obligations. It negotiates possible assignment with a potential Canadian investor. Finally, terminates the contract with notice directed at Mr. Obradović, only to subsequently find out that the potential Canadian investor was the true owner of BD Agro from the onset. Now, all of this effectively boils down to the agency being in contractual relationship with claimants without ever being aware of that. Article 2 of the Canada-Serbia BIT applies to measures adopted by a party relating to an investor of the other party and the covered investment. Respondent's position, our argument, is that there is no legally significant connection between the termination of the privatization agreement and claimants as deemed necessary by the Metanex Tribunal. An agreement, the SEMBI agreement, which was obviously created in breach of imperative rule of Serbian law, certainly cannot create a legally significant connection. Now, under Article 2 of the BIT, it is not enough that the termination of the contract with Mr. Obradović simply affects claimants' rights under the SEMBI agreement. In its essence, and when it's stripped of all semantics and sophism, the claimant's argument is that the SEMBI suffered loss due to the agency unlawful termination of the privatization agreement. This is basically the claim. SEMBI's shareholders suffer loss as a result of SEMBI's loss. And hypothetically speaking, even creditors of SEMBI's shareholders also suffered loss due to the loss inflicted on shareholders. This does not mean that the termination of the privatization agreements relates to them all. As a matter of common sense, a state cannot be held responsible for all possible consequences of its acts. This was precisely the reasoning of the Metanex Tribunal in interpreting the NAFTA provision corresponding to Article 2 of the BIT. Possible consequences of human conduct are infinite, but the law sets the limits on responsibility. Now, the Metanex Tribunal uses an example of situation in which, in traditional legal context, a legally significant connection is missing. A contract breaker is not generally liable for all consequences of its breach, even towards the innocent party, still less to person not privy to the contract. Members of the tribunal, this is the example that perfectly captures the essence of the dispute at hand. Now, According to the claimants, the agency has always known that claimants were the true owners of BD Agro. Looking at the documents on the record, however, the story simply does not add up. This is perfectly clear from the entire affair about the failed attempt to assign the agreement to Coropi in 2013. Now, the sequence of the events is as following. In 2008, Mr. Obradović supposedly assigns all his right, title, and interest in and of the privatization agreement. He never notifies the agency about the assignment and continues to communicate with the agency for several years. In 2013, as BD Agro reaches the brink of financial collapse, a potential Canadian investor makes an initial contact with the agency, offering through his attorney to invest in BD Agro and to take over the privatization agreement. This is email from Mr. Jakovljević to the agency, and this email was also shown before by my colleague, Mrs. Mihaj. In November 2014, Mr. Markicević, acting as a general director of BD Agro, sends a letter to the agency, again referring to Mr. Rand as an investor who expressed serious interest in taking over the majority shareholding in BD Agro and supporting the consolidation of the company. Finally, in September 2015, Mr. Obradović sends a letter to the agency again mentioning the reputable Canadian investor willing to financially support BD Agro, of course, once the assignment of the agreement was allowed. So, according to claimants, they were negotiating potential assignment with the agency, putting pressure on the agency to authorize it, while at the same time both parties were aware that the assignment already happened and that the claimants are the true owners of BD Agro Capital. The argument does not fly, especially in the light of evidence presented here. With regards to the issue of control under the Canada-Serbia BIT, we submit that the alleged control of Mr. Rand over Mr. Obradović's shares or over BD Agro is ultimately always a question of law. There must be a legal ground establishing control. There must be a valid contract that can establish control under the relevant rules of corporate law. Otherwise, if the notion of control would be interpreted as suggested by claimants as de facto or informal control, there is no way to objectively establish which person or entity controlled the decision-making process of Mr. Obradović. For example, it is perfectly conceivable that the ultimate de facto owner or controller of BD Agro was not Mr. Rand but some member of the Lundin family. And I believe that it is self-evident that the Serbia-Canada BIT is not meant to protect Swiss or Swedish investors in Serbia. In any event, members of the tribunal, whatever the true meaning of control should be, the treaty cannot be interpreted in a way to protect control over an enterprise acquired in breach of respondent laws. And here I remind you of Professor Radović's conclusion in her second report, paragraphs 90 to 92 and paragraph 97, that voting agreements concluded between Mr. Rand's companies and Mr. Obradović during Mr. Rand's tenure as a member of BD Agro's board of directors are null and void ex lege. Nevertheless, should the tribunal decide that the unqualified de facto control is all that is required under Article 1 of the Canada-Serbia BIT, there is another important point here. That is that finding of de facto control needs to satisfy an evidentiary threshold which is exceptionally high. In the words of the Thunderbird Tribunal, it must be established beyond any reasonable doubt. Now, this is indeed high threshold. As Mrs. Mihaj already explained, if we exclude testimonies of Mr. Obradović and Mr. Rand, there is no single evidence, no piece of paper, no email that would contain any instruction of Mr. Rand directed to Mr. Obradović concerning the business of BD Agro. This is very peculiar, bearing in mind the statement made by two gentlemen, that Mr. Obradović always followed every instruction of Mr. Rand. Were all those instructions verbal for a period of 10 years? This is highly unlikely. Another troubling issue here is the flow of money from BD Agro to Mr. Obradović. To control an investment means, among other things, to receive the economic return of the investment. So what happened with those returns in case of BD Agro? A large amount of money was transferred from BD Agro's accounts to Mr. Obradović directly. Has any of that money ever reached Mr. Rand? Has Sembi ever received any dividends from BD Agro? There is no evidence on the record for that. What is certain is that some money from BD Agro was transferred to other companies that were bought in privatization by Mr. Obradović. Now, claimants, of course, allege again that those companies, and those are Crveni Signal, Pik Pešter, Inex, and Obnova, also belong to Mr. Rand. Now, the fact is, however, that shares bought by Mr. Obradović in this process were transferred to a Cypriot limited liability company called Kalemegdan Investments Ltd. And Kalemegdan Investments, as you see in turn, is owned by Mr. Obradović and Mr. Obradović alone. Let me now turn to the ratione voluntatis objection. Respondent's ratione voluntatis objection.
Sorry for interrupting you, but would this be a good place to have the break?
It is fine with me.
Yes, good.
Thank you.
Fine, let's take 15 minutes then and resume then. ready, I think, to resume. Before, Mr. Hundish, you start, we were thinking about how to make sure who attends in the other room. And maybe the easiest way is that we rely on the parties, that you check who's there on both sides. And then we simply rely on you, because right now we see the room, but of course tomorrow if we have a remote witness, we will use that screen. And so, and it may also be a little distracting. I don't know whether you like it or not. But the only people who cannot be there are really fact witnesses who are not parties and who have not yet testified. Can we leave it like this, and we rely on counsel to make sure there's no one there who's not authorized?
Yes, Madam President.
We also agree.
Good, fine. Then we can continue with the respondent's opening argument. Professor Tundic, you have the floor.
Thank you, Madam President. Respondent's ratione voluntatis objection concerns two main issues. The first one is the issue of illegality of claimant's investment. The second one is dealing with the lack of jurisdiction for the claim with regard loss allegedly suffered by MDH Serbia. In terms of illegality of claimant's investment, if claimant's assertions are taken as true, acquisition of BD Agro's capital, specifically by way of the Serbia agreement, was done in breach of the 2006 securities law, 2001 law on privatization, and the 2006 takeover law. All of the provisions of Serbian law were mandatory in their nature. Now, the essence of respondent argument is simple. Should the tribunal find that claimants acquired property rights based on British Columbia or Cyprus law, those rights would be obtained in breach of mandatory provisions of Serbian law. There is, of course, no room for choice of law analysis here. The only relevant law is the host state law. In addition to that, in our submissions, we have already explained how fraudulent behavior of Mr. Obradović allowed claimants to obtain BD Agro and to squeeze out its capital, to the detriment of minority shareholders and the company itself. One example of such behavior was misrepresentation at the public auction that led to the conclusion of the privatization agreement. Claimants misrepresented the true role of Mr. Obradović during the acquisition of BD Agro. Again, if what claimants argue is true, that Mr. Rand entered the bidding process through Mr. Obradović, this is the way in which he obtained undue advantage over other participants at the auction, and we have heard today that there were 3 other participants at the auction. Only Serbian natural persons were at the time allowed to pay the purchase price for capital in installments. This incentive was not offered even to Serbian legal persons, and this is evident from the 2009 Decree on Sale of Capital by Public Auction, Article 31, Respondent Exhibit 217, and 2005 Decree, Article 39, Respondent's Exhibit 218. Claimants argue that Mr. Rand was under no obligation to reveal his role to the agency before the auction, since the agency did not require this. This cannot stand. Naturally, the agency did not ask Mr. Obradović to reveal his beneficial owner, since natural persons cannot have beneficial owners. I believe that claimants are in agreement with this statement as well. What the agency did ask from every participant in the auction was to submit a proper authorization in case a participant was to attend the auction as a representative of another person. Mr. Obradović, of course, confirmed that he was acting in his own name. Let me remind you here that Mr. Dean, claimant's legal expert on the British Columbia law, stated that the effect of MDH agreement was to create a principal-agent relationship between MDH and Mr. Obradović. This is DIN report paragraph 101. So if Mr. Obradović really acted on behalf of Mr. Rand during the auction, this was a fraud. Now claimants assert that the illegality objection was made belatedly and imply that it was made in bad faith. Respondent respectfully submits that the tribunal should take this objection into account. 3 points are important here. First, the illegality objection was not belated. It was presented in the respondent's counter memorial in accordance with Article 41(1) of ICSID arbitration rules. It was further developed in the respondent's rejoinder. Most importantly, respondent's arguments from the rejoinder were all based on the issues and facts that had been discussed previously by the parties themselves. This is, for example, the case with the issue of the alleged disclosure of Mr. Rand's beneficial ownership to the agency, discussed in memorial paragraph 304 and counter memorial paragraphs 252 to 275, or with the fraudulent behavior of Mr. Obradović in repayment of the shareholder loans. This was discussed in counter memorial paragraphs 183, 184, and reply paragraphs 144 to 153. Second, even if the legality objection was to be deemed belated, or even had it never been made, the tribunal would still have an authority to examine on its own motion any issue affecting the jurisdiction of ICSID or its own competence. If there is ever reason to do so, it is when there is a claim that the investment was obtained through fraudulent behavior. This is the issue of international public policy. And since the legality requirement impacts the tribunal's jurisdiction, the tribunal should consider to have a duty to assess the issue ex officio, independently from the assessment of facts or even legal qualification of those facts offered by the parties. The final point with regards to admissibility of the respondent's illegality objection. The tribunal should consider the fact that claimants did have an opportunity to respond to all of the arguments contained in respondent's rejoinder. Now, in terms of timing of the legalities assessment, respondent accepts that the jurisdictional inquiry into legality of the investment should cover the time of making the investment. What it does not accept is claimant's argument that the acquisition of BD Agro was a one-time deal that was finalized on the day the privatization agreement was concluded. Under the agreement, acquisition of the entire bundle of property rights for the buyer was conditioned upon payment of the purchase price in full. And this is evident for Article 2.1, which you can also see on the slide. In other words, ownership of BD Agro's capital was not fully acquired until the payment of the purchase price in full. This is why the illegality analysis in terms of jurisdiction must include the entire time period up until 8th of April 2011. As for the second part of the ratione voluntatis objection, claimants in this arbitration, and in particular Mr. Rand, should not be allowed to claim damages for harm allegedly suffered by MDH Serbia under Article 21(1) of the Canada-Serbia BIT. This provision allows an investor to claim damages for loss or damage incurred by the investor directly. In this case, MDH Serbia is a Serbian limited liability company seated in Belgrade, owned by Mr. Rand. In turn, MDH Serbia itself owned 3.9% of shares in BD Agro that were allegedly expropriated by respondent. It follows that the damage supposedly inflicted by respondent was incurred by MDH Serbia, while damage suffered by Mr. Rand was of reflective nature, a decrease of value of his shareholding in a local company. In such a case, the investor must follow the avenue established by the BIT, a claim on behalf of the local enterprise in accordance with paragraph 2 of Article 21. Now, the very same position was adopted by the NAFTA Tribunal in Bilcon versus Canada in January 2019. Of course, NAFTA contains two provisions with the exact same wording as paragraphs 1 and 2 of Article 21 of the BIT. The persuasive reasoning and eloquent reasoning, I would say, of the Bilcon Tribunal was already reproduced in the respondent's rejoinder. I will not repeat it here. I have only two short points. First, the Tribunal should consider the fact that the Bilcon Tribunal finally endorsed the interpretation that has been consistently argued by the Government of Canada for decades in the NAFTA context. And that is that the investor cannot sue in its own name for loss suffered by his enterprise. So the practice of the other state party of the BIT, which is Government of Canada, of course, concerning this particular issue is completely in accordance with the interpretation offered here by the Republic of Serbia. The second point is that the issue is not merely of academic importance. If damages owed to the local enterprise are paid to the shareholder and not to the enterprise itself, creditors of the enterprise could not satisfy their claims against the amount of damages. In this case, MDH Serbia owes almost 9 million Serbian dinars to BD Agro alone, as you can see, not counting any other potential creditors of MDH Serbia. In terms of ratione persone objection, respondent submits that Sembi cannot be deemed as investor under Article 1.3b of the Cyprus-Serbia BIT. Evidently, in order to qualify as an investor of a contracting party, a legal entity needs to be both incorporated according to the laws and regulations of the party and to have its seat in the territory of the same party. Now, claimants argue that the term seat should be interpreted by reference to the law of Cyprus and that under such law, seat means registered office, but they are wrong on both accounts. The notion of seat must be given an ordinary meaning under international law and in the light of object and purpose of the BIT. There are several important points here, but I will try to concentrate in interest of time on only one of those points. Interpretation of the BIT in this regard is governed exclusively by international law. Reference to municipal law is possible only when permitted by the BIT. This is the case when a treaty contains an express renvoi to municipal law of a party. Article 1.3b contains, indeed, renvoi to municipal law of contracting party, but only with regards the criterion of incorporation. There is no reference to municipal law when it comes to the second criterion, the criterion of seat. The only argument that claimants offer is that the term seat must be interpreted according to law of Cyprus because, according to them, there is no established uniform definition of seat in international law. But the lack of uniform definition in international law is, of course, no reason for the tribunal to abstain from its duty to interpret the treaty. Now, Sembi does not have a seat in Cyprus because Cyprus is not the place of its effective management. Claimants argue that Sembi meets the Tenaris test for holding companies, but the fact is that Sembi is much more than a holding company. According to its articles of association, and this is Claimants Exhibit 866, Sembi is registered for more than 40 other activities, unlike in Tenaris, where the company was prohibited by its articles of association in engaging in any other commercial or industrial activity. Sembi does not engage in any of those 40 or more activities in Cyprus. A testament to its inactivity is the fact that it has even failed to submit mandatory annual returns under the Cypriot loan companies since 2011. Second, the place of annual shareholders' meetings was considered an important criterion for determining the place of effective management in Tenaris. There is no evidence that shareholders' meetings of SAMBI was ever held in Cyprus, not even once. SAMBI does not own or rent any property in Cyprus. Accounting and other technical services are provided to SAMBI by HLB, a company providing similar services to other clients as well. SAMBI does not have any employees in Cyprus. 2 out of 4 SAMBI's directors were simply provided again by HLB. Critically, there is no dispute that the heart and soul of SAMBI has always been Mr. Rand. Virtually all business decisions of SAMBI, according to claimants, were made by its ultimate owner who resides in Canada. There is no evidence that Mr. Rand ever attended any board of directors or shareholders meeting in person, or even that he has ever set foot in SAMBI's office in Cyprus. This is quite different from circumstances in Tenaris, where Venezuela was unable, I quote, to point to any consistent act of management of Tenaris itself, unquote, taking place out of Luxembourg. All of acts of management of SAMBI are taken outside Cyprus. As a result, SAMBI has no seat in Cyprus, and it is not an investor under the BIT. With regard ratione temporis objection, as for temporal jurisdiction of the tribunal, respondents maintains that the tribunal lacks jurisdiction ratione temporis under the Canada-Serbia BIT for reasons explained in previous submission. At this point, I would like to address specifically the issue of the alleged failure to delete the pledge on Mr. Obradovic's shares in BD Agro. This is quite obviously a claim which falls out of the tribunal's jurisdiction ratione temporis. Of course, respondent does not dispute that a breach of an international obligation can have a continuous character under the Articles of State Responsibility. The problem here is that the retention of pledge was not a continuous breach of an international obligation for 2 main reasons. First, it was not a breach of an international obligation. Refusal to delete pledge is a typical contractual breach. The breach of a contract by a state is not alone and of itself a breach of international law. This is not, as claimants would have it, an issue of attribution. Whether or not the breach of a contract can be attributed to a state has nothing to do with the question of whether the obligation is an international obligation. This is the issue that comes under the scope of Article 3 of the Articles of State Responsibility. And the commentary of Article 3 is clear. An act of a state cannot be characterized an international wrongful unless it constitutes a breach of an international obligation. A simple breach of contract cannot just magically evolve into a breach of international obligation once a treaty comes into force, unless it is so provided by the treaty itself. Now, claimants argue that it can, and they point to SGS versus Philippines award. But this only serves to illustrate the respondent's point. There, the Swiss-Philippines BIT contained an umbrella clause which was interpreted to serve the exact purpose: to transform the continuous breach of a contract into a breach of the treaty once the treaty became applicable. Now, members of the tribunal, as you are aware, there is no umbrella clause in the Canada-Serbia BIT. The second point, and I will talk about this point really shortly, is that the agency refusal to release the pledge was not a continuous act. Now, the argument is that not every omission of refusal to act is of continuous nature. A refusal to act can also be definitive and placed at a certain point in time. This is the position that was, of course, mentioned by the international tribunals on several different occasions. Let me conclude by briefly explaining why the claimant's claims represent the abuse of process. Now, there is no doubt that Mr. Rand was involved in BD Agro's business. He was one of company's creditors and, at a certain point, member of its management. But he never became the majority owner of BD Agro. Since mid-2013, Mr. Rand actively attempts to take over BD Agro from Mr. Obradović. This is evident from numerous documents created by Mr. Obradović, by BD Agro's management, and Mr. Rand himself, and presented earlier by my colleague, Mrs. Mihaj. In all of these documents, Mr. Rand was introduced to the agency and the ministry as a reputable Canadian investor ready to financially assist BD Agro and acquire BD Agro shares from Mr. Obradović. Throughout this time, that is between 2013 and 2015, representatives of Mr. Rand were negotiating with the agency about transfer of the agreement from Mr. Obradović to one of the Mr. Rand's companies, Koropi Holding. The agreement was terminated in October 2015 and the authorization for the transfer was never obtained. Now, in 2015, there is a domestic dispute arising from the contract concluded between a Serbian citizen, Mr. Obradović, and the Serbian Privatization Agency. In February 2018, the same dispute becomes international. The very same persons and entities that once attempted to obtain the agency authorization to take over the agreement and shares in BD Agro are now claiming that the authorization is irrelevant and that they were the owners of BD Agro all along. Members of the tribunal, this proceedings is effectively used as an attempt of claimants to collect what is presumably owed to them by Mr. Obradović based on their previous dealings. Mr. Obradović is included in this effort and he is investing his witness statements which are contradicted by material evidence on the record at every step of the way. This is the effort aimed at manipulating the ICSID mechanism and as such should not be rewarded. On the contrary, the tribunal should dismiss claims submitted in bad faith. This concludes this part of respondent's opening. I thank you for your attention and I leave you in the hands of Dr. Đerić.
Thank you.
Thank you, Madam President. And I will conclude our presentation, and I'm sorry that I have to keep you for another hour at the end of this long day, but please bear with me.
Fine,
I hope not to bore you. I will deal with the merits and compensation, but I will not deal with various breaches and why there were no breaches alleged, because that has been amply discussed in our written submissions. I will deal with two issues related to merits. One is attribution, another is the nature of the acts alleged, or the nature of the measures. And then I will move on to compensation. Now, first, as regards the attribution. Generally speaking, claimant's attribution case is built on two assumptions. One is that respondent, specifically the Ministry of Economy, controlled the privatization agency. Another assumption is that privatization is a process of implementation of a public purpose and a public policy, and as such is a governmental process, which essentially makes all the conduct of the privatization agency governmental in nature. And I submit to you that neither of these assumptions is accurate. Now, let me begin by underlying several points about the legal position of the privatization agency that are relevant for the question of control and for various forms of attribution. First, as you know, the privatization agency had a separate juridical personality from respondent. And this is not a formality as claimants would try to present it. This creates a presumption that there is no attribution of the agency's conduct to Serbia. And I can refer you to many authorities on this point, but here I will refer you to the ILC commentary. Second, the privatization agency had managerial independence from respondent. And claimants at this point argue that the governing board and the director of the agency were appointed by the government, which is true, but is not conclusive in the context of attribution. For example, in Almash v. Poland, the tribunal ruled that there was no attribution of the conduct of the Polish institution which managed the state agricultural land, although its management was appointed by the government. Now, in this context, I would also like you to note that claimants have completely failed to address testimony of Mr. Cvetkovic, a former director of the agency, who testifies that he was completely independent in taking his decisions. Third, the agency was financially independent. Claimants, of course, disagree, and they argue that the money proceeds from the selling of socially owned companies were not retained by the agency, but transferred to the state budget. Now, this is, again, true, but irrelevant, in light of the fact that the agency had its own budget, it was financed from its own revenues, and very importantly, it decided about the disposal of its budget by itself. Now, I will now, having said this context of the attribution issues, I will now move to the specific rules of attribution. Now, in the context of Article 4, claimants argue that agency was a de facto organ of respondent, but they fail to provide any evidence that would even remotely begin to fulfill the international standard for de facto organs, which you know very well is the standard of complete dependence, which was formulated, so to say, in this very building by the International Court of Justice. Now, I mentioned the law on privatization agency provides for managerial and financial independence of the agency, and Mr. Cvetkovic, the director of the agency at the time, testifies that this was indeed the case. Further, the lack of independence, and let alone complete dependence, the lack of complete dependence and dependence in any case is vividly illustrated by the example of the agency's insistence on seeking Mr. Obradovic compliant with the privatization agreement, which was accompanied by a threat of termination, despite of and contrary to the Ministry of Economy's position that there was no economic justification to terminate the agreement. That was mentioned today, for example, by claimants. Now, is it possible to imagine that an entity completely dependent on the ministry would in this way ignore the ministry's express position? Second, claimants also failed to demonstrate attribution under Article 8 of the ILC articles. Now, I would just recall that the applicable standard requires that instructions, direction, and control must be exercised not only generally, but with regard to a specific conduct, specific situation. So all claimants talk about alleged general control through appointments, finances, and similar is not only inaccurate, it is also insufficient for attribution under Article 8. We have to look at the specific conduct and see whether instructions, directions, and control were given related to this specific conduct. And this also does not obtain in the present case. Specifically, there are two actions of the privatization agency that claimants argue were performed under respondents' instructions, direction, and control. That is their reply at paragraph 986. One is refusal to release the pledge over the shares, and another is termination of the privatization agreement. Now, I will discuss these two by starting with an argument that claimant's argument that concerns both these actions. According to claimants, since the Commission for Control within the Privatization Agency decided on both these actions, and since the majority of the members of the Commission for Control, especially the majority of the members who actually made the actual decisions, comprise members coming from the ministries, claimants say it's clear that the agency acted under the government control and direction. Specifically, they state that the decision to terminate was made by 3 members of the Commission, and 2 were coming from ministry, and one member was coming from the agency. So for them, there is instruction, direction, and control. Now, let me first note here that the parties agree that the Commission was a body within the Privatization Agency. Second, it is also clear that the Commission adopted these decisions as a body. Now, these were not decisions of its members in their individual capacity. These were decisions of the Commission itself. The Commission as a body within the Privatization Agency is clearly different from its individual members and different from the ministries from where the members are coming. So we submit that the Commission has its own will, distinct from the will of its members. And this is not something new in international law. There are many authorities that discussed this distinction, and I can point you to the RLA 134, that is the Institut de Droit International. There is also a commentary of the IRC Commission, etc. Claimants completely ignore this distinction. Now, claimants' argument is also absurd. Following their logic, had 2 members from the Privatization Agency adopted sat at the Commission, and in the majority who adopted the decision, and that if there were only 1 member coming from the ministry, and that could well be, there would be no attribution. So the attribution changes according to the composition of the members who are actually present at the session and deciding. This is contradictory, and this is obviously absurd. Now coming to the notice of termination of the privatization agreement, which is one of the crucial points in the case and in context of attribution. Claimants say obviously that it came as a result of the instructions from the ministry and from the Ombudsman. Now, I invite you here to consider the substance of the communications from the ministry and the Ombudsman, and I submit that one immediately sees that these communications do not reveal that either of these bodies or organs instructed or directed the agency to terminate the privatization agreement. Rather, both of them invited the agency to make a decision about the privatization agreement. And if you look at the text of the relevant documents, you see that as far as the ministry is concerned, one stated that the agency should grant an additional time limit to Mr. Obradović to provide evidence that he complied with the privatization agreement. And this is the only specific statement from the ministry to the agency. And 2, the ministry stated that if Mr. Obradović failed to provide such evidence, quote, the agency was to undertake the measures within its legal powers. So there was no mention specifically of termination. And it's also important that there was a mention of, quote unquote, the measures, which clearly shows that there was a range of measures that the agency could take, none of which was singled out or mandated by the ministry. The decision was up to the agency. As far as the Ombudsman is concerned, he also did not direct the agency to terminate the privatization agreement. It rather stated that it should, quote, take necessary measures to determine to determine by itself whether all conditions stipulated by the law on privatization for termination have been fulfilled. End of quote. Now, you will also remember that the Ombudsman could only recommend what an entity should do. His recommendations were and are not binding. So I think it's clear from these communications that the Ministry of Economy or the Ombudsman did not instruct, direct, or control any specific conduct. They did not tell the privatization agency what its decision or conduct should be. This was up to the agency, which had a choice to make. One, either to terminate the privatization agreement, which it actually did, or two, to set yet another deadline for compliance, or three, to issue a certificate that the buyer complied with the agreement. So there were three possible outcomes. Now, the privatization agency eventually decided to terminate the privatization agreement, but this was done following careful deliberations in the Commission of Control. And my colleague, Mrs. Mihai, has mentioned that already. And I would just invite you to read these deliberations. The transcript is on file, and not to rely on claimants' I would venture to say manipulation of the snippets from these stenographic notes. And we have exposed their method in the rejoinder at paragraphs 146 to 155. And I will say nothing more about the deliberations of the Commission. Now I will move to the question of exercise of governmental powers, which is the second source where claimants seek support for their attribution case. Claimants generally argue that all conduct of the privatization agency during the privatization is attributable to Serbia, because privatization serves a social purpose, while the agency implements and enforces this social purpose through its role in the process of privatization, which constitutes a sovereign activity. You can see that their whole case at reply at paragraph 912. Now, in this way, claimants actually assume that the social purpose of the privatization and the role of the agency in implementing this social purpose make the agency a governmental organ in the sense of Article 4 of the ILC articles. Now, what claimants forget is that privatization is by no means exclusively a governmental process. It has also important commercial and private law elements. And in particular, it has these elements as regards sales agreements, in our case, the privatization agreement. So this means that the privatization agency may well participate in various ways in privatization, both as an entity entrusted with certain governmental powers, but also in private commercial capacity. And this is particularly so with regard to privatization agreements. And so we have to look in each specific case in what way the agency participates and what is the nature of its actions. And I would just ask here a question which is related to claimants' argument that since privatization is a governmental process, everything done within the privatization is governmental, which is based on the public policy nature of the privatization. Now, why would the public policy nature of a process turn that process necessarily into a governmental process? We know from international law that many non-governmental entities could exercise governmental powers, and then we have attribution under Article 5. But there are certain rules under Article 5. And when they act under Article 5, we know that these same entities can also act in a commercial manner in other matters. And in that case, conduct is not attributed to the state. And I submit that claimant's approach, which draws attribution from the public purpose or character of an activity, would widen the scope of attribution beyond any limits. The result would be that any implementation of a public policy by separate entities or separate companies, for example, in the process of privatization, on the process of healthcare, in the process of education, would entail attribution of their conduct to the state. And as you well remember, in the Jan de Nul award, it was underlined that what matter is not the public purpose of or character of an activity, but the use of governmental authority in the specific case. And I submit that this undermines whole claimant's argument. And in fact, claimant's argument would dispose with the existing customary international rules of attribution. It would do away with the standard of de facto organs. It would do away with the presumption that separate juridical entities there is a presumption that there is no attribution of their conduct to the state, and it will obviously make Article 5 of the ILC articles completely redundant. And would do so by stating that generally all acts of an entity must be considered governmental just because it participates in a process that implements a public purpose. Now I will make a small, so to say, excursion, and we'll mention the cases of European Court of Human Rights on which claimants rely. And these are two cases in which the privatization agency was characterized, quote unquote, itself a state body. Now, I submit to you, if you look at the cases, you will see that this was said in passing. This was said without any meaningful analysis of the relationship between the government and the privatization agency. And it was not, there was not even a reference to Article 4 or Article 5 or whatever. And I must also say, or remind you, that the European Court of Human Rights was unfortunately heavily criticized for its interpretation of international law rules on attribution. And this, I have to say with regret, commands certain caution in this context. And this criticism continues. I have just recently read an article in the last issue of the American Journal of International Law, also dealing with a very interesting case against Azerbaijan and Hungary, and heavily criticizing the European Court of Human Rights and its application of the rules on attribution. Now back to the field of investment law. As you have heard today, claimant's approach is based on Audi versus Romania. But I submit to you that a careful reading of this case and consideration of its facts clearly mandates that the conclusions reached by the AFDI tribunal remain limited to that case. The AFDI tribunal, in the awards, just stated that the Romanian privatization agency was a state organ. It never provided a detailed discussion of the position of the Romanian privatization agency vis-à-vis the Romanian state. And this is first red light where one considers transposing its conclusions. Now, if one digs further, and we did that in our rejoinder, in order to learn about the actual relationship between the Romanian privatization agency and the Romanian state, it quickly becomes clear why the AFDI tribunal just stated that the Romanian privatization agency was a state organ. Because according to Romanian law, this agency was, quote, a specialized institution of central public administration with legal personality but subordinated to the government and coordinated by the Minister of Economy, end of quote. And this is completely different from the position of the Serbian privatization agency, and this is why AFDI conclusions are inapposite in the present case. Further, in AFDI, the commitment of the Romanian privatization agency and the breach thereof related to a sovereign act. The commitment in the case was to have enacted a piece of legislation that would grant claimants land for some kiosks in Romania. And the breach of this commitment was in the Romanian Privatization Agency's failure to procure enactment of a new legislation dealing with kiosks. Because the first one, the initial one, was the legislation was annulled by the Romanian Constitutional Court. So there was a commitment to do something to have another legislation enacted. And this was, the enactment was clearly a sovereign act. And nothing of the sort exists in the present case. Neither the commitment to exercise sovereign powers nor a breach thereof. The conduct in the present case was purely commercial. Termination of the contract, refusal to release the pledge, and alleged failure to consent to assignment of the privatization agreement. Now, on their part, claimants argue that these three types of specific conduct constituted exercise of governmental power. And this brings me obviously to their claim that there is attribution under Article 5 of the ILC articles because there was exercise of governmental powers in these cases. But here again, they argue that everything the privatization agency does in the privatization process is governmental in nature, as I have just mentioned and discussed. And so their argument in the context of Article 5 is also based on their general approach that privatization is a governmental process. Now, the reason why claimants base their Article 5 argument on this general assumption is because, I submit to you, they have difficulties to show that any of these acts, termination, refusal to release the pledge, and assignment of the refusal to assign the privatization agreement, that any of these acts were actually performed on the basis of any governmental authority conferred by the agency. So they cannot find that authority, and instead they rely on the general governmental nature of privatization process. And this is obviously not how Article 5 works. Article 5, as we all know, requires that the power to exercise governmental authority must exist in relation to specific conduct in each instance of a specific conduct. And in the present case, all conduct complained of was commercial conduct and not an exercise of governmental authority. And this obviously brings me to the nature of the acts complained. And at this very point, attribution under Article 5, analysis of attribution under Article 5 to a certain extent overlaps with the issue of whether a violation of investors' rights was performed in sovereign capacity. And that is in the exercise of governmental powers and not as an action as a contracting party. Now, as is well known and underlined by many tribunals, including the one in the Suez case, but unfortunately still disputed by claimants, there is no treaty violation if the conduct in question was performed in commercial capacity. That is, if an entity performing it did so as a contracting party. And from this perspective, obviously, even if there were attribution under Articles 4 and 8 of the ILC articles, there would be no violation of investors' rights unless the measure was taken in the exercise of governmental powers. Now, the test for distinguishing exercise of governmental powers from other commercial conduct of an entity is whether, quote, any private contract partner could have acted in a similar manner, that's from Jan de Nul, or whether the conduct in question was conduct which any contract party could adopt, that's Duke award. Now, if we consider the specific acts of the privatization agency that claimants complain of, it becomes clear that these are the acts that can be performed by any party to a contract seeking to ensure performance of the other side, seeking to ensure compliance with the contract. Starting with the agency's refusal to release the pledge over the privatized shares. Now, it is rather common and well known that one party may withhold its performance until there is performance from another party, and precisely in order to exact such performance. And I believe the principle, which can be formulated in Latin, originates from Roman law. So any commercial party would do that, what the privatization agency did. And by the way, as my colleague Mrs. Mihaj said, the privatization agency did exactly the same thing in other cases. Now, the same goes for the refusal to consent to assignment of the privatization agreement. This was today highlighted as something improper when we were listening to the minutes or to the to the recording and steno notes of the session. But this was, as it was said in the steno notes, this was a way to enable the agency to continue to seek performance from Mr. Obradović, to remedy violation of Article 534. And this was the performance that it could not seek from the party to whom the contract would have been assigned. And this is also a conduct not out of the ordinary for a private contracting party. And coming again to the termination, I would remind you the termination of the privatization agreement did not come as a result of some decree or a sovereign act. It was affected through the notice of the agency, acting as a commercial party to the privatization agreement, and as the ultimate remedy against the buyer's years-long non-performance of his obligations under the contract. According to constant court practice in Serbia, a notice of termination of the privatization agreement is, quote, a unilateral declaration of will of one contracting party to the other contracting party. You see the excerpt from the screen, but there are other cases where this was confirmed. Now, claimants tried to escape this inevitable conclusion by arguing that the notice of termination was actually an administrative act, an exercise of governmental power. However, this theory is proposed solely by their expert, Mr. Milosevic, and no one else. It goes against settled Serbian court practice, and it is also plainly wrong as a matter of legal analysis, as has been demonstrated by Professor Radović. Finally, let me say that involvement of the Ministry of Economy, when it considered the privatization of the BD Agro in the supervision procedure and made certain statements to the privatization agency, also does not change the fact that the termination of the agreement was a commercial act. You will recall that the tribunal in the Suez case, and there was also reference to Bayandir, said, quote, the mere fact that there is some government involvement in the events that led to termination of a contract does not necessarily mean that such termination is the result of an exercise of sovereign powers. That is RLA 116 at paragraph 153. Now, I have already discussed the substance of the ministry's conclusion, and the text of it shows that it did not direct any specific course of action as regards the termination. And the same conclusion is reached if one considers the text of the Ombudsman's recommendation. The decision to terminate was a commercial one and was agency's own decision. So I can conclude that there is clearly no attribution on the basis of Article 5 of ILC articles, because that was commercial, that was exercise of commercial powers, not exercise of governmental powers. And for the same reason, the conduct complained of could not lead to treaty violations because it was a commercial conduct. Now, to the extent claimants complain about the exercise of governmental powers through Ombudsman's recommendations, I would just say that these recommendations were not even addressed to them. It did not affect them directly, but only through their alleged influence on the privatization agency. But As in other cases, for example, Tulip v. Turkey, RLA 117, non-binding recommendation of a state body do not, in that case and in our case, did not have any particular influence. In our case, did not have any particular influence on the privatization agency. And moreover, were not an improper exercise of powers. It should be recalled here that the Ombudsman's recommendations and involvement were not even considered or mentioned at the meeting of the Commission for Control in the Privatization Agency when they were discussing termination of the privatization agreement. Today, I would just also like to say that today claimants again and again invoke Karatube case and never actually respond to a very simple point that we made in our submissions, for example, in rejoinder at paragraph 1749, and the point is the follows. In Karatube, the public prosecutor intervened, recommended, and then the ministry completely changed its position. In our case, there was no change of the position. Agency was for years threatening termination, and the termination was obviously coming, and Mr. Obradović knew it was coming, and eventually it came. The second topic that I will discuss now is the topic of quantum, and there I will discuss 2 points. One point is that BD Agro was an ailing company for years and not a robust company that was presented today in claimant's opening statement. And this is important for 2 reasons. One is for the choice of valuation method, and another is the question of causality, of which we have heard nothing about today. And I will address that in some detail. Now, the second point is that claimants overvalue BD Agro's land by inflating prices of the land and by including in their valuation land that is not BD Agro's. And that is going to be the second point I address. Now, starting with the first point, BD Agro's lack of profitability. Now, you will remember, but no one told you today, that the company was insolvent for many years before the alleged measures. Now, its performance was caused by generally 2 reasons. One was, I would say, criminal mismanagement by Mr. Obradović, which has been in detail explained in our written submissions. And the second reason was that BD Agro's business plans simply proved not to be realistic, and its business operation never proved to be viable. The abysmal business performance of BD Agro over the years have been summarized by Mr. Cohen in his first report in the graphs. You can see on the following slide, you follow the red line, that is the net result. And if you follow that, you will see that BD Agro was loss-making in all years except in 2008. And if you look at the revenue side, that is above the line, yellow and blue. Blue is the revenue from BD Agro's core activity, that is agriculture. And orange is indicating other income, which is primarily revenue from the sale of land. Now, if you look at their proportion, you will see that orange represents a significant part, sometimes even the majority of the company's income. So this means that a significant part of BD Agro's revenue came from selling land and not from its business operations. But even selling of the family silver could not change the company's disastrous performance, as it was making losses for 7 consecutive years before the alleged measures. This can also be seen if you look at BD Agro's EBITDA from 2006 to 2014. In each of these years, EBITDA was negative. So, in other words, even if we take back interest, taxes, depreciations to BD Agro's net income, the company was still constantly making losses. This is what Mr. Anway called, quote, a model example how privatization can benefit the state. Now, the extent to which BD Agro's management, led by Mr. Obradovic, underperformed is also evident if one compares BD Agro's business plans from 2006 with the actual performance of the company until 2011. So you will see that the planned targets were almost uniformly underperformed. And this was so despite the fact that milk prices, which is the main business revenue for BD Agro, that the milk prices were much higher than envisaged in the business plan. So Mr. Cohen remarks, quote, despite this price effect, because volumes produced were so much lower than planned, actual revenue in 2011 was about 34% lower than in the 2006 business plan. That is his first report at paragraph 4.19. Now, you should also note that BD Agro's bank accounts were blocked by creditors for unpaid debts in the amount of approximately 7 million euros, continuously from March 2013 until the valuation date, that is 21st October 2015 and beyond. In other words, BD Agro was continuously insolvent during the period of 2.5 years before the valuation date. Again, this is what Mr. Anway calls model example. Now, under Serbian law of bankruptcy, this fact by itself constitutes a reason for bankruptcy. This is called permanent insolvency under the law and exists if a company cannot pay its dues for 45 days after due date, or if the company permanently stopped making payments for at least 30 days. And here we are talking of 2.5 years. Now, at the same time, BD Agro's liabilities were enormous. According to Dr. Hearn, they were 43 million euros. According to Mr. Cohen, 61 million euros. I can also add that company was late with payment of salaries and was years behind in payments of the social insurance and health insurance, which is a mandatory obligation under Serbian law. And you can see that at, for example, in the Ombudsman opinion that's noted in the CE 42, pages 9 and 11. Now, claimants have not seriously changed the substance of Mr. Cohen's review of BD Agro's business performance. Obviously, these numbers are correct and can hardly be disputed. What claimants say is that all this is irrelevant because BD Agro's business performance was already reflected in contemporaneous valuations of the company. But is it really irrelevant? Is lack of profitability really irrelevant? I submit to you it is not. It is very relevant. The lack of past profitability and the lack of perspective of profitability indicates that BD Agro was not a going concern. And this is what BD Agro's auditors, their own auditors, said already in 2013 when they refused to provide a statement on the business continuity principle. So this must be taken into account when choosing an appropriate valuation method. And obviously, we submit to you that this cannot then be a DCF method. And I will not deal any longer with that because this is analyzed in great detail by Mr. Cohen. What I would like to elaborate a little bit more is another important aspect of quantum, and that's causality, and the impact on causation of the fact that BD Agro was a failed company on the verge of bankruptcy. As you know, a causal link must exist between an alleged treaty breach and the injury suffered by claimants for which they seek compensation. And this causal link must be proven by claimants. Now, as you also know, the standard of proof of causality in international law is a demanding one. And we submit that claimants have failed to meet this standard and have not proven causality between the breaches and the injury they allege. Now, the Arbitral Tribunal in Bilcon v. Canada has provided a useful standard of international standards relating, summary, of international standards relating to causality. And the summary shows that different tribunals may have used different formulations of the standard, but all have agreed that the standard is very high. The formulations of the standard were as follows. For example, that the alleged injury must, quote, in all probability have been caused by the breach, that is in Horso, or that a quote-unquote sufficient degree of certainty is required that the state's conduct, that absent the breach, the injury would have been avoided. That's the genocide case from the ICJ. Or even that the state's conduct, quote-unquote, necessarily led the investor to act in ways that harmed its profitability. That's the Nordzucker case. Now, the Bilcon Tribunal also noted something which is important for this case. It noted that while the facts of the genocide case were obviously markedly different from the Bilcon case, the ICJ and the Bilcon Tribunal were facing the same issue. The situation of factual uncertainty, where in the view of one of the parties, the same injury would have occurred in the absence of unlawful conduct. And I submit to you the same issue arises in the present case as well. Now, the Bilcon Tribunal formulated its causality test combining the tests used by the PCIJ in Horsov and ICJ in genocide, and it's on the screen. Now, what is interesting is how the Bilcon Tribunal applied this test. Now, the question of liability, as you know, had already been determined in the award on liability in that case, which found that Canada violated investors' rights under NAFTA because it did not assess the environmental impact of their project to open a quarry in Nova Scotia. It did not assess the environmental impact in a fair and non-arbitrary manner, so that was the breach. But turning to the question whether the project would have been approved as a result of a proper treaty-compliant process, the tribunal analyzed various other junctures of the administrative approval process, and then concluded that it cannot be said that this outcome alleged by claimants, that is the approval of the project and starting of the business, would have occurred, quote, in all probability, or, and again, quote, with sufficient degree of certainty. And this is how the Bilcon Tribunal applied the PCIJ and the ICJ formulations. Now, what the Bilcon Tribunal did was to analyze step by step the approval process for the query and found that it was not at all certain that claimant would have been granted a license even absent the NAFTA breach at one stage of the process. And the question asked by the tribunal was whether a NAFTA-compliant process could have, quote-unquote, reasonably concluded or, quote-unquote, reasonably recommended outcomes that would have in any case resulted in denial of approval for the claimant's project. In other words, even a reasonable possibility of a different outcome was sufficient for the Bilcon Tribunal to conclude that there was no causality. Now, turning to our case, claimants argue that there is causality between the measures and the alleged loss of profits that BD Agro would have made in the future because, quote, was it not for Serbia's unlawful actions, BD Agro would have implemented the pre-pack reorganization plan and continued its operations. However, it is not at all certain that BD Agro would have continued its operations absent respondents' measures. Or, to put it in accordance with a slightly different standard, it cannot be said that BD Agro would have continued its operations, quote-unquote, in all probability, absent respondents' measures. Indeed, we submit to you that the bankruptcy of BD Agro appears to have been quite certain, considering in particular two factors. One factor I just discussed, and that is BD Agro's permanent lack of profitability and its continuous past failure to achieve business plans. The second factor was insistence of its major secured creditor, Banca Intesa, that BD Agro must go into bankruptcy. Now, the original pre-PAC reorganization plan was prepared on the basis of the evaluation of the company at 20 million euros for the company's land and buildings. And out of that, approximately 17.5 million was the land and buildings encumbered with mortgages. And Banca Intesa had first-class mortgage on the real estate valued at approximately 15 million euros. So most of the encumbered land and buildings were under Intesa's mortgages. Now, this is the Adventist valuation report, which claimants have omitted to mention today and put it into their small list in the table of valuations, as they did also with the JLL valuation. Now, Banca Intesa, as a major secured creditor, should have had a majority of votes in the class of secured creditors. That is, the creditors that would be able to collect most of their receivables from the mortgage property. And at the same time, another bank, Nova Agro Bank, should have had minority of votes in this class. Now, what BD Agro did, what BD Agro's management did, was to contest Intesa's receivables without any justification, although the bank had first-class mortgage. The idea, apparently, was to exclude Banca Intesa from the first class of creditors because it was for bankruptcy and against reorganization. And naturally, Intesa objected to the pre-PAC organization plan. Its objections to the pre-PAC or reorganization plan clearly reveal its strong intention to seek bankruptcy of BD Agro, which it considered to be the only possibility to satisfy creditors of BD Agro. And you can see part of the text and the strong words on the screen. Now, then, and it also initiated bankruptcy proceeding itself. Later on, these proceedings would be discontinued once the amended pre-PAC reorganization plan was adopted by commercial court. And this adoption of the amended pre-PAC reorganization plan came with a new valuation of BD Agro. That was a valuation by Mr. Murgut. That the valuation of the land was by Mr. Murgut, sorry, and the land was suddenly valued at 87 million euros. Now, with such valuation of the land, BD Agro could afford to have Intesa among secured creditors, because much more of Nova Agro Bank, another bank, much more of their receivables could also be collected. And you will remember that Nova Agro Bank was for reorganization, but Nova Agro Bank had the second class mortgage on the same land, on most of the same land where Intesa had the first class mortgage. Now, then again, Intesa raised the challenge and successfully challenged these maneuvers on appeal. And it should be also noted that there were other creditors that appealed the court decision that adopted the amended pre-PAC reorganization plan. And the decision was eventually vacated on appeal and returned to the lower court. Now, given Intesa's continuous and unwavering insistence on BD Agro's bankruptcy and its opposition to a reorganization, it is clear that no pre-PAC reorganization plan would eventually be implemented in any case. with or without termination of the privatization agreement, with or without assignation of privatization agreement. In other words, BD Agro would in all likelihood go into bankruptcy. At the same time, it is beyond dispute, I would say, if you read their financial statement, it's beyond dispute that the company was not profitable during claimant's involvement. It did not make any profit for years. It was insolvent continually for 2.5 years. It was declared not to be a going concern as well. Now, going back to Bilcon award, you will remember that the Bilcon Tribunal analyzed causality by looking at whether the outcome suggested by claimants, that is granting approval and starting of the business, would have occurred even absent the NAFTA breach. The tribunal asked itself whether other stages of a NAFTA-compliant approval process would have reasonably reached outcomes that would have resulted in the denial of approval. If there was a reasonable possibility that the approval would have been denied even absent a breach, there was no causality between the breach and the injury. In the circumstances of our case, this question and the relevant standard can be formulated as follows: whether, absent the measures alleged, there was a reasonable possibility that BD Agro would in any case end in bankruptcy. And I think that the answer is self-evident. Banca Intesa was a major first-class creditor. It had a decisive vote in its class of creditors. It insisted on bankruptcy. Company's performance was disastrous. All this shows that bankruptcy was a likely outcome and not merely a possibility. So we submit that there is no causality. Now, the second theme that I would discuss, and the reminder of the time that I have, is quantum and how claimants inflated the value of BD Agro's land and especially of its land. Now, one way to inflate the value of BD Agro was to evaluate it as a profit-making company and to apply DCF method in its valuation. Another way was to inflate the value of its assets, particularly its land. And claimants and Dr. Hearn do so in two ways. One is to inflate the price of the land. Another is to include in the valuation the land that is contested or not even owned by the company. And today we see that they were forced to some extent to modify their valuation and their position, which land is actually owned by BD Agro. Now, the inflated price of the land has been exposed in two reports of our expert, Ms. Ilic, and she showed that claimant's valuation of the land was not in accordance with international standards. There are two main problems with their valuation of the land. First is they rely on third-party estimates, but never actually critically assess these third-party estimates. They pick and choose. They find one or two which suit them, as they did today, and they say, well, this is the price. Second is they rely on the assessment by the tax administration, which was given for the purpose of determining the tax on the transfer of property. And this assessment by the tax administration is conducted under completely different rules, which are stipulated by the Serbian law on Serbian tax law, and not under and pursuant to international valuation standards for property. And there are many differences between the two. And this is also exposed by our expert, Mrs. Ilic. Now, what is a further way to raise or inflate the amount of damages is to include the land that was actually not BD Agro's ownership, or the ownership of the land was disputed. And this is very important because in this way, claimants added between 24 and 38 million euros to their valuation. And you have that in our demonstrative exhibit. According to our expert, the value of this land would be 18 million euros, the land whose ownership is disputed. Now, How important this is to claimants, you can see from their repeated attempts to re-argue this point, which have been refused by the tribunal. Now, what I would like to hear to say, and I conclude with this, claimants cannot pretend to be surprised by the issue of ownership of BD Agro's land and the fact that the land is contested. They knew about it for a long time, and you can see that from the following evidence. One is that full list of the contested land, which was prepared by the bankruptcy trustee in 2018, that is before these proceedings, excluded some land because its ownership was contested. Mr. Rand, as one of BD Agro's bankruptcy creditors, must have been aware of the list. Indeed, Mr. Rand, or claimants through Mr. Broshko, must have known about the land also because Mr. Broshko acquired the bankruptcy sale documentation, which clearly flagged this information. Moreover, going back to 2014 and BD Agro's pre-pack reorganization plan, which was prepared by the management controlled by claimants, the plan provided a list of land for sale, and then in this context mentioned court proceedings and contentious issues over property rights. So claimants were aware of problems at least in 2014 already. And the land plots in question were listed for sale in the 2014 pre-pack reorganization plan with this qualification. And they are, with few exceptions, also included in the list of the land excluded later on from sale by the bankruptcy trustee. So claimants cannot simply now pretend that they did not know about the contested land. But nevertheless, what they did is to instruct Mr. Hearn to evaluate all land that is inscribed in the name of BD Agro, regardless of its contested status or outright fact that it does not belong to the company. And at the very end, and I'm finishing with that, I will briefly turn to the issue of Serbian taxes relevant for calculation of damages, specifically Serbian capital gain tax. We have a dispute whether this tax is applicable to a hypothetical sale of BD Agro. In our submissions, we promised that we will provide a calculation of the amount of taxes, and so we do that in our demonstrative exhibit RDE2. And we provide the applicable capital gain tax at the valuation date according to different valuations of experts. Now, for the sake of simplicity, given that various measures have been alleged, we chose 21st October 2015, which is also the valuation date, and we calculate the capital gain tax that Mr. Obradović would have had to pay upon the transfer of the shares. And this calculation will also be, tax calculation will also be included later on into Mr. Cohen's overall calculation. Let me also explain and apologize that we did what we originally submitted exhibit RDE2 with an additional table which should not be there. We just made a corrected exhibit, and we put one footnote. That's a footnote to the index of retail prices, but that does not make the calculation any different. And with this, I conclude. Thank you for your kind attention at this late hour and for your patience after a long day. And we conclude our submission with that. Afterwards, Madam President, we will have a question about technicality about the examination of witnesses, but we can return to that afterwards. Thank you.
Thank you. And congratulations as well, because you're exactly in time. It's not that late, actually. It's just turned very dark for a summer afternoon. Tomorrow, well, I don't know, are there any questions for respondents? Yes, good. So please go ahead.
And I also actually have a question for claimants too. I didn't before the break, but having
that's
checked
fine,
something, I
that's
do. For respondent, I think, Mrs. Mihai, this is for you. If I could turn you to your slide 42, and these are questions of clarification at this stage. What I had understood you to be saying in relation to curing the breach, do I understand respondent's position to be that the breach could have been cured had these two companies returned those sums? Is it as simple as that, or is there, am I simplifying it too much?
Yes, of course. It is simple as that.
Okay. Thank you for that clarification. The second question I have is this. Assume with me now that the privatization process would be finished. Let's say this transaction never took place, and therefore the pledge would be removed and the company would be private. Is it respondent's position that had BD Agro then done these transactions, okay, let's say the week after the privatization process was finished, that would not have been a breach of Serbian law or anything else? Yes, it would. In other words, at that point, it would have been entitled to do as it wished.
As I'm aware, it would not breach any of the Serbian laws.
Okay, thank you. For claimants, you talked today about proportionality, and the reason I didn't ask the question is I went back to look at your pleadings, and I saw discussion of proportionality in relation to Serbian law, the Serbian constitution, and how that may play in relation to the application of Serbian law to this particular dispute. I saw, I think, passing reference to proportionality in the international law section. My question is this: are you arguing proportionality also as a question of international law? And if so, under which treaty standard?
I think the direct answer to your question is all treaty standards. I had the fortune or misfortune of being involved in the key case that established the proportionality principle, which was the Occidental versus Ecuador case. I participated as counsel to Ecuador, both in the underlying arbitration and in the subsequent proceeding where they were attempting to annul it. And the case, the award was in fact very significantly partially annulled, but you will recall that the tribunal there did apply a proportionality standard under public international law to conclude there was a violation, and indeed it was the only violation the tribunal found under the treaty. I might also note that in that case, the tribunal had found that the terms in the contract between the investor and the state had in fact been breached by the foreign investor. That is to say, the contract that was at issue there effectively required the foreign investor to give certain notice of a transfer of rights under a contract to the government. The government had to approve it, and if it did not do so, the government had the right to declare caducidad, effectively to take the investment in its entirety. And what I argued to the tribunal, which they accepted, was the contract says if the investor does A, the state can do B. If they transfer rights without obtaining government approval, then the government is entitled to declare caducidad and take the investment in full. And nevertheless, despite the fact that the tribunal found the investor had agreed to that and breached the provision, they still held that it was disproportional for the state to do what the foreign investor had authorized it to do under that contract. And I give you that background because we don't have that situation here at all. Here we have a situation where we are not dealing with anything like that. In other words, the proportionality principle is far easier to apply in this context. But that obviously is the lead case, and the tribunal found that proportionality principle applied as a matter of both domestic law in the Ecuadorian Constitution itself, which I think has some parallels to your question, but also as a matter of public international law and all the treaty standards. Mr. Pekash, I don't know if you have anything to add to that.
Okay, then two follow-up questions. Is that case on the record?
It is, and in fact, it was cited today, I think, in our opening statement. It may have been the annulment piece of it. The annulment piece of it dealt with a different issue. All three members of the tribunal, including the dissenting member of the tribunal, agreed with that proportionality principle.
Okay, and just to understand your position in terms of how it applies to this treaty, you say it applies to all the treaty standards, so you're not, I guess I'm not quite understanding which treaty standard of this BIT you're saying is breached by any proportionality principle.
Our position is that the requirement of proportionality is a general principle of public international law, and therefore it influences all standards under the treaty.
Thank you. And since there was fulsome answers, I'm happy with the Madam President's permission to, if respondent wishes to say anything to my question on proportionality, to open the floor. Or you may wish to reserve your response.
I would just like to note what you have noted as well, that this argument of proportionality under public international law has not been developed in claimant submissions. This is something new, and this is certainly something that we are going to respond, but there is certain element of surprise, I would say, to which probably we will come back.
There will certainly be opportunities to come back. Absolutely, please.
Thank you, Madam President. I have a question for respondent with regard to attribution. I suppose that Mr. Jeric will answer. So the creation of the privatization agency was with the purpose to sell the so-called social owned property. If I understand well, the situation in the former Yugoslavia, after the end of the so-called socialist regime, this social owned property became state property. Am I right, or just to is that okay?
Not exactly.
Please.
If I may.
Please.
Social, I mean, it depends. I'm not sure what was the solution in other states of the former Yugoslavia, because socially owned property is an institution or a legal concept from the socialist Yugoslavia. So each state of the former Yugoslavia dealt with it separately, obviously. In Serbia, socially owned property was not transformed into state property and then sold. It was sold as socially owned property, at least in the case of BD Agro. There are some, and I will have to look at it, there are some cases or there are some variants whereby the state property or the public property was sold. That's a different matter, but here we are talking about the socially owned property, which was never transformed into state property. And in that sense, the privatization agency did not, legally or formally speaking, did not sell the property on behalf of the state, because it was not state property, it was socially owned property.
In that case, who was the owner of the so-called social owned property in the intermediate period, so to speak?
Yeah, well, it's a difficult question. We will have to look into it. I think it changed over time, but it was so it was usually, administered by various entities. But we'll have to look into what what was the exact model of administering this property, or who was actually doing the management. What I can say now is that the management of the socially owned company had to initiate privatization in a certain period of time that was under the law. If they didn't, then the privatization agency would press the button and initiate the process. But the exact, we can provide you with the exact answer as regards the relevant times, I think, later on.
If I understood you well, the privatization agency is not an organ of the state, either de jure or de facto. It was created by the state. But do you consider that the relationship between the privatization agency and BD Agro is just a pure contractual relationship, private relationship?
The short answer is yes, but at least from the moment the privatization agreement was signed onwards, the relationship was private relationship. And I think that Mrs. Radovic, Professor Radovic, is also supporting that position and arguing for that position. So this is different from the role of the agency in the auction and selling of BD Agro. That's pre-contract activity. From the moment when the contract was signed, we submit that it was a commercial relationship on the basis of the contract, and to some extent regulated by the framework of the law on privatization.
Yeah, with regard to privatization, you mentioned the example of Romania. Do you have in mind what was the situation with the Treuhand in Germany? I don't. This is the reason why I...
to you on that. Yes, thank you.
No further questions.
Maybe I should ask one question from claimant following the respondent's opening. Do I understand correctly that you claim damages as a result of the termination and the transfer of capital and not the other violations? Or do I misunderstand that? You don't need to answer now if you don't want to do it now or want to check. And related to this, and this is the causation discussion that brings this question. You have not spoken of causation today, and I'm not certain you have addressed it in your written submissions in answer to your opponent's arguments, but maybe I don't remember well right now.
So with respect to this, we did not label it causation as an independent part of our submissions, but it is embedded in our submissions on quantum. If you remember this morning, I mentioned several times that the bankruptcy over BD Agro was opened only in August 2016, which was 10 months after the termination and let's say takeover by the privatization agency. And I believe in our submissions we also explain the status of the reorganization plan, its approval, and how the termination of the contract and again the takeover by the privatization agency prevented BD Agro from complying with the very formal requirements which were there to be complied with for the reorganization plan to be approved after it was remanded by the appellate court.
So that this is your causation argumentation. Do I understand that correctly?
Yes, this is the causation. We understand that the causation argument is all centered on the allegation that BD Agro would have ended in bankruptcy nonetheless. And our position is BD Agro was not in bankruptcy at the time of expropriation, And it eventually ended up in bankruptcy, but only 10 months later because of intervening causes.
Thank you. Now, tomorrow we will hear the first witnesses, and the first one will be Mr. Rand, and then we follow up with Mr. Azrak, and in the afternoon, in principle, we'll have Mr. Obradovich and then Mr. Jennings. Is that the plan?
That's correct, Madam Chairman.
Yes. Fine. Any remarks? I think you had a question about the witness examinations.
That was us.
Oh, that was you.
Yes.
Sorry.
The question is following. We understand, and it transpires from, I believe, order number 11, that one paper copy of the cross-examination bundle should be given to the witness. And we also plan to examine the witness by giving a paper bundle to the witness. The rest of us will have electronic bundle. However, what we hear from our colleagues who are at the setup is that for some reason we are not allowed to approach the witness. In other words, no one will be allowed to approach the witness, to be near the witness, to show them through the bundle and to help them with the bundle. So this is, and this is a question of logistic. I don't think that, I mean, that person could have had a mask and perform that function, which is incidental and rare, but might help the speed of cross-examination.
Are you going to project on the screen the document on which questions are asked?
Yes.
And the witness will have a screen that's down there?
Yes.
Where she could read? Yes. And then in addition, maybe the witness wants to check in the paper copy going back and forth. That can be done, I would submit, by someone sitting next to the witness from the team and helping if necessary, just to save time.
Thank you.
And wearing a mask, please,
Yes.
then. And what we could also do is bring the table a little bit closer, because of these curtains, this room is rather dark, right? And it's always dark, but now it's even darker. And what we can also do is when we hear witnesses remotely, maybe we can pull the screen closer, not too close, because the cross-examiner must have a good view, but there's still some room for moving it closer. Is that a
Perfect,
way
thank you.
of doing it? Is it fine with the claimants as well?
Yeah, this is fine with us.
Yes.
Madam
Mr.
President, if I
Hanway
could
has
just
a
address
question.
another issue. Arbitrator Vasani had asked whether the Occidental Award was in the record. It is CLA 75, and the annulment decision is CLA 5, and I just wanted to put on the record.
Thank you. Anything else you wish to raise before we adjourn for the day?
Nothing, Madam President.
No? Then I wish everyone, sorry, I understood you
No, we don't have anything, thank you.
saying no with your head, but I should have given you the floor. Fine, then I wish everyone a nice evening. Well, a busy one, I suppose, but we'll see each other tomorrow at 9 o'clock to hear Mr. Rand. Goodbye, everyone.